Trial resumed. Jury not present.
The court said, "Good morning. Would you make your appearances, please?"
Ms. Murray said, "Juliana Murray and Justin Horton for the United States." And will be joined by our colleagues Ryan Finkel and Micah Fergenson.
Mr. Skirick said, "Good morning, Your Honor." Scott Skirick. Sabrina Schroff and Matthew Barkin together at counsel's table with Mr. Guo, and will be joined shortly by Mr. Kumraju.
The court said, "Please be seated. I'm told that there is a delay on the New Haven line and that alternate 3 is not here yet, so I would like to wait for him. Is there anything you'd like to raise?"
Ms. Murray said, "Your Honor, just with respect to anticipated timing the parties have discussed. We estimate that there's maybe 40 minutes left in the court's instructions up until the end of Section 5. We would request maybe a 5-minute break after that point to permit the government to set up for closing arguments. Move the podium, get the text set up. We anticipate that the government's summation will be around 3 hours. It might be a little bit more than that. We understand there will be a comfort break for the jurors at some point in the middle of that. We would just ask, we'll be cognizant of the approximately 11:30 timing depending when we start. But we ask the court's permission to make sure that it's in a kind of reasonable breaking point. Like at the end of a section or the end of a slide or something like that."
The court said, "Sure."
Ms. Murray said, "With respect to lunch timing working forward from when the government's summation begins. And building in the 10 or 15-minute break that there would be. We anticipate probably 1:15 or 1:30 for the lunch break because that would be, I guess, between the government's and the defense summations. We understand Mr. Kumraju's summation is probably around 3 hours, maybe a bit less than that. And then we would ask for a brief break, 5 minutes or so, for the jurors to stretch their legs. And then the government's rebuttal would probably be around an hour. Maybe a little bit less depending on the defense closing. Doing the math, it makes for a pretty long day. We've discussed with defense counsel, and we just wanted to let the court know, the timing is fluid. It seems quite likely that we wouldn't be in a position to be able to complete all 3 summations today. I'm not sure if the court wants to inquire whether the jurors can stay late. The parties are open to that. Although I would note that it might be a situation even if they can where we reevaluate later in the day. We wouldn't want to be in a position where the summations run over. And then the rebuttal is truncated just due to scheduling."
Mr. Skirick said, "Thank you, Your Honor. We're broadly in agreement with what Ms. Murray outlined as the process for today. We would just ask, particularly in light of alternate number 3's delay in getting to court today, if we may inquire with the jury as to their ability to stay a bit late today in order to build some time back in. Perhaps a half hour or so to 5:30 in the interest of getting in as much today as possible and in hopes that we can finish all the summations today so that the jury can begin deliberations tomorrow."
The court said, "So I contemplate giving them a half-hour break for lunch. Is that what you were thinking?"
Mr. Skirick said, "Yes, Your Honor."
Ms. Murray said, "Yes, Your Honor."
The court said, "It sounds very ambitious."
Mr. Skirick said, "But worthwhile, Your Honor."
Ms. Murray said, "I tend to agree."
The court said, "Based on my own experience, to me it does not seem that we will necessarily be able to finish the defense summation, so I think we need to play it by ear, and I would like you to prompt me concerning the breaks."
Ms. Murray said, "Yes, Your Honor. We're happy to do that and we really appreciate that. We've spoken with AUSA Finkel. And we're aware of how the timing would work. And for the morning break that would be in the middle of his summation. We'll make sure it's at an appropriate stopping point. We'll give as much kind of notice to your clerks so they can advise you so you'll be aware of what the timing is during the summation."
Mr. Skirick said, "Likewise we'll do the same during defense summation."
The court said, "I can inquire as to whether they can stay another half hour. I know that juries tend not to like that."
Mr. Skirick said, "Your Honor. One sort of potential alternative just to suggest it to the court for the court's consideration is in light of the delay in alternate number 3 coming to court is to tell the jury that in lieu of finishing the charge this morning that perhaps we go into summations this morning and finish the charge at the end of summations when everyone is here perhaps tomorrow morning."
The court said, "So I don't think that is a good idea. Especially because what is left is the racketeering charge, which is not a crystal clear concept. And I think it helps them to first hear about the law as it is so that they can better assimilate the arguments. Alrighty.
Mr. Skirek said, we just have two housekeeping matters from the defense. One comes out of the defense's Stip 2, which was entered into evidence yesterday. The court may recall that I referred during defense Stip 2 to a subset of documents. A subset of defense exhibits that would be moved in. We have agreement with the government, I believe, on what that subset is. I'm happy to read it into the record now to have Your Honor move it informally if that's okay. It's a series of numbers and letters as usual.
The court said, go ahead.
Mr. Skirek said, defense moves in DX40017.1 through DX40017.18, DX40019.1 through DX40019.4, DX40021.1 through DX40021.2, DX40024.1 through DX40021.9, DX40037.1 through DX40037.4, DX40052.1 through DX40052.7, DX40053.1 through DX40053.4. In addition, DX40017T, DX40019T, DX40021T, DX40024T, DX40037T, DX40052T, and finally DX40053T. And we move those into evidence.
The court said, they are admitted. Defendants exhibits DX40017.1 through DX40017.18, DX40019.1 through DX40019.4, DX40021.1 through DX40021.2, DX40024.1 through DX40021.9, DX40037.1 through DX40037.4, DX40052.1 through DX40052.7, DX40053.1 through DX40053.4. DX40017T, DX40019T, DX40021T, DX40024T, DX40037T, DX40052T, DC40053T received in evidence.
Mr. Skirek said, one final matter to pick up on, a loose end from yesterday. The court may recall we had a discussion at yesterday's 9 o'clock about whether it's permissible for the defense to argue in summation certain inferences from the record evidence, including in particular the testimony of Mr. He, who has been manipulated by the CCP in China. I would just like to address that briefly, Your Honor. Now that we had a chance to review the record and appreciate the court's indulgence on that score. Just as a background matter, the law, Your Honor, as we understand it based on Second Circuit's precedent, is that counsel have broad latitude in inferences they may reasonably suggest to the jury during summation. That is United States v. Edwards. 342 F.3d 168, 2 DCIR 2003. And counsel are free to make arguments which may reasonably be inferred from the evidence presented. That's United States v. Roland Zapata, 916 F.2d 795, 2 DCIR 1990. Your Honor, as the court well knows through the Fox Hunt Stip, which is the defense Stip 1, it is aptly in evidence that a principal goal of the Fox Hunt initiative was to discredit Mr. Guo using multiple means, and that the MSS tasked a specially formed group to that end. The court heard testimony from the defense expert Paul Doran, who testified as to, among other things, the CCP's tactics in manipulating its citizens by accusing them of false or gradually exaggerated crimes. The court also heard testimony from Mr. He, which I referred to before. He testified that what the Chinese police did to him, not only detaining him in China and forcing him to sign false complaints to the U.S. authorities, including the FBI and DOJ, but also abusing the U.S. judicial system itself by causing false civil complaints and lawsuits to be filed on Mr. He's behalf here in the United States. Next, the court also heard testimony from the government's witness Ms. Yili, also known as Mulan. Ms. Li testified that her parents in China were contacted by the CCP and told to tell her to stop all of her Guo-related activities because they threatened national security. In addition, as part of the defense's good faith basis for being able to argue the inferences that we request. Your Honor, there was 3,500 material produced by the government relating to Mulan, relating to Yai Li. After Ms. Li's testimony was over in this case, in which Ms. Li reported that she heard reports similar to the ones that Mr. He testified to, and that Chinese police approach people, and this is a quote from the 3,500. She heard similar reports where Chinese police approach people and instruct them to report to the FBI. This is all real, true, no people in mainland China in jail.
The court said, so if you could just identify specifically where you're getting that from?
Mr. Skirik said, yes, Your Honor. This is the 3,500 produced by the government, I believe, on July 1st of this year. And again. That's further to Ms. Li's record testimony where she testified that her parents in China were contacted by the police and the request was passed along to them to tell her to stop her activities. There's also, I believe, it's aptly in evidence that there are numerous of the government's witnesses who still have relatives in China who are of course susceptible to the same coercion by the CCP as long as they're in mainland China. And for those among other reasons, we think it's entirely proper based on Second Circuit precedent for the defense to be able to argue that what happened to Mr. He, that it is plausible and possible that has happened to other complainants, including the government's witnesses, victim witnesses, but not limited just to the victim witnesses, Your Honor. Just for the record, the cite to the 3,500 that I just referred to is 3613-071, Ms. Yai Li's 3,500 produced July 1st.
Mr. Horton said, Your Honor ruled on this yesterday morning. Mr. Skirik said that they would like to argue that it's a fact in evidence that the CCP planned to coerce people in China into making false complaints. So the defense ought to be able to argue to the jury in closing that that is something that has likely happened with respect to others besides Mr. He. And Your Honor ruled, and I'm quoting Your Honor, this is a very hard no. No. You cannot make that argument. That was correct. We cited a number of Second Circuit cases for Your Honor yesterday that confirm that the trial judge has broad discretion to limit the defense summation for the purpose of excluding arguments that are not tethered to facts in evidence. This is a particularly prejudicial argument. Mr. He's testimony, reviewed it quite closely, focused entirely on his personal experience. And indeed that was what the court said was permissible testimony from the defense witnesses, limited to their investing experience. He didn't testify about anybody else's experience. It wouldn't have been permissible for him to testify about anybody else's experience. It wouldn't have been permissible under Rule 608 for them to try to impeach another victim witness through Mr. He. And they didn't do that. This talk about victim witnesses having parents in China. They would have made a choice to cross-examine victims before the jury and suggest to the jury that their testimony was false or not trustworthy because their parents live in China. They chose not to do that. And what they're trying to do, and what Your Honor ruled on, is to take a single victim's, a single investor's testimony limited to his own experience, and I can go through specific sites in the transcript to show how limited it was, and extrapolate from that to really unfortunate innuendo against the victim witnesses in the case. And Your Honor said it was a very hard no, and that was absolutely correct.
Mr. Skirik said, Your Honor, a few things. One is that the court may recall after you'd said that on the record yesterday, you did in fact give the defense the opportunity to come back and present what I said would be a fuller record on the issue. So that's what we're doing here, so respectfully we do not believe that the court ruled on this issue. You left it open in order for us to present to you what we just presented to you. That's point one.
The court said, Mr. Skirik, when Ms. Li was testifying, did you raise this question about what she may have heard about others?
Mr. Skirik said, yes.
The court said, I'm asking whether you cross-examined on the issue?
Mr. Skirik said, we did cross-examine and elicited testimony, Your Honor, about her parents having been contacted by the CCP police in China.
The court said, no, I'm talking about others, people that are not related to her?
Mr. Skirik said, yeah, Your Honor. I'm not sure that we would have been able to do that. It would have elicited hearsay. which I'm sure that the court would not have permitted. But I think, Your Honor, if I may, the point is not.
The court said, so what you're saying is that her knowledge of the others is not in evidence. Isn't that what you're saying?
Mr. Skirek said, Your Honor, what we're saying is, we're not bound as I understand it to have to show that each of the individual witnesses that the government called are aware of others being manipulated the way that they were.
The court said, but you have to have some evidence in the record from which to draw a reasonable inference. So far the evidence has pertained only to testifying individuals and the evidence is now closed.
Mr. Skirek said, if I may point out to the court, we have Mr. He whose testimony we all knows goes directly to this issue. Right.
The court said, his personal experience.
Mr. Skirek said, correct, his personal experience.
The court said right.
Mr. Skirek said, in addition, we have Ms. Lee's personal experience, Mulan's personal experience. We also have Mr. Doran's expert testimony about the methods by which the Chinese government and CCP coerce its own citizens in China into doing things. And we also have testimony from numerous victim witnesses who say that they have family who lives in China. And I would submit to the court that when you put all of that together, there is enough of a factual basis from which the defense ought to be able to argue there is a reasonable inference that this could and may have happened with respect to others. There's no reason to believe that the personal experience of Mulan and the personal experience of Mr. He were limited to just them in light of Mr. Doran's testimony about the way that the Chinese government goes about manipulating its citizens. That is, I think, more than enough basis to draw the inference that the defense request.
The court said, is there anything further from the government?
Mr. Horton said, no. Your Honor's ruling yesterday was correct.
The court said, all righty. So,
Mr. Skirek said, one more point.
The court said, I don't agree that you can generalize and speculate based on the testimony in this case, and so I adhere to my decision. Anything further?
Mr. Horton said, not from the government. Thank you, Your Honor. Judge.
Mr. Skirek said, not from the defense. Thank you.
The court said, I'm just waiting from an update as to the alternate as to his anticipated arrival time. I will let you know.
Ms. Murray said, thank you, Your Honor.
Recess. Continued on next page. Jury not present.
The court said, all the jurors are present. You would have them brought in, please.
The law clerk said, jury entering.
Jury present.
The court said, please be seated. Good morning, jurors. Please turn to page 50 of the jury charge. I am now going to continue reading the instructions. Finally, I will turn to count 1, which charges the defendant with conspiring to violate the federal racketeering statute, Section 1962C, of Title 18 of the United States Code. The statute is commonly referred to as RICO, which stands for the Racketeer Influenced and Corrupt Organizations Act. The instructions for this charge have several steps, and I will walk through them one by one. Let me first note that the word racketeering may have implications in ordinary English. Do not infer anything from it. The word, as used in this statute, is a purely technical term that is defined specifically for this statute. The RICO statute makes it a crime for any person employed by or associated with any enterprise engaged in, or the activities of which affect interstate or foreign commerce, to conduct or participate, directly or indirectly, in the conduct of such enterprises' affairs through a pattern of racketeering activity. Count 1 of the indictment charges the defendant with participating in a racketeering conspiracy from in or about 2018 through in or about March 2023. In order to meet its burden of proving that the defendant is guilty of the racketeering conspiracy charged in Count 1, the government must establish beyond a reasonable doubt each of the following elements. First, that at or about the time charged in Count 1, the conspiracy charged in the indictment existed, that is, that an agreement or understanding between two or more persons existed to conduct or participate in the conduct of a racketeering enterprise. Second, that the racketeering enterprise or its activities would have affected, or in fact affected, interstate or foreign commerce. Third, that the defendant knowingly and intentionally joined the conspiracy. And fourth, that the defendant knowingly and intentionally agreed with at least one other person that either he or a co-conspirator would participate, either directly or indirectly, in the conduct of the affairs of the enterprise through a pattern of racketeering activity. as described in the indictment, that is, that either the defendant or a co-conspirator would commit at least 2 acts of racketeering activity. The first element the government must prove beyond a reasonable doubt is the existence of the conspiracy alleged in Count 1 of the indictment, that is, the agreement to conduct or participate in the conduct of a racketeering enterprise. Before I define these technical terms, I remind you that it is not necessary that a conspiracy actually succeed in its purpose for you to conclude that it existed. Because the agreement to commit a racketeering offense is the essence of Count 1, the government need only prove that if the conspiracy achieved its objective as contemplated, the enterprise would be established and that its members would participate in conducting the affairs of the enterprise through a pattern of racketeering activity. Of course, proof that the objective of the conspiracy was accomplished, if you find it was, may be the most persuasive evidence of the existence of the conspiracy. The object of a conspiracy is the illegal purpose the conspirators agree or hope to achieve. The object of the conspiracy charged in Count 1 is to violate the RICO statute, in other words, to conduct or participate in the conduct of the affairs of an enterprise through a pattern of racketeering activity. What is an enterprise? Under the racketeering statute, an enterprise includes any legal entity such as a partnership, corporation or association, or a group of individuals who are associated in fact, although not a legal entity. The enterprise does not need to have a particular name, or for that matter, have any name at all. Nor need it be registered or licensed as an enterprise. It does not have to be a commonly recognized legal entity, such as a corporation, a trade union, a partnership, or the like. But an enterprise could be a legal entity or a group of legal entities. An enterprise may be a group of people informally associated together for a common purpose of engaging in a course of conduct. This group may be organized for a legitimate and lawful purpose, or it may be organized for an unlawful purpose. In addition to having a common purpose, this group of people must have a core of personnel who function as a continuing unit. Furthermore, the enterprise would continue to exist, or did continue to exist, in substantially similar form through the period charged, in this case from 2018 through March 2023. This does not mean that the membership must remain exactly identical, but the enterprise must have a recognizable core that continues through a substantial period during the time frame charged in the indictment. Count 1 of the indictment defines the charged conspiracy as an agreement to participate in the conduct of an organization, referred to by the government as the G enterprise. The term G enterprise is simply a form of reference used by the government in the indictment to describe the group of businesses and individuals who participated in the alleged racketeering conspiracy. The government is not required to prove each and every allegation about the G enterprise. If you find that there was an agreement to conduct or participate in the conduct of a group of people characterized by 1. A common purpose, 2. An ongoing formal or informal organization, and 3. Personnel who function as a continuing unit, then you may find that the first element of a racketeering conspiracy has been satisfied. The second element that the government must prove beyond a reasonable doubt is that the enterprise itself, or the racketeering activities of those associated with it, would have some effect on interstate or foreign commerce, or in fact had such an effect. This effect on interstate commerce could have occurred in any way, and it need only have been minimal. Interstate commerce includes the movement of goods, services, money, and individuals between states. It is not necessary for the government to prove that any particular acts affected interstate commerce or even that acts that the defendant personally committed affected interstate commerce. It need only prove that some act or acts of the enterprise, even perfectly legal acts of the enterprise, had such an effect on interstate commerce. It is not necessary for you to find that the defendant knew the enterprise was engaged in interstate commerce. All that is necessary is that you find beyond a reasonable doubt that the activities of the enterprise would affect, or did affect, interstate or foreign commerce in some minimal way. The third element the government must prove beyond a reasonable doubt is that, at some point during the time period charged in the indictment, 2018 through March 2023, the defendant was a member of the charged conspiracy. I previously instructed you about participation in a conspiracy, and you should follow those general instructions here. See pages 31 to 35. You must determine not only whether the defendant participated in the conspiracy, but also whether he did so intentionally and knowingly, that is, did he participate in the conspiracy with knowledge of its unlawful purpose, and with the specific intention of furthering the objective of that conspiracy? As I've previously instructed you, a conspiracy is an agreement or partnership by two or more persons to violate the law. The object of a conspiracy is the illegal purpose the conspirators agree or hope to achieve. The object of the conspiracy charged in Count 1 is to violate the RICO statute, in other words, to conduct or participate in the conduct of the affairs of an enterprise through a pattern of racketeering activity. Even if a defendant did not personally participate in the operation or management of the enterprise, he may be convicted of a RICO conspiracy offense when the evidence establishes that the defendant knowingly agreed to facilitate a scheme which, if completed, would constitute a RICO substantive violation. Similarly, the government need not prove that the defendant agreed with every other member of the enterprise, knew all of the other members of the enterprise, or had full knowledge of all of the details of the enterprise. However, in proving this element, the government must prove that the defendant was connected to the enterprise in some meaningful way, and that the defendant knew the general nature of the enterprise and knew that the enterprise existed beyond his individual role. When considering if the defendant joined the conspiracy, you may consider evidence, if any, that the defendant agreed that a conspirator would intentionally perform acts, functions or duties which are necessary to, or helpful in the operation of the enterprise, or that a conspirator had some part in directing the enterprise's affairs. However, the government need not prove that the defendant would exercise significant control over or within the enterprise, or that he had a formal position in the enterprise, or that he had primary responsibility for the enterprise's affairs. An enterprise is operated not just by upper management, but also by lower-rung participants in the enterprise who are under the direction of upper management carry out upper management's orders. I want to caution you, however, that the defendant's mere presence at the scene of a crime does not, by itself, make him a member of the conspiracy. Similarly, mere association with one or more members of the conspiracy does not automatically make the defendant a member. A person may know or be friendly with a criminal without being a criminal himself. Mere similarity of conduct or the fact that they may have assembled together and discussed common aims and interests does not necessarily establish membership in the conspiracy. What is necessary is that the defendant participated with knowledge of the unlawful objective of the conspiracy and with intent to aid in the accomplishment of that objective. Ultimately, the question is this: has the government proven beyond a reasonable doubt that the defendant joined the conspiracy and knowingly and intentionally participated in it with the awareness of its basic purpose and as something he wished to bring about? The fourth element that the government must prove beyond a reasonable doubt is that the defendant knowingly conspired or agreed to participate in the conduct of the affairs of the enterprise through a pattern of racketeering activity. The focus of this element is on the defendant's agreement to participate in the objective of the enterprise to engage in a pattern of racketeering activity, and not on the defendant's agreement to commit the individual criminal acts. The government must prove that the defendant agreed to participate in the enterprise with the intent that he or another member or members of the conspiracy would commit two or more racketeering acts, which I will describe. The government is not required to prove that the defendant agreed to commit two racketeering acts himself, or that he actually committed two such acts. As I told you, it is not necessary that a conspiracy actually succeed in its purpose for you to conclude that it existed. Because the agreement to commit a racketeering offense is the essence of Count 1, the government need only prove that if the conspiracy achieved its objective as contemplated, the enterprise would be established, that its members would participate in conducting the affairs of the enterprise through a pattern of racketeering activity, and that those activities would affect interstate or foreign commerce. A pattern of racketeering activity requires at least two acts of racketeering, the last of which occurred within 10 years after the commission of a prior act of racketeering. These acts are referred to as predicate acts for the RICO conspiracy charge. To establish an agreement that the enterprise would engage in a pattern of racketeering activity, as alleged in Count 1 of the indictment, the government must prove three things beyond a reasonable doubt. First, that the defendant agreed that a conspirator, which could be the defendant himself, would intentionally commit or cause or aid and abet the commission of two or more of the racketeering acts of the types alleged in Count 1 of the indictment. You must be unanimous as to which particular types of racketeering crimes, if any, the defendant agreed would be committed. For example, wire fraud, securities fraud, bank fraud, money laundering, or any combination thereof. Second, that the racketeering acts have a nexus to the enterprise and the racketeering acts are related to one another. A racketeering act has a nexus to the enterprise if it has a meaningful connection to the enterprise. To be related, the racketeering acts must have the same or similar purposes, results, participants, victims, or methods of commission, or be otherwise interrelated by distinguishing characteristics, and not be merely isolated events. Two racketeering acts may be related, even though they are dissimilar or not directly related to each other, provided that the racketeering acts are related to the same enterprise. For example, for both nexus and relatedness purposes, the requisite relationship between the RICO enterprise and a predicate racketeering act may be established by evidence that a person was enabled to commit the racketeering act solely by virtue of his position in the enterprise or involvement in or control over its affairs, or by evidence that a person's position in the enterprise facilitated his commission of the racketeering act, or by evidence that the racketeering act benefited the enterprise, or by evidence that the racketeering act was authorized by the enterprise, or by evidence that the racketeering act promoted or furthered the purposes of the enterprise. Third, to establish a pattern of racketeering activity, the government must prove either 1, that the racketeering acts themselves would have extended over a substantial period of time, or 2, that they posed or would pose a threat of continued criminal activity. A threat of continued criminal activity need not be proven by any mathematical formula, or by any particular method of proof. Rather, it may be proven in a variety of ways. For example, the threat of continued unlawful activity may be established when the evidence shows that the racketeering acts are part of an enterprise that exists solely for criminal purposes, or when the racketeering acts are shown to be the regular way of conducting the affairs of the enterprise, even where the enterprise also operates for legitimate, non-criminal purposes. Moreover, in determining whether the government has proven the threat of continued unlawful activity, you are not limited to consideration of the specific racketeering acts that the defendant and his co-conspirators are alleged to have committed. Rather, in addition to considering such acts, you also may consider the nature of the enterprise and other unlawful activities of the enterprise and its members viewed in their entirety, including both charged and uncharged unlawful activities. For a conviction under Count 1, the government must prove that the defendant intended to further an endeavor which, if completed, would have satisfied all the elements of a substantive racketeering offense. The government is not required to prove that the defendant personally committed or agreed to commit any act of racketeering, nor is it required to prove that any acts of racketeering actually occurred. Rather, the government must prove that the defendant agreed to participate in the enterprise with the knowledge and intent that at least one member of the racketeering conspiracy, which could be the defendant himself, would commit at least 2 racketeering acts in the conduct of the affairs of the enterprise, and that those acts would constitute a pattern of racketeering activity as defined above. Enterprise v. Pattern of racketeering activity. Let me make clear that an enterprise is not the same thing as the pattern of racketeering activity. To convict, the government must prove that if the conspiracy achieved its objective there would be an enterprise, and that the enterprise's affairs would be conducted through a pattern of racketeering activity. The enterprise in this case, which the government refers to as the G enterprise, is alleged to be a group of individuals and businesses who associated together for a common purpose of engaging in a course of conduct. A pattern of racketeering activity, on the other hand, is a series of criminal acts. The existence of the enterprise is proven by evidence of an ongoing organization, formal or informal, with a common purpose, and by evidence that various core personnel of the group functioned as a continuing unit. The pattern of racketeering activity, on the other hand, is proven by evidence of a minimum of 2 acts of racketeering that the participants in the enterprise agreed would be committed. The proof used to establish those separate elements may be the same or overlapping. For example, if you find that an ongoing enterprise existed, the existence of this enterprise may help establish that the separate racketeering acts were part of a pattern of continuing criminal activity. Nevertheless, you should bear in mind that proof of an enterprise does not necessarily establish proof of a pattern of racketeering activity, and vice versa. Finally, although you need not decide whether the defendant agreed to the commission of any particular racketeering act in order to convict him of the RICO conspiracy offense, you must be unanimous as to which type or types of predicate racketeering crimes the defendant agreed would be committed. For example, wire fraud, securities fraud, bank fraud, money laundering, or any combination thereof. The indictment alleges that the following categories of criminal violations were committed or were intended to be committed as part of the racketeering conspiracy charged in Count 1. 1 Acts involving wire fraud, in violation of federal law. 2 Acts involving bank fraud, in violation of federal. 3 Acts involving the laundering of monetary instruments, also known as money laundering, in violation of federal law. 4 Acts involving engaging in monetary transactions in property derived from specified unlawful activity, in violation of federal law. And 5 Acts involving securities fraud, in violation of federal law. The government does not need to prove that the defendant agreed that all of these types of racketeering crimes would be committed. As I explained, the government must prove that the defendant agreed that at least 2 racketeering acts would be committed. Those acts may be within the same category of racketeering activity, such as 2 acts of wire fraud, or those acts may be within different categories of racketeering activity, such as 1 act of wire fraud and 1 act of money laundering. I previously instructed you on violations of the wire fraud statute, in connection with counts 5, 7, 9, and 11, see pages 16 to 21. You should use those instructions in assessing whether acts involving wire fraud, in violation of federal law, were committed or intended to be committed. I previously instructed you on violations of the bank fraud statute, in connection with the bank fraud object of Count 2's conspiracy to commit wire fraud and bank fraud, see pages 37 to 40. You should use those instructions in assessing whether acts involving bank fraud, in violation of federal law, were committed or intended to be committed. I previously instructed you on violations of the money laundering statute, in connection with the objects of the money laundering conspiracy alleged in Count 3, see pages 40 to 47. You should use those instructions in assessing whether acts involving the laundering of monetary instruments, also known as money laundering, in violation of federal law were committed or intended to be committed. I previously instructed you on violations of engaging in monetary transactions in property derived from specified unlawful activity, in connection with Count 12, see pages 27 to 29. You should use those instructions in assessing whether acts involving engaging in monetary transactions in property derived from specified unlawful activity were committed or intended to be committed. And I also previously instructed you on violations of the securities fraud statute, in connection with Counts 6, 8, and 10, see pages 22 to 27. You should use those instructions in assessing whether acts involving securities fraud, in violation of federal law, were committed or intended to be committed. With respect to each count in the indictment, the government, in addition to proving the essential elements of that charge, must also prove that at least 1 act in furtherance of the charge occurred in the Southern District of New York. This is called establishing venue. The Southern District of New York includes all of Manhattan and the Bronx, as well as Westchester, Rockland, Putnam, Dutchess, Orange, and Sullivan counties. The government does not have to prove that a completed crime was committed within the Southern District of New York, or that the defendant was ever in the Southern District of New York. It is sufficient to satisfy the venue requirement if any act in furtherance of the crime charged occurred in this district. The act itself need not be a criminal act, and the act need not have been taken by the defendant, so long as the act was part of the crime that you find the defendant committed. The defendant did not testify in this case. Under our Constitution, a defendant has no obligation to testify or to present any evidence, because it is the government's burden to prove a defendant guilty beyond a reasonable doubt. That burden remains with the government throughout the entire trial, and never shifts to a defendant. A defendant is never required to prove that he is innocent. You may not attach any significance to the fact that the defendant did not testify. No adverse inference against him may be drawn by you because he did not take the witness stand. You may not hold this against him or consider it in any way in your deliberations in the jury room. You heard the testimony of some witnesses who are law enforcement officers and employees of the FBI. The fact that a witness works for the government or in law enforcement does not mean that the witness's testimony is, by virtue of the witness's position, deserving of more or less consideration, or greater or lesser weight, than that of any other witness. The testimony of such a witness should not be regarded as more or less truthful or accurate than that of any other witness simply based on the witness's employment. It is your decision, after reviewing all of the evidence, whether to accept the testimony of the law enforcement witness and to give that testimony whatever weight, if any, you find it deserves. You heard testimony from what we call an expert witness. An expert is a witness who, by education or experience, has acquired learning or experience in a specialized area of knowledge. Expert witnesses are permitted to express their opinions as to relevant matters in which they have special knowledge, skill, experience, and training, and to give their reasons for their opinions. Expert testimony is presented to you on the theory that someone who is experienced in the field can assist you in understanding the evidence or in reaching an independent decision on the facts.
Continued on next page.
The court said, your role in judging credibility applies to experts, as well as other witnesses. In weighing this opinion testimony, you may consider a witness's qualifications, his or her opinions, the reasons for testifying, as well as all of the other considerations that ordinarily apply when you are deciding whether or not to believe a witness's testimony. You may give the opinion testimony whatever weight, if any, you find it deserves in light of all the evidence in this case. You should not, however, accept opinion testimony merely because I allowed the witness to testify concerning his or her opinion, nor should you substitute it for your own reason, judgment, and common sense. The determination of the facts in this case rests solely with you. As with the testimony of any other witness, you may decide to accept all, some, or none of the testimony of any expert witness. If you should decide that the opinion of an expert was not based on sufficient education or experience or on sufficient data, or if you should conclude that the trustworthiness or credibility of an expert is questionable for any reason, or if the opinion of the expert was outweighed in your judgment by other evidence in the case, then you may disregard the opinion of the expert entirely or in part. On the other hand, if you find the opinion of an expert is based on sufficient data, education, and experience, and the other evidence does not give you reason to doubt his or her conclusions, you would be justified in placing reliance on his or her testimony. You heard testimony from witnesses who entered into non-prosecution agreements with the government arising out of facts that are at issue in this case. You are instructed that you are to draw no conclusions or inferences of any kind about the guilt of the defendant from the fact that a witness entered into such an agreement, even involving similar conduct. The decision of that witness to enter into that agreement is a personal decision. Likewise, the government's decision to enter into the agreement is a lawful exercise of its discretion. Fourth, you may consider whether the fact that the witness entered into the agreement affects the credibility of their testimony. You have heard evidence that the defendant and certain entities were represented by attorneys. A lawyer's involvement with an individual or entity does not make that individual or entity's actions legal. You heard evidence that witnesses may have discussed the facts of this case with the defense lawyers or with government lawyers before they appeared in court. Although you may consider that fact when you are evaluating a witness's credibility, there is nothing either unusual or inherently improper about a witness meeting with the defense lawyers or the government lawyers before testifying so that the witness can be aware of the subjects he or she will be questioned about, focus on those subjects, and have the opportunity to review relevant exhibits before being questioned about them. Such consultation helps conserve your time and the court's time. In fact, it would be unusual for a lawyer to call a witness without such consultation. The weight you give to the fact or the nature of the witness's preparation for his or her testimony, and what inferences you draw from such preparation are within your discretion. There are several people whose names you heard during the course of the trial, but who did not appear here to testify. I instruct you that each party had an equal opportunity, or lack of opportunity, to call any of these witnesses. Therefore, you should not draw any inference or reach any conclusions as to what they would have said if they had been called to testify. Their absence should not affect your judgment. You should, however, remember my instruction that the law does not impose on a defendant in a criminal case the burden or duty of calling any witness or producing any evidence. The burden remains with the government to prove the defendant guilty beyond a reasonable doubt. In this case, you heard evidence in the form of stipulations of fact. A stipulation of fact is information the parties agree to present to the jury as evidence without calling a witness to testify. The parties agree that the facts contained in the stipulations are true. You must accept those facts as true. Some of the exhibits were submitted in the form of charts and summaries. For the charts and summaries that were admitted into evidence, you should consider them as you would any other evidence. You heard testimony about evidence seized in connection with certain searches conducted by law enforcement officers. Evidence obtained from these searches may be properly considered by you. Such searches were lawful law enforcement actions. Whether you approve or disapprove of how the evidence was obtained should not enter into your deliberations because I instruct you that the use of the evidence is lawful. You must, therefore, regardless of your personal opinions, give this evidence full consideration, along with all the other evidence in the case in determining whether the government has proved the defendant's guilt beyond a reasonable doubt. You will note that the indictment alleges that the charged crimes occurred in or about 2018 to March 2023. It does not matter if the evidence you heard at trial indicates that a particular act occurred on a different date. The law requires only a substantial similarity between the date alleged in the indictment and the date established by the evidence. You heard reference in the arguments, you will hear reference in the arguments of counsel to the fact that certain investigative techniques were, or were not used by law enforcement authorities. You may consider these facts in deciding whether the government has met its burden of proof, because you should look to all of the evidence or lack of evidence in deciding whether the defendant is guilty. However, there is no legal requirement that law enforcement agents investigate crimes in a particular way, or that the government prove its case through any particular means. The government and its techniques are not on trial. Although you are to carefully consider the evidence presented, you need not speculate as to why law enforcement used the techniques they did, or why they did not use other techniques. Your concern is to determine whether or not, based on the evidence or lack of evidence, the guilt of the defendant has been proven beyond a reasonable doubt. The government has introduced evidence in the form of audio and video recordings. Whether you approve or disapprove of the recording of these conversations may not enter into your deliberations. I instruct you that these recordings were made in a lawful manner, and that no one's rights were violated, and that the government's use of this evidence is lawful, and it was properly admitted into evidence at this trial. You must, therefore, regardless of any personal opinions, give this evidence consideration, along with all the other evidence in the case, in determining whether the government has proven the defendant's guilt beyond a reasonable doubt. If you wish to hear any of the recordings again, they will be made available to you during your deliberations. During the trial, you were given transcripts of recordings which were admitted into evidence. These transcripts were translations of foreign language recordings in Mandarin. You were also shown translations of foreign language documents. Although some of you may know Mandarin, it is important that all jurors consider the same evidence. Therefore, you must accept the English translations that are in evidence and disregard any different meaning. Among the exhibits received in evidence are some exhibits that are redacted. Redacted means that part of the document or recording was taken out. You are to concern yourself only with the part of the item that has been admitted into evidence. You should not speculate as to any reason why the other part of it has been redacted. Some of the people who may have been involved in the events leading to this trial are not on trial. This does not matter. There is no requirement that all people jointly engaged in criminal activity be charged and prosecuted or tried together in the same proceeding. You may not draw any inference, favorable or unfavorable, toward the government or the defendant from the fact that certain persons other than the defendant were not named as defendants in the indictment. Nor may you speculate as to the reasons why other persons are not on trial. Those matters are wholly outside your concern, and have no bearing on your function as jurors. Your verdict must be based solely upon the evidence developed at trial or the lack of evidence. In reaching your decision as to whether the government sustained its burden of proof, it would be improper for you to consider any personal feelings, positive or negative, you may have about the defendant's race, religion, national origin, sex or age. The defendant and the government are both entitled to a trial free from prejudice. And our judicial system cannot work unless you reach your verdict through a fair and impartial consideration of the evidence. I'm also going to ask you and advise you to not decide the case based on implicit biases. Everyone, including me, has feelings or assumptions or perceptions or fears or even stereotypes, and they're referred to as implicit biases, and you might not even be aware of them. These hidden thoughts can impact what we see and hear, how we remember what we see and hear, and how we make important decisions. Because you are making important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to any conclusions based on personal likes or dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. Members of the jury. Next, we turn to another stage of the trial, and so you may put down your instructions. But before we turn to the summations, we're going to take a 5-minute break. Remember, do not discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, watch, or listen to anything from any source concerning any topic that touches upon this trial.
Jury not present.
The court said, you may be seated. I understand the government is going to take time now to set up.
Mr. Finkel said, yes, Your Honor.
Recess.
The court said, please have the jurors brought in.
Jury present.
The court said, please be seated. Members of the jury, now we turn to summations. The government will make its summation first, then the defense will follow. As I said yesterday, after the parties' summations, I will provide my final instructions. In making their summations, the government and the defense will review the evidence you've heard and seen during the course of the trial, and will suggest to you certain inferences or conclusions which they, in their opinion, believe may be properly drawn from the evidence in this case. If you find a particular attorney's analysis of the evidence to be correct and accurate, then you are at liberty to adopt such inferences and conclusions in whole or in part. On the other hand, if you find that a particular attorney's analysis of the evidence to be not correct and not accurate, then you are at liberty to disregard such inferences and conclusions in whole or in part. Either way, you are free to draw your own conclusions based on your analysis of the evidence presented. Nothing said by either attorney in their summations is evidence. In this case, it is argument. The instructions on the law that I provided to you yesterday and this morning, that I will provide following summations, are not evidence either. You have heard all the evidence in this case. You, and you alone, are the sole and exclusive judges of the facts in this case. We will now hear the summation of the government by Assistant United States Attorney Ryan Finkel.
Mr. Finkel said, thank you. Good morning.
Audio played.
Mr. Finkel said, that's the real Miles Guo.
The court said, Mr. Finkel, please get close to the microphone.
Mr. Finkel said, that's the real Miles Guo. The person that Brother Seven, the supposed political activist, never thought his followers would hear. The real Miles Guo, who he never thought anyone would hear. And especially not a jury in a criminal trial. But you heard it. You heard the proof behind all these G entities. G TV, G Club, G News, G Mall, G Fashion, the G Series. Miles Guo was the man in charge, the boss. It was Guo himself, this man, who spouted devious lies to trick his followers into giving him money. Lies he told time and time and time and time again. Lies he told so he could take other people's money. That recording that you just heard was on April 28, 2021, in the thick of this fraud conspiracy. Miles Guo, Yvette Wong, and William J., who's also known as Mr. UYU, were recorded unknowingly to them by Haitham Khalid. Now Guo, Yvette, and William didn't know that Haitham was creating a record of their discussion. A discussion about how and whether to paper the movement of $100 million of G Club member fees, fraud proceeds. How to move that money from a G Club bank account abroad to Hamilton, to William J.'s foundation, which he operated in London, in Abu Dhabi. Now Yvette, as you may recall from the recording, was concerned. She thought they at least needed to go through the G Club's board, meaning Howard and he, the paper ultimate beneficial owner of G Clubs. Miles' son Guo's son, best friend. Yvette pleaded, "Do you think a normal company would do this? Just send the money off like Guo wanted?" Jie said they could just use G dollars to make it look real. They discussed using H coin, Himalaya coin for compliance. Yvette wanted those things to make sure she can answer questions from banks, from regulators, from the Securities and Exchange Commission, from U.S. law enforcement, so that the scam would look legitimate. So they could hide their crimes. But Guo interjected. Guo asked whether Howard he, the paper owner, authorized Alex H., the G Club's controller who worked in Manhattan, whether he was authorized to move the $100 million. Yvette Wang reasserted that that's not enough. They should go through the board. They should make it look official. But Miles Guo, boss, the principal, the man in charge, he did not want to wait. With that context, let's listen again.
Audio played.
Mr. Finkel said, Miles Guo ordered that they move the money as a so-called investment from G Club's member proceeds. Victim money, that they move it abroad to Hamilton. Miles Guo, who on paper is just a spokesperson for G Clubs, was recorded on tape. And you heard it. Government Exhibit 417. He controlled the money of G Clubs, which is to say what is obvious, what is known, what is clear. Guo controlled G Clubs. He directed how the money would move and when. And they did it. They papered it with this document on the left side of your screen that has an effective date of March 6, 2021. A backdated transfer, $35 million. And more, as the bank records show, followed from G Club's operations to Hamilton Digital Assets. G Clubs existed so that Guo could take other people's money, and that's what he used it for. Now, this trial began about 7 weeks ago to the day, and between then and now, you have learned and you have seen evidence about the real Miles Guo, the man who, from 2018 through 2023, received hundreds of millions of dollars, money Guo got and spent on himself and his family. Money Guo got because he lied, because he committed fraud, because Guo laundered those fraud proceeds and tried to cover it all up. And in the process, Miles Guo agreed and, in fact, actually built an enterprise of fraud. He engaged in a racketeering RICO conspiracy. That's what he did. That's why he's guilty. Now, the RICO conspiracy Miles Guo engaged in that you have heard about was made up of all these companies and entities and organizations. The Himalaya Farm Alliance, the Iron Blood Group, the Himalaya Exchange, Hamilton, Mountains of Spices, ACA Capital, Sriracha, Golden Spring, Lamp Capital, Crane, the New Federal State of China, the Rule of Law Foundation, and entities that bear Guo's name: G News, G TV, G Clubs, G Fashion, G Bank. As Guo himself called it, the G Series. There are other entities. I could go on. But make no mistake about it, this was Miles Guo's enterprise. What the indictment in this case has turned the G enterprise for Miles Guo. An association of entities and people within them that carried out Guo's vision to erect a fraud empire. A fraud empire that committed wire fraud and securities fraud and bank fraud and laundered money, and it targeted people. His enterprise targeted people who tried to get between Guo and his fraud proceeds. Guo used the G enterprise to buy whatever he and his family wanted. That's what it was for. That's why he did it. That's why he's guilty. So you have seen the evidence, you've heard from all the witnesses. And now you know this was a scheme, this was a con, this was a fraud. And Miles Guo, that man, was behind all of it. And though the scheme was vast and the enterprise was wide-ranging, its core, its foundation, so simple. Miles Guo lied to take other people's money. That's it. He streamed videos of himself over the internet. He lied to the people who watched them, his followers. He said, send money. Invest. He promised his followers, his supporters, you're not going to lose money. I'm rich. I'll take care of you. You're going to get stock. And he lied. Not just once, he lied for years and dozens and dozens and dozens of broadcasts of videos.
Video played.
Mr. Finkel said, I can guarantee you will never lose money. I bear legal responsibility. Dear brothers and sisters, if anyone loses money, come to me, come to me. I will be responsible. Let me repeat again. As long as you lose a penny, I will be responsible. Guo's words himself on tape, recorded. That, in a nutshell, are the lies that Guo told to take other people's money. And at its core, as I said, it's all very straightforward. Guo's fraud was based on a simple lie. Simple lies. It was grand at its scale. This closing is the government's opportunity to take you through the evidence that you've seen and heard. And to do that, I'm going to do a few things. First, very briefly, remind you of the charges that Miles Guo is facing. Then I'm going to go through what, in the government's view, cannot seriously be disputed by the parties. Third, I'm going to discuss the schemes, Miles Guo's schemes. The schemes he used to defraud people. And then fourth, I'm going to go through some of the reasons, there are others, but I'm going to go through some of the reasons that Miles Guo is guilty of every charge in the indictment. So as you know, and as you heard from Judge Torres yesterday and today, Miles Guo is charged in 12 counts. The first 4 are conspiracy counts. Charges 5 through 12 are what are called substantive counts. And Judge Torres has explained to you the difference. Guo is guilty of the conspiracy counts because he agreed with at least one other person to commit a certain crime. And he's guilty of the substantive counts because he committed a certain crime. Or he aided and abetted someone else committing that crime. And so here, Guo not only committed crimes, but he agreed to commit crimes. He conspired with Yvette Wang, William J., his son, Miles Sun Guo, Howard He, Max Krasner, Long Island David, Yongbing Zhang and others, to build a criminal enterprise, a racketeering enterprise. A group of people who were associated together for the common purpose of taking other people's money through fraud. And they engaged in a pattern of criminal activity, of wire fraud, of securities fraud, of bank fraud, of money laundering, and of unlawful monetary transactions, using fraud money to buy things. These are the conspiracy charges, as Judge Torres has explained, and Miles Guo is guilty of all of them. And these are the substantive charges, which are based on the various schemes, some of the various schemes that Miles Guo committed. The GTV private placement, the farm loan program, G-Clubs, the Himalaya exchange. Count 12 is a charge for engaging in an unlawful monetary transaction, specifically the $100 million of victim money that Miles Guo and his co-conspirators sent to Heyman Capital to invest in hedge funds. Now, with all the evidence in, step back and think about it. There's a good amount here that cannot seriously be disputed. So I want to start there. With what cannot seriously be disputed. First, it cannot seriously be disputed that Miles Guo made dozens and dozens, actually hundreds, of broadcasts and videos about various businesses and investment opportunities. You have seen many of them. Victims have told you about them. You have seen Shamal Medrano's summary chart, which is GXZ9. A 200-page chart of just excerpts of what was said. And all the videos that chart summarizes are in evidence, and you can review them. There is no serious dispute that Guo made these videos, that Guo said these things, that they were broadcast from Guo's YouTube page, from his media outlets, his own media outlets, G News, GTV, from Getter, his social media platform. Guo's statements themselves, the statements alone, GXZ9 itself, is damning evidence of Miles Guo's guilt. By the way, if I mention an exhibit or you see an exhibit marked in this closing deck that you want to take another look at later while you're in the jury room, feel free to just jot it down. You're going to have access to every exhibit and every witness testimony you wish to review, but you won't have access to the parties' closings. So if I mention something that you want to take a closer look at, feel free to make a note of it. Second, it should not be seriously disputed that these investment opportunities raised hundreds of millions of dollars. You're looking at a piece of a bank summary chart which summarizes thousands of pages of bank records. Now, I'm sure the parties dispute what this means. But you know what it means. It means the videos, the broadcasts. Miles Guo's broadcasts worked. His legion of statements mattered to people as they forked over their money to participate in his investment opportunities. Next, it cannot seriously be disputed that Miles Guo worked with others to carry out his businesses, to carry out his investment opportunities. You've heard from several witnesses that Miles Guo ordered his staff and others to carry out his vision. And key to that were two people in particular, Yvette Wang and William J. Ms. Wang was the head of operations. She ran the day-to-day of each business. William J., described as the finance guy. He kept track of Miles Guo's money and helped launder it. But there were others. There were others too involved in Guo's investment schemes. Names you've heard and individuals whose actions you have learned about. Now, these co-conspirators also worked for Guo. They carried out his vision. They helped him spend his followers' money. They helped him launder it. They helped him try to cover it up. There's Howard He. He's the paper ultimate beneficial owner of G Clubs, Miles Guo's son's best friend. There's Miles Guo himself, who you heard on the recordings that Haitham Khalid made, talking about moving fraud proceeds abroad. There's brother Long Island David, who you've heard a lot about, who was named by Miles Guo to be the head or the Secretary General or something like that, of the Himalaya Farm Alliance, who lied to people too. There's Yongbing Zhang, the criminal, emphasis on criminal, defense attorney or, immigration attorney, who asked Yuli to sign a false affidavit, who was gifted a Lamborghini by G Clubs. And then there's Max Krasner, the man who cut the checks and papered the many items that Guo purchased for himself and his family, who worked in the New York office alongside Yvette Wang and Miles Guo. That's the conspiracy. Fourth, there cannot and should not be any serious dispute that actions were taken in this conspiracy with respect to these crimes, and that wires traveled into and out of Manhattan. As you heard from Judge Torres, one of the things you'll need to consider is venue, which is whether any actions were taken in the Southern District of New York, which includes Manhattan. There should be no serious dispute about this. The offices that ran the various Guo businesses were in Manhattan. You may remember Limari Reyes described them as being on the right side of Central Park and the left side of Central Park, the east side and the west side, the townhouse on the left side of your screen, and 3 Columbus Circle on the right side of your screen. And, of course, right in the center is the Sherry Netherland Hotel, where, as you can see from this photo alone, Miles Guo made broadcasts that traveled throughout the country and throughout the world to further his enterprise. There should be no dispute about interstate commerce either. Obviously, as money is moving back and forth, that has at least a minimal effect on interstate commerce. And, in fact, It was stipulated that there were victims in the Southern District of New York, that's GX Stip 19, individuals who received money back from the SEC as a result of the private placement fraud. It also should not be in dispute that a red Lamborghini was found in the garage of Miles Guo's estate in Connecticut. Now, it should also not be disputed that the VIN number on that Lamborghini matched exactly the VIN number on a document that G Clubs had. Now, I suspect there is a dispute about what this means. Here's what it means. This Lamborghini in Miles Guo's garage is itself devastating evidence of his guilt. It shows he made statements about G Clubs. Money came in, and it was spent on a Lamborghini that ended up in his garage. And the keys were in his house. You held them. Frankly, the Lamborghini is enough itself to find Miles Guo guilty on all the conspiracy counts and counts 7 and 8. The G Club counts. Another thing that is not in dispute is that the CCP targeted Miles Guo. The government stipulated to it. My name, our names, our boss's name, are on this stipulation in the signature block. That means the government agreed the CCP posted things online about Miles Guo. They tried to extradite him. Didn't work. Parties also agree that the FBI charged the people who targeted Miles Guo. The FBI charged them with violating U.S. law. That's what the FBI does. The CCP targeting Miles Guo might be why Miles Guo has so many cell phones. I don't know. I don't care how many cell phones Miles Guo has, and neither should you. What you should care about: what was on those cell phones. And we'll talk more about that later. This is a fraud case. And so the CCP targeting. Why does it matter? Does it matter? Well, let's take a look at what Guo's targeting expert, his fox hunt expert witness, said about this very issue. The business opportunities that Miles Guo promoted have nothing to do with why you were hired here to testify today. Correct? Answer from the expert. I was hired to testify as an expert in the Chinese intelligence and police agencies. And Operation Fox Hunt, which is to say targeting for Miles Guo. Question: that has nothing to do with the business opportunities that Miles Guo promoted, correct? Answer: correct. That's what Guo's well-paid expert believes. Paul Doran also testified that he was targeted by the CCP. But he knew. Of course, that didn't give him a license, it's what he said, to commit fraud. There's no justification defense in this trial. There's no duress defense in this trial. None. So is Miles Guo targeted by the CCP? Yes. Does that excuse what he did? No. And what does it mean for the questions that you as a jury have to consider? Very little. This is Minran Wu's testimony. Question: if it were true that Miles Guo was targeted by the CCP, does that change your view of the investment projects? No. Does it change your view of the movement? No. Why doesn't it change your view? This movement is just a scam. I don't think it's related anything to the CCP. Also, if somebody is anti-CCP, it doesn't mean this guy could scam somebody else. That's different things. You cannot use this anti-CCP to do something illegal. So that is what cannot seriously be disputed. Now we're going to turn to Miles Guo's schemes. Guo's enterprise carried out several schemes. Each scheme, by the way, is a RICO predicate act. And there are more than just these 6, but these are the 6 we're going to talk about. Each scheme was designed to take other people's money, the money of his followers. The men and women around the world who believed Miles Guo, who believed in Miles Guo. Now, those schemes were principally the Rule of Law Society and Foundation Scheme, the GTV private placement, the Farm Loan Program, G Clubs, the Himalaya Exchange, and A10. As I mentioned, there were others too: G Dollar, G Coin, G Bank, a second GTV private placement. We're going to focus on these 6. Because at their core, these 6 are really kind of all the same. Miles Guo first would tell lies in broadcasts to get his followers to send him money. Second, those lies mattered. They were important to his followers in deciding whether or not to invest, whether or not to send Miles Guo and his company's money. Third, money poured in, tens of millions, hundreds of millions, $1 billion. Fourth, the money was washed. It was laundered by William J. and others through Hamilton. You heard the recording, ACA. Or otherwise cleansed through these businesses that were designed to look legitimate. To try to trick U.S. law enforcement, to try to trick you. And fifth, after the money was cleaned, Miles Guo used the money for himself, for his family. Through it all, Guo, the boss, the principal, was in control. He was in control of the companies that bear his name and of the companies that do not. When he wanted to hide certain things, so he named a company called Medical Supply or ACA Capital even. So at its core, it's so very simple. In some ways it's kind of just one long big scheme that kept evolving and changing. When the SEC caught on, they adapted their methods. When assets were seized, Guo made another change. But it's the same foundational principle. Miles Guo lied to take other people's money. Let's go through these schemes briefly. First, there's a rule of law society and rule of law foundation scheme. In this scheme, Miles Guo said that he would donate his own money and, by so doing, encourage people to donate theirs. Money came pouring in, and he spent it on himself and to promote himself. The GTV private placement. Miles Guo said he's going to create this media company. Invest. Buy shares. Money came pouring in. He cleansed it through Soraka and invested it in a high-risk hedge fund in the name of his son that lost $30 million. Then came the Farm Loan Program, which was operated through the Himalaya Farm Alliance, which Miles Guo created, which Miles Guo names who is in charge of each farm. He offered so-called loans that he said would be used to be working capital for the farms. And in exchange, people would get stock. No one got stock. No one got interest payments. But Miles Guo and his family took the money. Then, there was G Clubs, another stock-related scheme. This time you buy a membership. You get GTD stock or G Fashion stock or G Club stock, or you buy the stock, and you get the membership. He did it both ways. Money poured in. It was cleaned. Miles Guo spent it on himself and his family, including putting that Lamborghini in his garage. The Himalaya Exchange, a cryptocurrency-related scheme. These cryptos are going to make you rich. You're not going to absorb any losses, he would say. They are backed by gold. They are safe. They are valuable. In truth, not only weren't they backed by gold, but after a certain point, they weren't backed by anything. They weren't on the blockchain, and the price was manipulated. And what happened to that money? A lot of it was seized by the U.S. government. But before it was, when he needed $37 million to get out of a jam with a court in New York State, he got it, like a bank account. Then there's A10, which is just A10 is pure snake oil. This was a business opportunity that emerged shortly after the U.S. government seized, as I just mentioned, hundreds of millions of dollars. And Guo promised through the A10 a stake, 5% getter. 5% in the Himalaya Exchange, you're going to get these stocks. Didn't make any sense, but money came in. Those are Guo's schemes at a high level, each of which was integral to Guo's fraud. Each of which he promoted in his broadcasts, and from each of which, he and his family benefited. Now I'm going to discuss some of the reasons that Miles Guo is guilty of every crime with which he is charged. I'm going to go through 7 reasons. There are way more than 7. We only have so much time. So I'm going to go through 7. Here's the first reason. The first reason you know that Miles Guo is guilty is he lied to his followers about these investment opportunities. Miles Guo told these lies, not the Politburo, no one else. He himself told these lies, this man in the courtroom. Now, there are a lot of lies that he told. But they mostly fit comfortably under an umbrella of 2 lies in particular. First, he guaranteed that his followers would not lose money, and he said his followers would make money. And he said these things over and over and over and over and over again. His former close associate, who testified here, Yili, was known as Milan, summed it up for you well in her testimony. She was asked, what promises, if any, did Miles Guo make about the investments? Her answer, and she watched hours upon hours of his videos. Her answer, he guaranteed all investment will be no loss. If there's a loss, he will repay us all the loss. Here's another excerpt from her testimony. Ms. Lee, was this video, the one that she had just watched, the only time Guo made this type of promise? No, many times during this 3 years. How often would he say these things in the 3 years? The promises about investment. How often would Miles Guo make these promises? Always. So those are the big umbrella lies. But there are lies that are specific to each scheme that fit underneath that umbrella. That fit underneath the guarantee and the promise of returns. So let's now start with the lies Miles Guo told about the rule of law. Rule of law launched in November of 2018. About a month after the CCP seized Miles Guo's money. We're going to come back to that. It launched in November 2018 at a big press conference with Steve Bannon. Let's take a look in part at what Steve Bannon said.
Video played.
Mr. Finkel said, now, Steve Bannon wasn't freelancing here. Karen Maestrello, Miles Guo's interpreter, a few weeks ago. But you may recall, she told you that she participated in meetings where Guo and Bannon discussed this very fact that Miles Guo was going to donate his own money to the Rule of Law Foundation and Society. And it's not some accident, by the way, that Steve Bannon was involved at all. Miles Guo used Steve Bannon. He was hired for $1 million so that Guo could use Bannon's notoriety and his fame to promote himself. Rule of law is where all this sort of started. Guo paid Bannon $1 million. That's what you're looking at now. His contract through Soraka. Soraka Media Group, which really, as you will see as we continue today, is Miles Guo's slush fund. Now, there's no way Miles Guo paid this guy $1 million and let Bannon freelance about what to say at the media launch. But that's okay anyway, because Miles Guo himself made the same false promise. This is Miles Guo's words. Government Exhibit 6-191 translated in 192T. Guo Wengui's $100 million will be donated to the Rule of Law Fund. I bear legal responsibility for what I said today. In other words, for every US dollar donated by comrades in arms, $2 come from Wengui. After donating the $100 million US, Wengui is coordinating a donation of $1 billion to the Rule of Law Fund. He tells his followers he bears legal responsibility. He does. He knows he is making a promise that matters to them. But it was a lie. You may remember this document. It's GXWA 30. It was found in Yvette Wang's apartment on March 15, 2023. Yvette, of course, was Miles Guo's right hand, really his right arm, who carried out his orders and kept all the businesses and entities and people running. And this is a summary in Yvette Wang's records of all donations the Rule of Law Foundation and Society. And what does it say? The total, both entities, $36 million. Not even close to $100 million. And that document, by the way, is consistent with what Karen Maestrello, who was the president and treasurer of Rule of Law Society, told you. Did Mr. Guo ultimately make $100 million donation? No. So that claim for Miles Guo that he donate $100 million and $1 billion was a lie was nonsense. But there's more that Miles Guo lied about. Guo and Bannon in that press conference. They pitched the rule of law as a way to help people who were oppressed by the CCP as a charity. And Guo would talk about that mission, how to further it, through the rule of law time and time again. What did the Rule of Law Society and Rule of Law Foundation actually do? You said the purpose was to help people in China, Ms. Maestrello was asked. What, if anything, did Rule of Law do to help people in China? While I was there, nothing. It's actually worse than that. Because boss, Miles Guo, did less than nothing. He took Rule of Law Foundation and Society money, donor money, victim money, and he spent it on himself and his family. Guo used Rule of Law money to send a shipment of N95 masks in March of 2020. On the onslaught of the COVID pandemic, when no one could get an N95 mask anywhere, not even in hospitals. Not in Home Depot, there were none. And Guo used donor money to send a shipment of those masks to his estate in Connecticut. But there's more. Guo did use some donor money to send some masks to the NYPD. Karen Maestrello testified about that too. You may recall what happened next. Guo demanded personal credit for doing so. And Maestrello was asked to write a letter, saying that those masks were a gift from Miles Kwok. Even though that wasn't true, because they were a gift from donors. Maestrello refused. Because it was not a direct gift from him, she said. It was donor money. Rule of Law money. What did Yvette say to her? What did Yvette Wong say to Maestrello as Yvette was carrying out Miles Guo's orders? She told me, Maestrello said, that I was being paid to execute orders and not to think. You didn't know it at the time. At the time that Maestrello testified about that. But that was a prelude of things to come. That's, in part, how the RICO conspiracy worked, how Guo's enterprise worked. Recruit people who don't ask questions. Recruit people who follow orders, who understand the company line and carry it out. People like Jesse Brown, president of the Himalaya Exchange. People like Limari Reyes, the CEO of G Clubs. We'll come back to that later. So one of the reasons that Miles Guo is guilty is he lied in the Rule of Law scheme. He lied about donating his own money. He lied about how donor money would be used. He lied about how the money would be spent, because he spent it on himself and his family. And he used it to promote himself. Now let's talk about the lies Miles Guo told to take people's money in the GTD private placement scheme. Reeling from the success of Rule of Law, this is when the scheme and the enterprise became turbocharged. On April 20, 2020, Miles Guo announced the private placement. He told his followers, "We are friends." And he explained that GTV would be a social media platform with functions such as one-to-one chat and group voice messages like WeChat in China. He explained he wanted to create a media company that would break through the Chinese firewall and bring democracy and freedom to the Chinese people. And he told his followers to read the private placement memorandum. This document says at the top, "Everything is just the beginning." And inside that document, it emphasized that the purpose of this private placement, the purpose of this company, is to create a platform independent of the Chinese government censorship, to create a unique and the only news-focused social media platform revealing the truth about China, to be a bridge between China and the Western world for open communication, business transactions, and trading. and was specific about how the money raised in the private placement would be used. It would be used, it says, on the right side of your screen, to expand and strengthen the GTV business. Nowhere does it say in here that the money could be used for a high-risk hedge fund bet. That wasn't included on purpose. But beyond the private placement and beyond the news conference, Guo also made representations to individual investors, the old chairs, as they were known. Wei-Chin was one. She testified about it. She told you how she texted her and her husband exchanged messages with Miles Guo. And she told you her understanding of what Miles Guo had told her, that she was promised only returns, huge returns. Zero risk. Question: that's what Miles Guo said? That's exactly right. Then on June 2nd, 2020, the private placement closed. Guo explains in that video, in that broadcast, that this is that he had a separate conversation with each investor. That this is a serious and solemn commitment and responsibility of Guo to you to be responsible for this investment forever. Forever. It's a legally valid commitment, he says, an attitude. It's June 2nd, 2020. Do you know what he doesn't say in that video? He doesn't mention, because he doesn't want the victims, his fellow fighters, his friends, as he called them, to know the truth. That at that point, he was committed to spending $100 million of their money on a high-risk hedge fund bet with Heyman Capital. The GTV private placement closed on June 2nd. The next day, Guo moves $100 million of investor money to another bank account. From the Chase 5601 account to the Chase 2038 account. And from there, $100 million flows into Heyman Hong Kong Opportunities Fund, the hedge fund in Dallas, Texas, run by Kyle Bass. And you heard from Steele Schottenheimer, the managing director of investor relations at Heyman. She explained to you that this Hong Kong Opportunities Fund has nothing to do with the media company at all. Nothing. It's a bet against the Hong Kong dollar. She explained it as a bet when the band breaks on the weak side. The band breaks on the weak side, it could pay off. This was not a bet in the S&P 500, not that that would make it okay, it wouldn't. This was not a bet or an investment in Coca-Cola, again, not that that would make it okay, it wouldn't. This was a hedge, a high-risk investment for qualified investors. It was a high-risk gamble on the Hong Kong dollar price. Just to be clear, that 5,601 account is investor money. It doesn't take a lot to figure that out. Just looking at the bank record shows the wire transactions into that account list in the wire's GTV investment. Attention to Mr. Miles Guo, for GTV stock, $291.5 million, over 2,400 deposits. Floated into that account in 1 month, in May of 2020, made references to GTV, stock, investment, private placement, capital, and so on. This is Steele Schottenheimer's testimony. She explains what you know. That the Hong Kong Opportunities Fund is a very high-risk, potential high-return strategy. She explained how it's designed to hedge people's risks, qualified investors' risks. And that investment, by the way, is something that Miles Guo had contemplated for a long time. You saw this video. This is W1007V1. It's an interview that Miles Guo did in English with Kyle Bass, where they talked about the Hong Kong dollar peg. When it could break, when it could not. Moreover, during the private placement, while victim money was coming in. As you just saw, Guo's moneyman, William J. requested and received the deal materials from Heyman Capital. This is May 23, 2020. This is when we know by at least this time that Miles Guo had decided to make the investment. And remember, after that, June 2nd, he talks about his solemn commitment. 3 days later, this is a text from Kyle Bass to Steele Schottenheimer. It was made clear to Schottenheimer that Miles and William were investing through two entities, Soraka Media Group and Hamilton Investment Management. Soraka Media Group being a Miles Guo entity, the entity he was using to funnel fraud proceeds to Heyman Capital. So GTD private placement closes. The money goes into the Heyman Hong Kong Opportunities Fund, but then they hit a snag. The Securities and Exchange Commission, the SEC, an American securities regulator, contacted Heyman. That was on July 13, 2020. Steele Schottenheimer told you about that. She said that Heyman received a call from their lawyer that they had received a letter from the SEC requesting documentation regarding Soraka's investment in the Heyman Hong Kong Opportunities Fund. So in response, Heyman's lawyers sent a letter to Soraka, Guo's family entity. And they asked some questions. What was the source of capital used by Soraka Media Group to invest in the fund? Was any of the money raised in GTD's primary offering of shares used to fund Soraka's investment in the fund? If the proceeds were derived from a securities offering, did the offering documents disclose the use of proceeds to include an investment in the fund or in any similar private fund vehicle? If yes, please provide a copy of the disclosure document. What, if any, response did Heyman receive after dispatching that letter? No formal response to that letter. No response. Soraka did not send the private placement memorandum and point to the document that says, "This is how we could use the proceeds." They did not send the private placement memorandum and point to the part in the document that says, "Management has broad discretion in how to use the net proceeds of the sale of common stock." They didn't send the private placement memorandum at all. Why? Why did Soraka not send the private placement memorandum to Heyman? Because the private placement memorandum does not allow them to use the money raised for a media company to invest in a high-risk hedge fund in the Hong Kong dollar. If they thought it did, if they truly believe that the private placement memorandum means we can do whatever we want with the money, they would have told Heyman that.
Continued on next page.
Mr. Finkel said, they didn't cause Miles Guo knew. Yvette Wong knew. William J. knew, and you know. The money was sent for the GTD company, not for high-risk debt in the name of Miles Guo's son. By the way, this is proof that Soraka got the letter that Heyman's lawyer sent. Because this document, the letter we just looked at, this is from the SEC. If you recall, there was a witness who testified from the SEC that the SEC sent a subpoena to Soraka. And in response to that subpoena to Soraka, Soraka produced the same letter from Heyman's lawyers. So it's clear that Soraka got the letter and never responded to it. Then in August of 2022, Kyle Bass himself sent an email to William J. And in part that email said, in order to allow Soraka to remain invested in the fund, the Hong Kong Opportunities Fund, the high-risk hedge fund bet, Heyman needs to receive a representation from you and from Soraka's lawyers regarding the specific source of the money. The $100 million, beyond what was initially provided in the subscription documents. And the representation must include that this money is not tainted in any way, including that it does not represent assets from the GTD offering, but that it's a bona fide investment made by Soraka and Miles Guo. Did Kyle Bass get a response? No. Did Soraka ever provide a representation from itself or from its lawyers regarding the specific source of money? No. Was there any representation made that the money was not from assets from a GTD offering according to Steele Schottenheimer? No. Was there any representation made by Soraka or its counsel that the $100 million investment in the Hong Kong Opportunities Fund Prodigious Series was a bona fide investment made by Soraka Miles Kwok? No. This is evidence of intent, of Miles Guo's intent. By the way, what happened to that $100 million? That $100 million of investor money, of follower money, of victim money, money from the fellow fighters? Well, $70 million of it was sent to the SEC. But $29.6 million, $29 million was lost in the investment. Gone as part of that investment. Soraka made a $100 million investment. What happened to that $100 million? Steele Schottenheimer told you. 70 of it was segregated and moved to a feeder fund. How much was lost? $29.6 million. Did Miles Guo live up to his promise that he made on video that you just saw? His promise to protect his followers' investment in GTV? No, he did not. How do we know that? Wasn't already obvious? There's a stipulation in this case that Soraka, GTV and VOG made a settlement with the SEC, and as part of that settlement, they agreed to pay back the money that was part of the GTV private placement. And as of the date of this stipulation, which was June 21st of this year, Soraka and GTV owe almost $31.5 million more. So Miles Guo has not made good on his promise. And why? Because he was lying when he made that promise. And why did he lie? To try and to in fact take his victims' money. Just to be clear, his promise extended to the voice of Guo investors too. You may recall the GTV private placement had the old chairs. The people who invested directly with Soraka like Wei Chen. And then there was the VOG investment. The voice of Guo investment, which was the pooling when people who couldn't afford $100,000 pooled their money through voice of Guo, which was in effect a farm. Miles Guo promised to guarantee their money too. I will be responsible. If there is one of your pennies that's missing, a penny, Guo Wengui will be responsible. So these are the GTV lies. Guo lied about what GTV investment money was going to be used for. He lied about guaranteeing any loss. And in fact, he just spent investor money on himself and his family. Now let's turn to the farm loan program. Recall that the farm loan program began shortly after the SEC started asking questions about Soraka and its investment in Heyman. Rather than sell securities explicitly, that is, sell stocks of GTV explicitly, Guo said he'd sell loans. Loans that brought with them the promise, his promise, of stock ownership or interest payments. And as you will see, and as you well know, and as Guo well knew, those promises were lies.
Media played.
Mr. Finkel said, Miles Guo's words. By the way, those sunglasses he's wearing in that video, those are the same sunglasses Yuli brought to this courtroom that Miles Guo had sent her, as a sign of his appreciation for what she had done, for what she now knows she told you was a giant scam. Victim testimony that you heard is consistent with that video. This is Minran Wu. What was the farm loan program? We members lend money to the farm to get GTD stock. Why did you understand that lending money to the farm would get you GTD stock? He said so. Who are you talking about? Miles Guo. Here's some more from Minran Wu. What, if anything, did Miles Guo say about why you had to use loans instead of just investing in GTV? He said for the GTV private placement already finished, already ended. So he created another chance for us to invest in this GTV stock. He called this step to equity. Here's some more statements that Miles Guo made that were not true about the farm loan program. I'll give you the money. I'll be responsible for everything, okay? People should never, ever worry about this. He goes on. This is the United States of America. You are legally responsible for what you say in the video. I am legally responsible. His words on a boat. Here's some more. Just with the investment of GTD, we managed to raise more than $400 million so far. We haven't spent a penny of that. That was on February 28, 2021, after ye had sent the money already to Haman. The farm will give you clear notice that all the money you lent them is inconvertible bonds. I call you to specify, and you will go to the account I specify. If any of you lose money, I will take full responsibility. In my live streaming today, I say anyone, as long as you follow Reviewing News Alliance. As long as your money was deceived and stolen, what I said was based on the original rule. For those involved in what GTD Phoenix Farms or farms like this, I am fully responsible. Miles was words. So, victims got contracts. This is Minran Wu's contract. And the contracts say that the loans proceed under this agreement are for the general working capital purposes of the farm. The loan agreements do not say what was true, which is that Miles Guo was going to use the money for his personal expenses, for his family. It also does not say that they will get stock by the way. And he did that because this was designed to obscure the fact from the SEC that he was promising his followers stock. Ms. Wu explained that to you. The use of proceeds does not mention GTD stock, right? Yes. What, if anything? Were you told about why that was? They said they couldn't write clearly about that in this contract just because of the CCP, because CCP always eyeing this group. They couldn't do that. And who told you that? Miles was said this, and Brother Long Island said this. Xia Qidong said this. CCP being a replacement for the SEC. That's what this was about, hiding it from the SEC. Ms. Lee, were the farm program contracts real loans? No. They were for GTD shares. Where did that money go? Where was it sent? The farm loan money? Yeli told you. It was sent to ACA Capital's bank account in Abu Dhabi. William J.'s bank account. And that money from William J.'s bank account in Abu Dhabi from the farms to ACA Capital laundered, and then sent on to Lamp Capital. What happened with it in Lamp Capita? It was used for Miles Guo's family, for his son Chang Guo, for his daughter Mei Guo, for car-related expenses, for airplane expenses. That's not working capital for the farms. They never got stock either. No surprise there. Did you ever receive stock for your loan? No. Did you ever receive interest payments for your loan? No. What, if anything, Ms. Wu? Did Miles Guo say in his broadcast about using the money from the farm loan program investor money for himself? What did he say? He said nobody can touch our money. Even a penny safe, all safe. All safe. Did they receive interest payments? This is Ye Li's testimony. No. To your knowledge, did farm members ever receive interest payments? No. Did you receive stock, Ms. Li? No. To your knowledge, did farm members ever receive stock? No. Well, there was one instance actually. Ye Li told you about this, where interest payments were made, just one. And that is to Long Island David's farm. The New York farm, the Mountain of Spices farm. And why were those interest payments made? To trick the SEC. Question: what's your understanding of why Mountain of Spices receive interest payments? Answer: because that time SEC start investigation Mountain Spice Farm, because they want to show the SEC. This is a real loan, not for GTD shares. So what were Miles Guo's lies about the farm loan program? He lied to his followers that they would get stock for the interest payments. He lied that he would guarantee their investment. He lied about how the loan money, victim money, was going to be used. And Guo spent his followers' money, his victim money, on himself and his family. Let's turn to G Club. Guo lied about G Clubs too. In fact, Let's watch another video of Miles Guo committing a crime.
Media played.
Mr. Finkel said, and that video is a crime because Miles Guo is lying to try to get other people's money. And he broadcast those lies over wires. This is a video. Like so many of the other videos you have seen throughout this trial of Miles Guo committing wire fraud. And because it's about stock, it's securities fraud too. Let's read some more statements of what Miles Guo said about G Club. It is not a membership club, Miles Guo says. G Club is for you to get the original stocks. The comrades who have not invested in GTD original stocks this time to be given a channel so you can get legal G Club. G Fashion stocks. That's it. Simple. So then on October 13th, 2022, Guo does the official launch of G Clubs. And in this launch, he says he's being economically me too. His words. He says, today is the launch of G Club and G Fashion and some statements that have to be made, he says, before the launch. He explains that there's a Me Too in the economic field of the U.S., not the CCP by the way, the U.S. And you can accidentally become economically Me Too'd. That's how Guo described it. What do you mean by economically Me Too'd? RGTV, take a look at RGTV and you will see. He continues. Because he's being economically Me Too'd, I have to say that you will not receive GTD stock. You will not receive loans to purchase membership. This is serious business. There will not be stock. There will not be loans. No. 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 But then, he says the quiet part out loud in the same video. To put it bluntly, this is all nonsense. I'll be straightforward with you. This is what we need to have to legally avoid Me Too. There is no other way. We'd have to do that. And he says what is obvious and plain, what is clear. I don't think you'd buy a GTV membership for something like free music. If you were, why would you buy it? My suggestion would be don't buy it, but the procedures laws, measures that prevent me to have to be there to prevent economic Me Too, all of which are published on the websites. So he goes out there, he says no stock, no loans, just membership. And then he says it's all nonsense, which is to say Guo knows. He knew. He knew it was wrong. He knew it wasn't lawful to say that members in G Club would get stock. He also knows because he told his followers that. You saw him say that G Clubs is not about the benefits. The 3 hotels you get a discount in Puerto Rico. The hour or hour and a half at FAO Schwartz. The one-night dinner discount at a restaurant in London. The coffee mug and cookies for $50,000, for $10,000. Those are a farce. Those are designed to make G Club look legitimate, while Miles Guo goes online in his broadcast and tells people, send the money, get stock. You know how else you know that Miles Guo knew when he was saying these things that it was wrong first of all? Your common sense tells you he knew. But another way you know is in February of 2021. He received the Do Not Say Words list. Limari Reyes told you about this document. This document was found by the FBI in Miles Guo's Greenwich estate. And this was a list of words that the lawyers at G Club told Miles Guo he cannot say, words like shares, words like securities, words like loans, words like growth, words like GTV, words like the SEC, DOJ, prosecutors, G-Coin, G-Dollar, H-Coin, H-Dollar. They told him not to talk about his schemes. He knew better. Of course he knew better. He did it anyway. February 2021, this is June 2021. All G Club card holders are entitled to 1 to 10 of the new GTD stock for the amount of the card. Please cherish each and every share of your GTD. You have to remember this, I'm just begging you. Take your membership, take your shares. Don't lose a single share. Oh my! This is big money. Think about the value of GTV. He said that after the Me Too video, after the Do Not Say list. Because of course he knew. Of course he knew. July 5th, 2021, G Club is definitely we have a solution. Which is legally approved. We have all the investors in G Clubs, all investors now who are currently set at $50,000. When paying $50,000 for the membership card, you will have 10,000 shares of G Fashion in the future. It's like giving them 10,000 shares for free. Here's another video, July 30th, 2021. He references Brother Long Island. Meaning he's referencing the farms, because the farms were integral to all of this. The farms help promote the G enterprise, the schemes, the fraud. Brother Long Island and Kai told me that some of the fellow fighters, the victims, his followers asked, "Will I still get a free stock offer when I buy a G Club membership?" 100%. Anyone can choose whether to use your money to buy G Club before September 17th, G Club and the stock shares. You'll get both. The video he made in a Rolls Royce to try to show his followers how rich he is. How his guarantees mean something, how he could be trusted. That's part of the con. That's part of the fraud. That's part of what Miles Wood decided to do. That's why, by the way, G Club offered multiple memberships. This is an email from Yvette Wong, Miles Wood's Chief of Staff Operations. She sent it to Limari Reyes and Jessica Mastro Giovanni at G Club from her Office Work 2020 at Proton Mail account to set up multiple memberships. Now, you also learned what multiple members get. You get one membership. You learned about this. This is the discount at the hotels in Puerto Rico, the dinner in London. There was a couple of weeks of a hotel in New Zealand. What do multiple members get that single members don't? They get additional entries to the G Talk sweepstakes. That's it. Did you know why that's the only difference? Because multiple memberships were not about providing additional benefits, it was a way to conceal we're buying. Or thought they were trying to buy additional stock. And what do we know about that sweepstakes and G Talks? It was fixed. Miles Guo's immigration attorney, who carried out his criminal acts, got a Lamborghini. That's not a coincidence in the G Talk sweepstakes. Miles Guo also explained to get stocks through G Club you have to send money to Crane, which collected the fraud proceeds, Haitham Khalid's entity that Yvette asked him to set up. Here's another pitch from Miles Guo, August 2021. Do you think Brother 7 is fooling you? Think about that for a moment. Do you think Brother 7 is fooling you? For fellow fighters like them. They're not just fellow fighters anymore. In my heart, he says. In my heart, they are the highest member of our G Club. That's why if you have bought the G Club membership card, you would have stocks now. Why would you lose money? What risks are you taking? Is there such a good opportunity in the world? Will there be such a good opportunity again? Will you have such a good opportunity again? And this too is promise of stock, just like so many of his other promises. Lies. Limari Reyes, the CEO of G Clubs. Question, Ms. Reyes, did G Clubs provide its members stock in G Clubs? No, it did not. Did G Clubs provide its members stock in G Fashion? No. Did G Clubs provide its members stock in any company? No. Was G Clubs an investment club? No. But his followers believed him. Mr. Zhou, did you receive any stock shares in exchange for your G Clubs membership payment? No. Jenny Lee, did you receive any benefits for G Clubs? Nothing. Wei Chen, she thought she was buying shares and getting a G Clubs membership for free. Did you ever get additional GTV shares for the 110,000 you sent to ACHK and the approximately 100,000 you sent to Crane? No, I don't think so. Miran Wu, why would you think you would get GTD stock by sending money to G clubs? Miles Guo said. Where did Miles Guo say that? In his video, maybe several videos. Did you get GTD shares? No. What benefits, if any, did you get from your G Club's membership? I didn't get anything. So GTD2 was a scam. You know Miles was guilty because he lied about G Clubs. He lied about getting GTD stock. He lied about getting G Fashion stock. He lied about getting G Club stock. And he lied about the benefits. The benefits were for show so the fraud money could roll in, and so they could have some claimed excuse. Now let's turn to Miles Guo's lies about the Himalaya exchange and Himalaya coin and Himalaya dollar. And I should note that the Himalaya exchange was sort of part of a longer con that began as G dollars and G coins, and evolved into this fake cryptocurrency. Now Miles Guo's statements about H coin, H dollar, and the Himalaya exchange were varied and plentiful. There was the gold lie. There was the cryptocurrency lie. There was a lie that they were tradable on a blockchain. There was a lie that the money was guaranteed. There was a lie about price. There was a lot of lies about the Himalaya exchange. We're going to look at some of them. June 23, 2021. I want to help my fellow fighters make money. There's H dollars backing H coins, and H dollars is backed by Himalaya Reserve as well as gold. October 20, 2021, Miles Guo says. He designed it. Brother 7 designed it at the time. It has the first one. It has the attribute of currency. Why? It has 20% gold. Awesome. No matter how much it raises, 20% will turn into gold. How to exchange it? It is the issuer of H coin. If the H coin is worthless, he can sell all 20% of the gold, exchange it to you, and become your money, or take all of the value of 20% gold and ask everyone to unify it and make it yours. He calls it a generation of cryptocurrency. Tell me who does business and dare say that you will not lose money. I can. It's all on Brother 7, Miles Guo. It's all on Brother 7 if we lose money. April 27, 2021. Let's see the sensational effect of H coin when it is listed. It is the only Chinese cryptocurrency that makes Westerners believe that is a cryptocurrency without communist and absolutely safe and law-abiding currency. May 5, 2021. He calls it a cryptocurrency several times. He goes on to say, I will be responsible if you lose it. I have H coin. US dollar gold. It is impossible to be used as a tool for money laundering crime. The pricing power of H coin is not in anyone's hands. He's talking about the price. He's saying it's not centrally controlled, and he calls it a cryptocurrency again. And William J. was broadcast on G News through the G Translators Farm talking about what a cryptocurrency actually is. Let's hear what Miles Guo's finance man has to say.
Media played.
Mr. Finkel said, so William J. defines cryptocurrency as it actually is defined. It's a distributed ledger. A public ledger called a blockchain. Miles Guo talks about it too. Any actions performed in the blockchain will be known to the whole world, meaning public. Cryptocurrency is based on blockchain have an important function, absolute fairness. Talks again about how he designed it, and no matter how much it raises, 20% will turn into gold. And he makes a video H coin to the moon. You've seen it a few times, which literally has gold in the video. And the Lamborghini that was found in Miles Guo's garage. Another comment about how it's on the blockchain. Now, was H coin, was H dollar actually traded on the blockchain? No. Was it backed by gold? No. This is Jesse Brown, the CEO of the Himalaya Exchange. Was it true, Mr. Brown? that 20% of the value of H coin was anchored to gold? No, it wasn't. How much of the value of H coin was anchored to gold? None to my knowledge. How much of the Himalaya dollar reserve was in gold? 0. This is Guo's expert cryptocurrency witness, Ms. Sklar. Ms. Sklar, in all of the documents you reviewed from the exchange, all of the documents reviewed from third-party contractors, and the time you spent on Etherscan, you didn't see any evidence that H coin was backed by gold, did you? That is backed by gold. No. I didn't see anything. This is Sam Roberts' testimony. You may recall he worked at BitGo cryptocurrency services provider. They ultimately closed the account with the Himalaya exchange because of the number of red flags that the Himalaya exchange had. He did his own review. Did he find gold? No. During this account review, Mr. Roberts, what, if anything, did you learn about whether Himalaya dollar or Himalaya coin was backed by gold? Do you not recall making a finding about gold backing either of these cryptocurrencies? In fact, not only was there no gold, but after September and October of 2022, when the U.S. government seized money from G Clubs and G Fashion and the Himalaya exchange, there wasn't even backed by money. This is Bo Collins' testimony. He talks about when the U.S. government seized money that was going to be used to by his bank, which came from Himalaya exchange, by the way. This is an email that was sent actually from Ms. Murray to G Club attorneys attaching the seizure warrant, which made clear that money from a mercantile held by the name of Himalaya International Clearing, Hamilton Capital, Himalaya International Reserves, Himalaya International Financial Group, the Himalaya exchange entities was seized, but they kept using this document. The Armanino document that said the Himalaya dollar was backed by $401 million in cash. Priya Patel sent it. You remember her? She's the one who pretended that she never heard of GTV. She was the lawyer for William J. and the Himalaya exchange. It's important to keep in mind that's another example of how Miles Guo worked with other people to keep this fraud scheme going. Mr. Roberts from BitGo talked about that document. Mr. Roberts, why did seeing in this document that the exchange gave you that the number of HDO tokens on the blockchain was 0 make you question whether to accord it with your understanding of a stable coin? He had questions about it. I understood the total amount of Himalaya dollar in circulation to be in the range of 1 to 1.5 billion. Seeing this number 0 made me question whether the Himalaya dollar on the blockchain had any value at all. But despite the seizure, September and October of 2022, Miles Guo kept promoting the exchange, H coin and H dollar, talking about how it could redeem, how it could issue, and how it was extremely strict supervision. Even though it had no money behind it, he was trying to get more money to come in. Here's one of his Gitter posts. His social media platform talks about how most cryptocurrencies will disappear, but HCN will continue. It can't be tainted with. It can't be stolen from. It's safe, even though there was no money backing it. Mr. Brown, in your 2.5 years with the Himalaya exchange, when, if ever, could customers buy H coin on a blockchain? Never. When, if ever, could customers buy H dollar on a blockchain? Never. That's part of this lie too. Himalaya coin and Himalaya dollar weren't on a blockchain. They weren't cryptocurrencies at all. They're on a database. Jesse Brown told you about that database, and that it was centrally controlled. Despite what Guo promised, controlled by the exchange and its technology team. And by the way, what Jesse Brown testified to, what he saw as an insider at the Himalaya exchange was consistent with what Sam Roberts saw in his review. He understood that the database meant transactions were occurring on a private ledger not available for public viewing. So it was a closed-loop system, not a public blockchain, like William J.E. described, like Miles Guo described. What they were instead were credits. That's what Maggie Sklar talked about, notations on internal databases. They're not on the blockchain, Ms. Sklar was asked. In my understanding, the credit system was not on the blockchain. Guo's own expert, it's not on the blockchain. And in the fine print buried within this 40-page document, it says that credits can only be used on the Himalaya exchange. And they represent a right to participate in trading. They do not carry any right to require their exchange for fiat currency or crypto assets. A member can make a request to the exchange to exchange credits on their account and receive a transfer of corresponding crypto assets to their external wallet address. Miles Guo never said anything about that. He left that out. And even the price was a lie. They manipulated the price of H coin. Jesse Brown. What was your understanding why stakeholders at the exchange didn't want the coins or the dollar to be listed on another exchange? For fear the price would drop, and they using Hummingbot, a software to make sure that the price wouldn't drop. They were manipulating the price. And again, Jesse Brown's testimony as an insider is consistent with what Sam Roberts saw in his review. He recalled finding that it appeared that H coin had a very large apparent market capitalization based on the number of H coin he understood to be in circulation. In other words, the price didn't make sense. That's the Himalaya exchange lies. Guo lied about it being backed by gold. He lied about it being backed by cash. He lied that he was responsible for the loss. He didn't pay it back after the government seized the money. He lied about them being cryptocurrencies. He lied that HCN and HDO were essentially controlled. They were not. He even lied about the price. Then there's Guo's lies about A10. This scheme, which is utter nonsense, comes in February of 2023, after the government seized the Himalaya exchange money. It's about a month before Miles Guo was arrested. He creates this snazzy graphic. And he makes a broadcast offering shares in both the social media platform and the Himalaya exchange.
Media played.
Mr. Finkel said, different spin on the same theme, lies about stocks, lies about coins. Lies about all these things you get if you send him money for A10. And he connects it to G Club for some reason, saying, if you own G Club without a cent, if I say that, I am not stupid. I am not a fool, and I've invested $1 million. I can get $1 million from G Club, $1 million membership. And then you hold equity owner in both companies without any risk. Then he goes on to explain that it originally was A15, but then he turned it to A10. And that's because A10 didn't involve G Club, because the G Club stock wasn't profitable at present. Which, if that were true or not true, it certainly suggests that Miles Guo knew that the G Club stock he promised to his followers that he said could never lose money. He wasn't paying them back for it. Yuli explained her understanding of A10, and what it was really for is now clear. Ms. Lee, at the time of A10, where would you send money? Send US dollars to buy a G Club card to Abu Dhabi. Why would you send it to Abu Dhabi? Because new G Club company established in Abu Dhabi. Around when was this new G Club company established in Abu Dhabi? Around the end of 2022. And what happened in the end of 2022? The US government seized Miles Guo's fraud proceeds. So he tried to move them offshore. That's what A10 was, collecting more money to go offshore. Weichen, I think, described it well. When he promoted A10, I'm confused, she said when she testified. Why? Because why is another investment? It feels to me that he just keep asking us to give money to invest. Just keep draining out our pocket, is always giving investment, but where is the return? Why keep giving money out? When is the money coming in as a return? Did Ms. Chen invest in the A10? No. Those are lies about A10. Guo lied about getting shares in Getter. He lied about shares in the Himalaya exchange. He lied about these G Club benefits. A different spin on the same theme. So those are the lies Miles Guo told about his various schemes. The rule of law, GTV, farm loan program, G Clubs, the Himalaya exchange, and A10. These are all part of the same conspiracy. And Miles Guo kept going back to the same well, to the same people, his followers, that he knew would believe him. That there was some promise of stock, of ownership that he never meant to provide. And all of those lies that I just went through. They all fit under the umbrella of promising followers would not lose money, of promising followers they'd make money. Make money by owning stock that Guo repeated over and over and over and over again. Our fellow fighters have to be rich. Let's see how Guo does business for you and makes money for you. I want them, the followers, to be rich. I want them to never lower their heads for money. You will make a profit. Who will you share? Who will you share the money with? And he guaranteed them. He guaranteed they wouldn't lose.
Media played.
Mr. Finkel said, that personal guarantee is pretty egregious given that Guo filed for bankruptcy on March 15, 2022. In his bankruptcy filing which he signed, he said he estimated his assets to be worth $50,000 to $100,000, and that he owed between $100 million and $500 million. In other words, he didn't have any money. But did that stop him from promising he would guarantee his investors, his followers, his victims money? Of course not. February 15, 2022 bankruptcy, he still made guarantees. July 15, 2022, this is from the video you just watched. If you lose a penny, I will take responsibility for it. He knew he was bankrupt, or so he claimed. That's the first reason that Guo is guilty, because he lied to his followers about investment opportunities. I know, Your Honor, that you wanted to take a break around now. This would be a good time if it's okay with the court to do that.
The court said, members of the jury will take a 10-minute break at this time. Remember that I have not yet given the case to you, so you're not allowed to discuss the case amongst yourselves. Don't permit others to discuss it in your presence. Don't read, watch, or listen to anything concerning any topic involved in this case.
The law clerk said, jury exiting.
Jury not present.
The court said, we'll come back in 10 minutes.
Recess.
The court said, please get the jurors.
The law clerk said, jury entering.
Jury present.
The court said, please be seated. USA Finkel, you may continue.
Mr. Finkel said, thank you, Your Honor. Okay. Welcome back. So reason number one that Miles Guo is guilty is he lied to his followers about investment opportunities. Reason number two is that those lies mattered. They were, as Judge Torres explained in her instructions, material. And that's something that you're going to have to consider when you deliberate whether the lies were material. That is, whether a reasonable person would have viewed the information, Miles Guo's lies and omissions, as altering the total mix of information available. Material facts includes facts which viewed objectively affect the value of an investment opportunity, of a security, of a promise. Now, the government does not have to prove that investors, victims actually relied on the statements that Miles Guo made. Investor intent, victim intent, is not a concern of yours. What matters for you in your deliberations is whether Miles Guo's false statements, his misrepresentation, his omissions, like saying he wouldn't spend investor money on himself, whether those show that he had intent, whether those matter to a reasonable investor. So did Guo's lies matter? Of course. Were they material? Of course. It's common sense. One way you know that they were material. One way you know that Miles Guo's lies matter is because he kept repeating them over and over and over again. But more to the point, anytime someone guarantees that you won't lose money, it is common sense that statement, that lie is material. Even Maggie Sklar, Miles Guo's cryptocurrency expert, agrees with that. Remember, she was a lawyer who worked at the CFTC. Are you aware, Ms. Sklar, of any crypto coin whose holders are guaranteed against any losses by a particular individual? No. But I probably want to invest in that cryptocurrency. Of course. Of course it's material if you promise you can't lose. And not surprisingly, victims agreed with Maggie Sklar. They agree with what is obviously common sense. This is Jenny Lee's testimony. She's talking about rule of law, that it mattered to her that Miles Guo was putting up his own money when deciding to donate to rule of law. This is Wei Chen. Why did she invest in GTD? Because there's no risk, she said. Minran Wu, excuse me. This is Wei Chen, asking about the risk factors that were in the private placement memorandum. Did these alter the mix for her? No. Why? Because I trusted Miles Guo. He said there were no risks, only huge returns. Minran Wu. Would you have sent money to GTD if you knew it would be used for a hedge fund investment? No. Minran Wu again. What would happen to the money, to the profits? He said many times, everyone will make money. She will make money. Miles Guo lies mattered. Jenny Lee talking about the farm loan program. Why did she send money? Because she was expecting to get GTD stock. Yeli talking about the farm loan program. Why were you collecting money? We were collecting money, and then we sent it to Miles Guo's company. And what was the purpose of doing that, to your understanding? To get shares of GTD. Le Zhou farm loans. It was important to him that the money, he understood, because he was told, would go to the working capital of the farms. Limari Reyes talked about G Club members broadly. She learned that there came a time when she became aware that G Club members, plural, expected to receive stock. And what was her understanding as to why that was? Cause Miles would mention it in a video. That's what G Club members expected according to the CO. Minran Wu, why did she send money to G Club? GTD stock. Wei Chen, why did she send money to Crane and ACHK? Why did she get a second loan on her house? For GTD shares. Minran Wu, was this 20% gold reserve important to you? The gold promise? The gold lie that Miles Guo told? Yes. Because she explained, if a financial institution has an ability to buy 20% gold as the reserve, this institution's financial ability should be very good. And second, I have the impression that many banks in the world, including the Federal Reserve, they all have gold as their reserve. This sounds formal, she said. Wei Chen, did gold matter to her? It was critical, she said, because it made it sound better than Bitcoin. Lu Zhou, same thing. 20% gold adds to the value of it. Now, through this trial, you've also seen the victims be questioned by defense counsel about whether they read other materials. Other materials, some of which said things different than what Miles was said. Now, as Judge Torres instructed you yesterday, and it's important you remember this, a victim's negligence or gullibility in failing to discover a fraudulent scheme is not a defense to fraud. So whether the victim should have realized they were being defrauded or could have realized they were being defrauded is not a concern of yours. It's not something that you need to consider. That's what Judge Torres instructed. The victims are not on trial. It doesn't matter if there was some fine print disclaimer hidden purposely, by the way. But actually this fine print revealed something else. They reveal Miles Guo's intent to deceive. He knew, as we've talked about, and his co-conspirators knew. that Miles Guo was spouting off lies to get other people money. So he put these documents in place to try to protect himself. This is the G Club disclaimer. Think about this for a moment. It's worth some reflection. It is literally saying, in effect, we know G Clubs knows that you've listened to Miles Guo, and what Miles Guo said mattered to you. Please don't listen to him anymore. Even though, and this is sort of hard to keep track of, but even though Miles Guo was the spokesperson for G Club. How bizarre is it to have a spokesperson who didn't get a salary by the way he just got Lamborghini and houses? We'll talk about that. How bizarre is it to have a spokesperson and then disclaim the very words of the spokesperson? The disclaimer, properly understood, is proof that Miles Guo's lies about stock mattered. Because if they didn't matter, there wouldn't need to be a disclaimer. Remember, you can't blame the victims. You cannot blame the victims for failing to review this disclaimer, or consider it, or decide that the disclaimer means that they weren't getting stock. The question for you is Miles Guo's intent to deceive, his intent to defraud. You cannot fine print your way out of criminal liability. Similar thing could be said, by the way, about the farm loan contracts. First of all, most of them weren't even signed. They were just ways to paper things, and the farms are Miles Guo's farms. It's his Himalaya Farm Alliance. He appointed the personnel. He decided who is in the Blood Iron Group. Miriam Wu's farm loan contract is a prime example. She signed it in August of 2020. When was it countersigned? November 2021 by Long Island David. And that was done because they wanted to extend the contract to add this addendum. And that happened to Lezhou too. And they wanted to add this addendum to give the farm additional control. To try to paper additional reasons, so they didn't have to pay up on time. It shows intent. This was part of the farm loan addendum. It said, the borrower, meaning the farm, has the right to unilaterally terminate the loan if the lender defames Guo. If the lender engages in any statements or conduct against the mission of the whistleblower movement, or engages in any conduct against the new federal state of China. Which is to say, they're just papering reasons to try to come up with ways that they think legally. Miles Guo legally can say, I don't need to pay you. It shows Miles Guo's intent. And with respect to reading the fine print, Yili Mulan told you when you invested in GTD. Did you read the documents closely? No. I don't read. I just sign where I need to sign. Why? Because I trust Miles Guo 100%. Another way you know that Miles Guo's statement mattered is that they worked. Look at the money that flowed in. Hundreds of millions of dollars floating over months, over years, because the statements. Because Miles Guo pitched them, and his statements worked. Those statements mattered for another reason too. And Wei Chen told you about this. They weren't infectious. He made those statements over and over and over again. Miss Chen, you said just a moment ago you felt like you were brainwashed. What are the things that happened to you that you think caused you to be brainwashed by Miles Guo? I think it is a messaging keeping repeating and emphasizing in your mind that make you believe it is true and make you believe it is true without any doubt. I don't know how it happened, but unfortunately it happened to me. That message is repeating. It's emphasizing. It's instilling in my mind, make me trust it every single thing, and making me acting as an idiot back then. She told you that as tears welled up in her eyes thinking about how she was deluded and tricked and brainwashed. Patrick Chen told you about something similar. My feeling right now, he said, it's like another cult, right? When you believe the leader, and you cannot ask questions. You use the phrase, wake up! What do you mean by wake up? That's how I feel because after I left the group, I feel very relieved, Miles Guo group. That's what Miles Guo did to people on purpose. He affected what they thought. His statements mattered to them. And Mulan Yili, one of Miles Guo's closest associates, a member of the Iron Blood group, what did she learn? What did she realize after she woke up? I believe that was a very elaborate scam. Meaning Miles Guo's statements, his pitches were a scam. They were a con. They are a fraud. Wei Chen explained some more. Miles Guo lied to me and gained my trust by emphasizing and repeating over and over again that he's very honest, trustworthy person. He never lied. He brainwashed me into believing him by telling his story that made me believe that he's very nice, kind, caring person. He lied to me to make me believe that he cares about me as his sister. He lied to me to make me believe that he's willing to share his wealth with me as his sister. He took advantage of my high hope for providing a better life for my older parents and young children by promising huge returns with zero risk. He depicted a beautiful family, a beautiful future for my family that deceived me into giving all my money. All my hard-earned money, all my hard-saved money to him to pay for his family, his daughters, his son's lavish and extravagant life. Miles Guo is a liar. He's a cheater. He's a shameless and heartless cheater and fraudster. Ms. Chen is right. You know she's right. That's another way you know that Miles Guo is guilty, because the lies he told mattered. They worked. His fraud worked. The third reason you know that Miles Guo is guilty is because on legal documents he thought would be in a court one day, he hid his control. He tried to protect himself from the SEC, from the Department of Justice, from the FBI, from U.S. law enforcement, and he did that. He concealed the control on legal documents because he knew what he was doing was wrong and illegal. So he tried to set up a canard to have some paper reason why all of this would be okay. To be clear, the G series, GTV, G News, G Club, G Fashion, G Coin, G Dollar, G Bank, G Mall, that stood for Guo. Not goodness and God and global. It stood for Guo. And he was in charge of all of it. But on paper, he wanted to create distance. So GTV was owned on paper by his son, by Milesun Guo through Soraka, which Milesun Guo on paper was the ultimate beneficial owner of. And on paper in the PPM, the private placement memorandum, Miles Guo, it's on the lower right of your screen, was the sponsor and advisor. He named Max Krasner, the guy who ran the slush fund for him, as an executive director, and Yvette Wang as a director. G Clubs, he had Howard he be the UBO, so he can sign money from and to himself, which is really from and to Miles Guo. Limari Reyes told you about Howard he, who was in fact Milesun Guo's, Miles Guo's son's best friend. And also Milesun, and we know this from the college recordings, also on paper like GTV, like Soraka, had ownership interest in G Club. He was technically, as he put it, a settler of the foundation. So he thought he could participate in legal conversations about it. But he was clear that actively no. The UBO is Howard he. I am just the settler. And the Himalaya Exchange, which William J. allegedly owned. This contract was found in Connecticut. Government Exhibit CT-198. It was found and signed. But it's marked as the executed version, and it shows that William J., the financial guy, was holding in trust the Himalaya Exchange, those companies that are listed 1 through 4 below for Milesun or Changguo. 4 Miles Guo's son. So the Himalaya Exchange, Miles Guo tried to hide himself from that too. This is a zoom in on it. Assets were held in family members' names. This document was recovered from a search of Yvette Wang's apartment. That Lamborghini, the one found in Miles Guo's garage, was on it, along with a lot of other cars. And who hold the title to the Lamborghini? Defeng Chow, Mei Guo's fiancé. his soon-to-be son-in-law. You see next to that it says G Club International? This is Defeng Chow, Miles Guo's soon-to-be son-in-law. And this is a certificate of title for the Lamborghini with the VIN number on it that was found in Miles Guo's garage. And Defeng Chow was not an employee of G Clubs, had nothing to do with G Clubs. You heard that from Limari Reyes. This was a way to paper it to make it look like Miles Guo didn't own the Lamborghini, but he did. This is an entity issue. Also found in Yvette Wong's apartment listing various entities, and who the paper owners of them. All the shell companies they used to hide Guo's control on legal documents. Then there's Taurus Fund. Scott Barnett. Remember him? He testified yesterday and the day before. That was Miles Guo's bodyguard. He was named as the managing member of Taurus Fund LLC. What was Taurus Fund? It was a way to hide the mall and mansion that was for the Guo family. The real estate broker who represented the Guo family, Frosini, she told you that she showed this house, this mansion to the Guo family. And Guo himself lied under oath during his depositions in connection with his bankruptcy about Golden Spring. He claimed he did not know anything about it. He lied some more about Golden Spring. He didn't know who Max Krasner was, not true. He lied about Lamp Capital, which we saw before was used to pay for his family's yachts and boats and things like that. Said he didn't know about it. He even lied about Soraka. Soraka. Remember that? We're going to come back to that. And he too lied about the G in GTV. What does it stand for? God, the goal, like GOL? The English word goal? Yeah, goal or God. Do you remember the hero video? Remember the hero video in which he appears in every single frame. A man who puts himself out in front of everything and wants to take credit and be the front of everything. Do you really think GTV is really not Guo TV? Guo Media is not Guo Media? G Fashion isn't Miles Guo? G Clubs isn't Miles Guo? It's all Miles Guo. He's lying to the bankruptcy trustee, the bankruptcy court, to hide his control on legal documents because he knows these companies are criminal. He's playing them. He's trying to hide behind the shell game. Miles Guo is not dumb. He's very smart. Look at what he put into place. Look at what he planned. Look at what he did for years. He knows. He knows. And you know too. He used the shell game so much he disobeyed a court order so flagrantly that he was held in contempt when he tried to send the Lady May the yacht abroad. And he hid his control. He hid his control by using trusted co-conspirators like Yvette and William J. that gave him some cover to try to make businesses look like independent businesses that weren't part of this criminal enterprise. And so they could put out these statements that say Miles Guo does not have any decisive control over G Club BVI, or its parent Jovial, or its parent The Stickting. Was that true? No. And Khaled told you that. Focusing on the first sentence. Do you believe that statement to be true? No. And you know that statement is not true. And then to get some more cover, Guo and his co-conspirators had a second layer of conspirators Howard He Milson, Long Island David, Yo Bing Zhang, Max Krasner. We've talked about that. This was a large enterprise after that all. And below them were figureheads, like Limari Reyes, the CEO of G Clubs, and Jesse Brown, the CEO of the Himalaya Exchange. And how do you know that? They told you. Ms. Reyes is the CEO of G Clubs. Did you have final decision-making authority on all matters concerning G Clubs? No. Ms. Reyes, when you were the CEO of G Clubs, did you believe that you could fire Guo? I didn't feel like I could. And in fact, going back to the do not say words for a moment, if Miles Guo was just the spokesperson of G Clubs, And G Clubs knew he kept saying all these things on video that were causing problems for G Clubs. So much so they gave him a list of words not to say if he was causing that much problem. If Miles were really just a spokesperson for G Clubs, they'd fire him.
Continued on next page.
Mr. Finkel said they couldn't, because Miles Guo was G Clubs. It was his company. He controlled it. He just didn't want it to look that way on paper. Jesse Brown. As the CEO of the Himalaya Exchange, Mr. Brown. How many people reported to you? 0. What were you in control of? I was in control of nothing. It all goes back to this. Earlier on in this conspiracy, Karen Maestrello asked questions. She pushed back. Yvette told her that she was paid to execute orders, not to think. And so the enterprise worked. They found Limari Reyes, they found Jesse Brown. They found people willing not to ask questions. People who were willing to sign documents, willing to do what the enterprise wanted, to keep the money. And, of course, everyone answered to the boss, to the principal, to Guo. And the farms? Guo was in charge of the farms. He appointed Long Island David, brother Chong Dao, as the Secretary General of the farms. He appointed its leaders. On the right is the UK farm leader. He communicated with his most loyal farm leaders, like the Iron Blood Group, who executed his instructions, who transferred money on his behalf. And when that money went missing, he could blame it on these people, like Sarah Way and others. That was part of how this worked. And I talked about Guo used legal fine print to hide crimes. He misled his followers by brainwashing them. He built up trust. He played a long con. And amid the flurry of things, he was always careful to sometimes say, again, to try to protect himself from some legal liability, because he knew what he was doing was wrong and illegal. Remember. Wink, wink, remember, read the contract. Remember, look at the disclaimer. Look at everything. Please read the prospectus. Read the contract carefully. Please read it carefully. Look at the white papers. As I talked about, this was all intentional. It tells you that this was a setup for the victims. It tells you that Guo, the boss, the brains behind all of this, knew what he was doing was wrong. It tells you he knew he had to try to paper over the frauds by stealing money. I just want to point to this. This is part of his bankruptcy filing. You could see from the top it was filed on the docket. And in the bankruptcy filing he was asked a question. Do you have any equitable interest in any residence, building, land, or similar property? And he said no. He uses 373 Taconic. That's the Greenwich estate where the Lamborghini was parked, but he doesn't own it. And that he has access to the Sherry Netherland Hotel, the penthouse in Midtown Manhattan. But again, he doesn't own it. His son just lets him live there. But he did not mention that mansion on the lower right-hand side of your screen. And why did he not mention that mansion? Because he was hiding it from the bankruptcy trustee. That's why there are NDAs. That's why he was trying to keep it secret. He didn't want the bankruptcy trustee to get it. The CCP canard is a scapegoat. So much so that it became a joke at G Clubs. Did there come times while you were employed at G Clubs, Ms. Reyes, the CEO of G Clubs, where the cable or internet would go out? Yes. And what would the employees say? If anything, when that would happen, they would joke about it was the CCP. Because we had heard that many things were due to the CCP. Any problem, any issue. Any time someone got between him and his money, CCP. CCP. It's convenient scapegoating that he played over and over and over again. This insulation, this cover-up. They tell you that Miles Guo knew exactly what he was doing, that he wanted to paper over this fraud. And that's one more reason that you know Miles Guo is guilty. The next way you know that Miles Guo is guilty is he attacked people who went after his fraud proceeds. And by so doing, he also demonstrates his control over the G enterprise. Now you remember, perhaps, Jenny Lee, one of the victims who testified here. She introduced a recording that she had made about a dentist known, as she understood, was Himalaya Dentist. Himalaya Dentist asked Guo personally for her money back. The translation is on the right. Mr. Guo, I'm sorry. I thought it was someone else. I'm a dentist, not a spy or anything like that. How can I send them to you? She's talking about her receipts, about money that she had lost. Ah, Himalaya. This freedom fighter is now indiscernible. Please get out. Wow, please get out, the dentist responds. Is Mr. Guo asking me to get out? A male voice. Yes, please get out. Guo, now they have sent 2 lunatics to make trouble. Just ignore them. Goes on to say, Himalaya, she is crazy. That's what he does. When someone wants their money back, calls them a lunatic, says they're crazy, calls them a spy. Whatever he needs to do to go after them. Just like he went after Luke Despens, the bankruptcy trustee who was appointed by a court in Connecticut to represent creditors, and tried to make sure that Guo can't conceal his assets. That the creditors who were owed money, including a creditor who's owed money, because Miles Guo promised to pay them back and never did. Luke Despens' job was to find his assets and give them back to creditors. So Miles Guo let loose the new federal state of China on him and his family. His picture was in Guo's phone. And it's sick. Circled are Luke Despens' daughters, including Isabel Despens, Dan Copeland's wife. He told you about what it was like when he and his family were attacked and protested and harassed and targeted. Were targeted because Isabel's dad was appointed by a court to try to get creditors their money back. And this picture found in a phone in the Sherry Netherland Hotel, one of Guo's phones, proves Guo ordered this. That's how the enterprise operates. And Guo, to the fellow fighters, tried to make it fun for them. He got them not just to protest for days outside of the Despens children's home, but also outside of a school. An elementary school where Isabel Despens taught. He did this to protect his money. And Dan Copeland, who, through tears, told you about how stressful it was, how hard it was on his wife, how much she cared about her kids. Keeping them safe, making sure school is a safe environment for them to feel comfortable. And she saw how the idea that she could be causing, she blamed herself for what he did. Causing trauma in some of her kids, these kids' lives. Miles Guo did that to protect his money. That's not the only time. Jenny Lee told you about a protest she went to in Hawaii that was organized by Miles Guo. Again, because someone was complaining. Yeli told you about it, that when people asked for refunds, she would ask Miles Guo whether or not to give the refunds. And Miles Guo would decide whether they publicly had criticized him or not would depend on whether they got a refund. Miles Guo told Yeli that himself, not through an intermediary. Yeli also told you about protests she watched online, where one protester punched a CCP spy. Where? In the face? Another one was punched in the eyes. What, if anything, did Guo say about these incidents? He said, well done. That's what Miles Guo is willing to do to protect his fraud proceeds, to protect his enterprise. And he paid these people through rule of law money. Created a blacklist. He named people who got in his way. He posted their personal information online. He broadcast their login and Discord IDs. He doxed them to keep people afraid of him. When the SEC got involved, he organized protests about the SEC too. He said they were infiltrated, the SEC was infiltrated by the Chinese Communist Party, the Securities and Exchange Commission. The thing about this political activism is Miles Guo wants to have it both ways. When he is protesting and harassing people who are trying to prevent him or trying to take back fraud proceeds, then it's political activism, then it's, "I'm just a political activist. This is our First Amendment rights." But when the political activism becomes a problem, him and his co-conspirators very quickly, throw it to the side. This is an email from William J. to Ferrari. They were trying to organize some sort of promotional thing with Ferrari through the Himalaya Exchange. This was in the UK, his true home, Miles Guo's email account. And William J. says that Himalaya Exchange is a commercial entity, no political agenda. Himalaya Exchange has never made an announcement on any political stand, especially those related to China. And Miles Guo himself distanced, when it was helpful for him to do so, the G-Series and the NFSC. His political operation. This is completely a business operation. Do not think the G-Series under any circumstances. Do not link the G-Series under any circumstances to the NFSC. That is all bullshit. He plays it both ways. He say whatever he wants to say to try to get money, to try to cover it up, and to try to prevent people from doing the same. The NFSC was a tool that Miles Guo used in furtherance of his fraud enterprise to carry out his orders. It did dirty work for him. It did dirty tricks for him. And it's part and parcel of the racketeering enterprise that Miles Guo created and controlled every step of the way. Miles Guo is guilty because he lied to his followers about investment opportunities. Those lies mattered. They were material. On legal documents, he hid his control, and he attacked anyone who tried to take back fraud money. Anyone who got in his way. What's the fifth reason that Miles Guo is guilty? He laundered the fraud money. Now, I want to turn back briefly to the GTV private placement, the GTV misappropriation. There are some details in there that prove that Guo, Yvette Wang, and William J. moved money to hide its source. And its source, of course, was investor money, victim money. Now, if you recall, in the subscription documents, they said they would pay this $100 million from a J.P. Morgan bank account in New York. By the way, ending in 5601. And this was part of the KYC-AML process, Know Your Customer, anti-money laundering process that Heyman Capital had put in place. They were requesting all different kinds of documents. That's important. But the 5601 account was a problem for Miles Guo, Yvette, and William J. Because the wire information made clear that the money in it, these are bank statements, said it was from a GTV investment. So they had a problem. What if, as part of that KYC-AML process, Heyman asked for bank statements? They might. So what did Miles Guo, William J., and Yvette do? This shows all the statements that could get them in trouble. And, in fact, William J. even mentions that they might try to transfer from another bank account, from a different company name. And Steele Schottenheimer told him he couldn't do that. So they did something else. They laundered the money. They engaged in a financial transaction to conceal the source of the money. They moved it from the 5601 account to the 2038 account. They made this internal transfer to an account, to the 2038 account, that Yvette Wang, Yinping Wang opened that day. This transfer is June 3rd. This account, the 2038 account, was opened on June 3rd. There's no reason for this internal transfer other than to conceal where the money came from. And then after they concealed it with a financial transaction from the 5601 account to the 2038 account, they moved the $100 million into Heyman. They concealed the fraud proceeds from the GTV private placement. G Clubs was a fraud scheme, but G Clubs was also a money laundering operation. All its loans and investments, they were designed to create, as we've talked about, a paper trail. And these financial transactions that they implemented from G Clubs in Puerto Rico to G Clubs in BVI, meaning the British Virgin Islands, abroad, were designed to conceal the source of the money, to make it harder for U.S. law enforcement, for the FBI to find. These are the loan agreements. This is the summary chart that Owen Foley put into evidence. He was a summary witness. There was $302 million in total in these loan agreements. This is GXZ13. $300 million. That's about, approximately, what G Clubs took in. G Clubs took the money in, they papered it with these loan agreements and investment agreements, and implemented these transactions, sent money to the BVI, sent money abroad to launder it. And where did it end up? Where did that money go? Miles Guo's garage. He also bought a Bugatti from Miles Guo. If you recall, originally, the customer name said Miles Guo, but that was a problem. That's too obvious. So they changed it to G Club International Limited, concealing Miles Guo's name for a $4.6 million Bugatti was part of it. Make no mistake about it. There was never any real effort to make these investments available for members. This was to provide benefits to the Guo family. That's what G Clubs did. There's also a yacht. Howard and he signed an agreement to send money for the yacht to the BVI, to the British Virgin Islands. A financial transaction from the U.S., out of the U.S., to conceal it. And make no mistake about it, Miles Guo was a part of this every step of the way. This is an email from Max Krasner from the office in New York to the G Club folks in Puerto Rico talking about the shipping for the vessel. For the yacht which you now know was called the Liberty. Here's a chat. This email, by the way, is September 14, 2021. Here's a chat from one of Miles Guo's phones between himself and Gladys Chow, his interpreter. What does Gladys tell him about? The boat, the yacht. Boss, this is information about the new boat Max sent you. The first shipping company, and it goes on to provide details about how to ship it ultimately to Connecticut, where he has one of his homes. He's the spokesperson allegedly, but he's involved in the shipping of a yacht? Why? You know why. Because the yacht was for Miles Guo. In fact, he helped design the font on the back of the boat. That's how in the weeds he was on this stuff. That's how immersed in the details he was. Boss, these are the fonts of the new ship. Which one do you like best? He responds, this one. G Clubs also sent a loan. A loan? Remember, none of these loans were paid back. Limari Reyes testified to that. This loan was for $10 million to Miles' son, to Miles Guo's son. What does that have to do with member benefits? Nothing. Money came in, they processed it in G Clubs, and spit it out to the Guo family. This is an email from Howard and he about that loan, or one of the loans to Miles' son Guo, in which he says they got a green light from Mr. Guo. He's in contact with Mr. Guo. And that's Mr. Guo. That Mr. Guo. Howard, he was friends with Miles' son. He didn't refer to him as Mr. Guo. We know about that because Limari Reyes, Alex H., Miles' son and Howard, he went on that boat ride together in Europe. Miles' son wasn't called Mr. Guo. They're friends. Then there's Fiesta Property Developments Limited. Howard, he tells Limari Reyes, our projects in London are doing well. There are no projects in London. Once Limari looked at a few hotels in London. There are no projects in London. We'd like to ask for the rest of the loan agreement to be transferred to Fiesta Property Developments Limited. £10 million. So they put together this loan agreement. He's referring to this loan agreement from January 2021. And what was this loan agreement for? Where did that money from G Clubs go? It went from G Clubs to a Santander bank account. This is GXZ14, in the name of Fiesta Property Development. To another account, Metro Bank, which is a bank in England, and then to Ferrari Beverly Hills. To buy this car for my son. And by the way, in the process of doing that particular transaction and others that Haytham Khalid told you about, they had to lie to a bank. This is Alex H., lying to Morgan Stanley, an FDIC-insured financial institution, saying that Fiesta Property Developments is a real estate holding company by Mr. He in the UK. That's not true. Fiesta Property Developments was a Ferrari buying company. Khalid told you. When you were working for Miles Guo and Yvette Wong, were you always truthful with banks? No. Why did you lie? To make sure that accounts got opened and stayed opened. Was that in the course of your employment? Yes. They lied to banks. They committed bank fraud. That's part of the enterprise. That's part of how it worked. I want to return to Crane for a moment, Haytham Khalid's company. Crane, as you may recall, received member payments, received G Club member payments, victim payments, and there was a dispute between Haytham Khalid and G Clubs, leading to an arbitration. You may recall that Limari Reyes told you that she wasn't truthful during that arbitration. She was towing the company line. And as a result, G Clubs won. And $46.5 million and change was awarded to Crane, to G Club from Crane. And then this letter was sent to Limari Reyes, which she didn't really know why it was sent to her. But this letter was from Aaron Mitchell, one of Guo's longtime lawyers, who helped facilitate these schemes. And it said that he was going to facilitate the transfer of 11 wire transactions. And you can look at this document. If you want, it's GC 497, totaling $46.5 million in change. Where did that money go? Went from Crane Advisory into Lowell and Mitchell, and then Aaron Mitchell sent the $46,549,275.17 to Hamilton Opportunity Fund, William J.'s company, abroad. Then they moved it again, because they always do that, not always. But they usually do that internal transfer, to conceal it some more. Went to the Hamilton Opportunity Fund, and then was sent to McDonnell Whitaker, Inside Title Services, and Bucky SQ. What was that money for? It was for this. That's where the G Club money went, after Haytham Khalid had to send it back to G Clubs. It went to purchase this mansion in Mahwah, New Jersey. This is a chart Mr. Hinton helped create, showing the farm loan money flows. This chart is definitionally money laundering. Look at all of these transactions designed to obscure the source of where the money came from, to make it harder for U.S. law enforcement to find. That was Guo's plan. And after the money from the farms went to ACA Capital in Abu Dhabi, we know it flowed out to Lamp Capital, to Greenwich Land, to Hudson Diamond, to Lexington Properties, to William J. himself. Those other entities, Lexington, Hudson, Lamp, Greenwich, those are Miles Guo's family funds, what he used for his life, for his food, for his clothes, for his boats, for his cars. It was a slush fund. That's the fifth reason you know that Miles Guo is guilty. Because he laundered the fraud proceeds to cover it up. The sixth reason that Miles Guo is guilty is that he had a motive. First of all, money is always a motive. People are motivated by money. Some people are willing to commit crimes to get money, like Miles Guo. But the money mattered to Miles Guo in particular, because of what happened in Hong Kong. On October 23, 2018, a court in Hong Kong entered an order seizing and restraining Guo's assets in Hong Kong and elsewhere. So yes, the CCP seized Miles Guo's money. Obviously they took it. He no longer had the ability to project that he was a billionaire. And what happened in November of 2018? He started asking for money. Rule of law. Now moved to GTV. And what happened with GTV? The SEC got involved and took a lot of the money. There's the freezing order, leads to the rule of law launch. Then, there's the private placement launch. Then, there's the SEC getting involved, putting a stop to the GTV private placement. So what happens? Farm loan program gets launched. Then G clubs. Another way to conceal sales of stock. That's the settlement, where Soraka, GTV, and VOG had to pay more money. What happens after that? The Himalaya exchange launches. If you remember, Jesse Brown told you that the reason the Himalaya exchange launched when it did is because Miles Guo was putting pressure to launch it. Then, in September and October of 2022, the U.S. government seized about $640 million from the G enterprise. What happened after that? A15 and A10 and Abu Dhabi G clubs. In other words, trying to create fraud enterprises. Sub-companies in foreign countries, outside the reach of U.S. law enforcement. This timeline shows the schemes. They show that Miles Guo was adapting and moving and evolving his operations, trying to literally outfox U.S. law enforcement and the Securities and Exchange Commission. One other point to make on this. There's been suggestion throughout this trial that Miles Guo is very rich and he has other money abroad. His family has money, other people have money for him. Maybe, but rich people commit crimes too. And whether Miles Guo was rich or poor doesn't really matter. What matters is what he did, lied to people to take their money. The seventh reason that Miles Guo is guilty is he and his family benefited from his crimes. The proceeds of the fraud flowed to Miles Guo and his family. It shows why he did all this. This is Mawa. This is Miles Guo's house. He tried to make it a home. He lived in it. His real estate broker told you the buyers were the Guo family. He kept his medicine there. His New York State license, his passport, his identity card, pictures of his family, some more pictures of his family. His wife's Lego collection, his Brioni suits with his name in them, some more pictures of his family, $394,000 in cash. And there was also a document found inside about setting up electricity and lighting boxes in May's closet. His daughter's closet, in her fiancé's room, Wayne Deffing Chow, and in his main bath and shower. Boss's main bath and shower, and Madam's, his wife, Mrs. Guo. He even moved some of his stuff from Taconic Road, 373 Taconic Road, to the Mala Mansion in New Jersey. And, of course, you saw these documents between Palazzosi and Promemoria, a designer of some sort, and Gladys Chow. This is one example, Pro 466. But there are many other examples in the Pro series of exhibits. Gladys says, "It's been almost a year since we last talked. Please allow me to introduce myself. I'm Gladys, the assistant of Mr. Miles Kwok." And she gives him links about design plans. Send him a walk-in closet for the missus, a closet for the daughter, a closet for the son, a closet for the for Mr. Kwok. And, of course, Miles Guo texted with Gladys Chow about designing the Mala Mansion.
Video played.
Mr. Finkel said, translated, he is saying, "Don't put the head of the bed on the third floor toward the back. Put it towards here. Most of the bathroom facilities are placed here, which is Guo Mei's bedroom, his daughter's bedroom. This is Guo's master bedroom, Guo's big bathroom here. And this is Xiao Chao. Defeng Chao's room, a small suite. There are 2 bedrooms for them. And a public living room between the 2 of them for them to share. This text chain is important too. This is a text chain between Gladys Chao and Miles Guo. She texts him a picture of this table and says, "Boss, this table you asked your comrade to help order is already ready and will be shipped from Shenzhen, China. Where do you want to ship it?" Then she goes on to ask, "Is this table intended for a company, that company? Let me see that the company should be responsible for the expense." And what does Miles Guo say in response? Use G Club or another private company for payment. Don't involve anything else. Either G Club or another private company. This is yet another example. On top of all the examples of the Khalid recordings, which are the GX400 series, of Miles Guo directing the use of G Club money for a table. He's not the spokesperson. He's not just the spokesperson. He controls the money. Talked about this a moment ago. Then there's Buck ESQ LLC, the attorney trust account. And Amy Buck testified. She told you about how she would get direction from Gladys Chao and sometimes Scott Barnett. Some other people, about things to buy for this family she thought was really rich for the Mawa property. This is her testimony. She talks about the things she would buy with, just to be clear, the money in her trust account which came from the Crane money, which is to say G Club money, member money, victim money. She bought for $1.1 million a tortoiseshell jewelry box and some candlesticks. She bought a chandelier for $120,000 under the direction of Miles Guo's agents. She spent $6,000 on some other candelabras under the direction of Miles Guo's agents. A $53,000 bronze, I don't know how to pronounce that, but there was a pair of them. A $19,000, that was on sale, handsome and complete set of 4 19th century walnut benches, a coffee table for $40,000, less the $16,000 discount, mattresses for $36,000 apiece, an antique rug for $250,000, another set of rugs for $300,000, mirrors and some other stuff for $97,000. For large antique French Louis the 16th gilt bronze and glass arm lantern chandeliers for $1 million. Additional items for $428,000. Sound equipment for $104,000. None of these things were for the G Club members. This was how Miles Guo wanted to turn the house he bought in Mawa, New Jersey into his family home. And he used victim money to do it, to benefit himself and his family. And as we talked about, he got a car. His son would have gotten the Bugatti, except for the fact that the FBI got involved. Seized it. And Miles' son got a Ferrari, as we talked about. A Ferrari for him. His helmet says, "Miles' son." This is not for G Clubs. This is not for members. This is not to fight the CCP. This is a benefit that shows Guo's family benefited from his crimes. From the Himalaya exchange. Miles Guo got a $37 million loan when he needed it the most. When he thought that he'd be held in contempt. Can go to jail. And the farms paid for personal expenses. And the GTD private placement paid for a hedge fund investment, as we talked about. And that was in the name of Soraka, which itself was a slush fund. You saw some of those documents. Stefano Ricci clothing for $8,000. A home inspection in New England at Taconic Road was paid for with Soraka Media Group money. That was for Miles Guo's home in Connecticut. And there's a chat on the side, which makes clear that Max was implementing orders from Miles Guo to use the family slush fund. Soraka. That was the name the Heyman investment was in, the family slush fund. and Miles Guo knew his victims lost money.
Video played.
Mr. Finkel said, that's November 11, 2020, where he tells his followers not to worry. No one lost money as a result of the Soraka investment. Do you know how much money you lost by shorting the Hong Kong dollar, brothers and sisters? All Kyle-based funds loss. 50% loss. You did not lose. Fellow comrades, Soraka you did not invest, Soraka invested. So he knew about the Soraka investment. Of course he knew. And he reemphasizes again, I can't use the money you invest to buy even a Japanese meal. If he does, I will be arrested directly. The United States will really arrest you. He knows using fraud money, victim money, is a crime. He always knew that. And he did it for years. And that money, as we talked about, 30 million of it, $30 million, a lot of money gone. Never paid back. So this is what Miles Guo got. $1.3 billion comes in. Approximately 100 million goes to his family offices and his family members. 550 million goes to William J.'s companies to be laundered and processed. It's a lot of money. A lot of money from his victims for himself. That's what Miles Guo got. What did his victims get? Less than nothing. They lost. Minran Wu, she lost $15,000 just from this investment. More overall. Lu Zhou, $30,000. A lot of money, $30,000. Jenny Li, $60,000 from the farm loans itself. A lot of money. Wei Chen, $1.1 million. She invested in the private placement in G Club. The digital bank, another scheme. Don't have time for all the schemes. Himalaya Exchange, the rule of law, H-Coin. She lost $1.1 million. And these people, these victims, they not only lost their money, you heard testimony about this, they lost credit by taking out loans to pay for these investments. They lost time with their children and their families, and their work by volunteering for Miles Guo. By trying to help him because they thought it was a good thing to do, thinking about him all the time. Putting their trust in him. And he took it from them. He took that trust and used it to buy a boat and a car and a huge house. Everyone agrees. Government agrees. Defense agrees that Miles Guo was targeted by the CCP. But as Miles Guo's expert told you, none of that matters for this trial. And it doesn't give him a license to rob from these people. Common sense tells you that. Their expert, Guo's expert, told you that. But there is targeting in this case that does matter. You know what targeting matters in this case? The targeting Miles Guo did. His targeting of victim money, that's the targeting. His targeting of victims that matters in this trial. Miles Guo claimed to be a political activist. And he sucked people in. He brainwashed some of them. He convinced them he could help them, that he was trustworthy. He attracted people like a magnet, people who agreed with his message. He called them his fellow fighters, his comrades, his brothers in arms, his sisters in arms, his friends, his family. He brought them in close. He said he loved them. He cared about them. He built up his trust. And they gave their money to him. He took it. And what did he do when these people put their faith in him? He conned them. He scammed them. He defrauded them. He targeted these people, thousands of people, the victims. He knew what he was doing, and he did it for years. Over and over and over again. It wasn't a mistake. It wasn't an accident. It was intentional. It was his design. He targeted the victims. He targeted thousands of victims. He lied to take other people's money. That's the targeting that matters in this trial. So there are many reasons, many, and Miles Guo is guilty of each and every charge. And we went through 7. And any one of these is enough to convict Miles Guo. He lied to his followers about investment opportunities. Those lies mattered. They were material. On legal documents, Guo hid his control. He attacked anyone who tried to take back the fraud proceeds. He laundered the fraud proceeds. He had a motive. He, Miles Guo, and the Guo family benefited from his crimes. Any one of these is enough to convict Miles Guo of each and every charge. And you should convict him because he's guilty beyond a reasonable doubt. I'm going to make 2 last points, and then I'm going to sit down. First, as I think you already know, and as Judge Torres instructed you, this case was lawfully brought by the United States government by career prosecutors and career FBI agents whose job it is to enforce the laws of this country. This is not China. This is New York City. We're in downtown Manhattan in a federal courthouse, where judges like Judge Torres make sure everyone who wants their day in court is entitled to it. Everyone who wants to hold the government to its burden of proof is entitled to it. And we've met our burden here and then some. Do you know what else we have in the United States? We have you. We have a jury, average citizens doing their civic duty, taking away time from their lives, from their jobs. Your jobs, from your friends and family, to make sure that everyone who wants it is entitled to their day in court. I'm not a CCP spy, neither is Judge Torres, neither are you. So decide this case based on the evidence you have seen and heard these past 7 weeks. The evidence that is overwhelming. All of the testimony, all of it. The direct, the cross, the defense case, the government's case, all of it shows beyond a reasonable doubt that Miles Guo committed wire fraud, securities fraud, laundered money, lied to banks, and agreed with others to erect a racketeering conspiracy, a fraud enterprise. That is what Miles Guo did. That is what he chose to do. That's what the evidence shows. That's what the government has proved beyond a reasonable doubt. I'm going to end where we began when this trial began, back on May 24th. The first witness, Special Agent Erin McNamara. She's a special agent from Connecticut. She took the stand, first time. She told you about the search of this place. Was Greenwich Estate. On March 15th, 2023, there was still snow on the ground. She told you about the garage. Lamborghini in the garage. She took you inside to an office. Inside that office was some production equipment. Microphone, cameras, a flag that at the time you didn't know what it meant. A star at the time you couldn't have known what it meant. But you know now. And at the time you first saw this image, you didn't appreciate. I'm sure, because the evidence wasn't in like it is now, that this is not just a desk and a microphone. This is a crime scene. This is where Miles Guo, one of the places, he sat and lied to people to take their money. And Guo is responsible for doing that, for the harm he caused, for doing it on purpose, intentionally, knowingly. Guo is responsible. Just like everyone, all of us, are responsible for your choices, for our choices. He's responsible for his. He's responsible for his actions. He's responsible for his decisions. Guo is responsible for all of this. He chose to lie. He chose to defraud. He chose to take what was not his. He chose to work with others to make it all happen, to build an empire of fraud. The evidence of all that is overwhelming. It is clear. It is plain. Guo's schemes were sprawling. They were vast. But they collapsed to a simple, inescapable, and obvious truth. Miles Guo lied to take other people's money. And the evidence in this case, all of it, leads to one verdict, just one, and you know it. You know what that verdict is. The defendant, Guo Wigui, Ho Wan Kwok, Brother 7, the principal, boss Miles Guo. This man, on each and every count, Miles Guo is guilty. Thank you.
The court said, members of the jury, we've heard the government's summation, but we're still not finished with the trial. We have other phases, and so it's not yet time for you to start deliberating. So we're going to take our half-hour lunch. We'll come back at 2:30. Remember that you're not allowed to discuss the case amongst yourselves. Don't permit others to discuss the case in your presence. Don't read, listen to, or watch anything from any source that touches on the subject matter of this trial.
Jury not present.
The court said, counsel, please step up.
Continued on next page. At sidebar.
The court said, Mr. Ferguson, I just wanted to ask about your wife.
Mr. Ferguson said, everyone is doing very well. Thank you, Your Honor.
The court said, wonderful. Was it a girl or a boy?
Mr. Ferguson said, a girl.
The court said, oh great. Well, I'm happy for you.
Mr. Ferguson said, thank you.
The court said, all righty. That's it.
Luncheon recess. Continued on next page. Afternoon session 2:30 p.m.
The court said, please have the jurors brought in.
The law clerk said, jury entering.
Jury present.
The court said, please be seated, members of the jury. And now the summation on behalf of Mr. Guo will be presented by Mr. Siddhartha Kamraju.
Mr. Kamraju said, thank you, Your Honor. May I proceed?
The court said, you may.
Mr. Kamraju said, hello. As Judge Torres just mentioned, my name is Siddhartha Kamraju, and I represent Miles Guo. Now you heard Judge Torres say before that the defendant has no obligation to make a statement. He has no obligation to present a case. He has no obligation to present any evidence whatsoever. And that's because it's the government's responsibility to prove Mr. Guo's guilt beyond a reasonable doubt and overcome something that he enjoys. Like we all enjoy, the presumption of innocence. As Judge Torres told you at the very beginning of this trial, Mr. Guo entered the room with that presumption. He continued to have that presumption through every moment of this trial, and he continued to have it right now. Even after you heard from Mr. Finkel, even after you will eventually hear from Ms. Murray, Mr. Guo has to be presumed innocent. And that means despite what the government says today, you have to do more than just keep an open mind. You have to presume him innocent. And what you have to do is, you have to hold the government to the standard required by U.S. law, not Chinese law, U.S. law. That they have to prove their case beyond a reasonable doubt. That they have to prove to you that what they say happened beyond a reasonable doubt. And you know what this trial has proven, they have failed in that burden because the trial, like Mr. Finkel's summation, was long on rhetoric, but short on specifics, long on talk, but short on evidence. We're going to talk about all of that. And I want you to pay as much attention as you've done throughout the entire trial. Because the things that we'll talk about, you'll see, some of the things Mr. Finkel said are flat out wrong. They're not showing you the whole side of the story, and that's what we're going to do. Because as you heard, we did present a defense. You saw. We cross-examined witnesses. We called our own witnesses. We presented our own documents, and now I'm here to give Mr. Guo's closing statement. Now, it's not my style to do a lot of pointing and yelling. I'm just here to tell you the side of the story. But when you hear it, I am confident that you will agree with me that they have failed in their burden. That they have not proven that Mr. Guo is guilty beyond a reasonable doubt. So I'm going to start where the government ended with Mr. Guo, cause obviously this trial is about who he is. Now, the government would have you believe that he's a consummate fraudster, a swindler. They'd have you believe that he's a head of a racketeering enterprise. But as you've seen, as you will continue to see as you deliberate, the government is wrong. The government's case is based on a superficial and misguided view of the evidence. And that's what you're going to see as we walk through it. So who is Mr. Guo? Well, like all of us, Mr. Guo has many dimensions.
He's a father. He's a husband. He's the seventh of 8 brothers. He's a friend. He's a Chinese businessman that has built an enterprise in China that is massive. He's the founder and face of a pro-Chinese democracy movement that has amassed global followings of thousands of fellow political dissidents. And he's a fugitive. Not from this government, but from the ruling party of one of the world's great superpowers. The Chinese Communist Party or the CCP. Like all of us, Mr. Guo is many things. And to truly comprehend what happened here, you have to consider all of those parts. You have to look at the whole story, not just the part the government is asking you to see. The whole video. The whole document, the whole recording, the whole testimony, you have to look at the whole story. Now, over the next couple of hours I'm going to walk through each of the supposed frauds that the government alleged. I'm not going to be able to get to all of them, not going to spend a lot of time on A10. Because you didn't hear a lot about A10 during this trial. But before I do that though, I want to talk about what I think is a central question that you're going to have to address in coming to a verdict. Because at bottom when you peel back all the ominous sounds of a racketeering conspiracy, the government's case is essentially a fraud case. I think Mr. Finkel even said that. The government's entire racketeering enterprise is based on allegations of fraud. Its money laundering allegations are based on the supposed transfer of fraudulent proceeds. Those allegations of fraud are at the heart of the entire case. Now Judge Torres is instructed you on the law. And what she says controls. But what she told you is that to prove any of its fraud charges, whether related to GTV or the farm loans or G Club or the Himalaya Exchange, any of the fraud charges, the government must prove beyond a reasonable doubt that Mr. Guo intended to defraud people when he made the statements that the government claims are false. He had to intend to trick people out of their money or their property. And you've also heard that Mr. Guo's supposed victims are the other members of his political movement. The whistleblower movement. And you've also seen that the money that Mr. Guo supposedly stole was intended to help that movement's ventures. So in a very real sense, the government's claim is that Mr. Guo intended to deceive the political movement that he started and helped grow. And why does the government say he did this? For money, plain and simple. So that's the central question you're going to have to address is would Mr. Guo intentionally cheat his fellow movement members for money? And when you look at the evidence, you will see that the government has failed to carry its burden on that question. It has failed to prove beyond a reasonable doubt that Mr. Guo took a penny with the intent to undermine the political movement he invested so much in. Now, and I will address that question in detail over the next little bit. But at a high level please think about this as you deliberate. Think about what Mr. Guo endured to advance this movement. He fled China to escape persecution by the CCP. To do so, he left his family, his life, and his home. After he arrived in the United States, he made the choice to start speaking out against the CCP publicly in 2017, a choice he did not have to make. And almost immediately after he began speaking out, the Chinese Communist Party tried to silence him. It started a relentless campaign to destroy Mr. Guo's credibility and his ability to broadcast his message. It started a specific squad dedicated to harassing and discrediting Mr. Guo online, spreading misinformation about him. It tried to coerce U.S. social media companies to block Mr. Guo from their platforms, limiting the reach of his message. It paid protesters to target Mr. Guo in the United States. All CCP efforts to kill Mr. Guo's pro-Chinese democracy movement at its birth. It seized assets in Hong Kong, choking off his access to money for his movement. The CCP even tried to force Mr. Guo back to China. Corrupted American citizens to engage in illegal plots to lobby the Trump administration to extradite him back. They tried to force him to return by illegally sending Chinese agents to the United States to negotiate his return in exchange for giving his family, his money and his life back. The CCP even tried to kidnap him. All to get him out of this country without protections for free speech in our global media industry. That's some of the things that Mr. Guo went through to establish this movement. And as crazy as it sounds to us, as outlandish as it might sound, you can take that targeting of him as a given. Because even the government, the United States of America, agrees that it happened. So ask yourself when you're deliberating, how much would you have to care about something to risk losing your family, your money, maybe even your life for it? I think we all know the answer to that, a tremendous amount, a life-sacrificing amount. And on the other side of the scale, the government's claim that Mr. Guo needed money. That's it in a nutshell. According to the government, Mr. Guo was willing to throw away the movement. He endured everything we just talked about for money. I'll say two things about that initially. First, there is no dispute that Mr. Guo lived a lavish life from the moment he came to the United States. We all saw the luxury apartment that took up an entire floor overlooking Central Park. He had the yacht. He had the jet. He had the suits. He had all of that well before the government even claims this racketeering enterprise started. You've also seen no evidence from the government whatsoever that his lifestyle changed at all during the time of the alleged enterprise. You didn't see anything from the government's case showing that Mr. Guo suffered for money even after the Chinese Communist Party seized his assets in Hong Kong. Or even after he declared personal bankruptcy. And contrary to the government's slanted depiction of things, you haven't seen any evidence of him taking a penny from the movement for his personal use. So that's obviously the heart of it, right? The government put on weeks of evidence to try to show you that Mr. Guo took money improperly for himself. They called witness after witness to say that. But I want you to think about something. And you'll hear me say this over and over again, they're asking you to connect the dots and take away a man's liberty. But had they ever really given you the dots they need? As we walk through and as Ms. Murray stands up after me, I want you to ask that question. They want you to have leaps in logic. Have they given you the actual evidence? And I think if you do that, you will agree that the answer to that is emphatically no. They have not satisfied their burden. So let's start at the beginning. So you heard in 2015, Mr. Guo arrived in the United States. He was fleeing the reach of the Chinese Communist Party, and he landed here in New York in Manhattan. Now maybe some of you emigrated or have relatives who emigrated to this country. So you know how disorienting that can be. Here was Mr. Guo. He was a stranger in a strange land. He barely spoke any English. His friends and family were back in China. And he had no connection at the time to this country. Those are daunting circumstances for anyone. But as you heard, Mr. Guo threw himself into a new life in America. In 2017, he began to speak out against the CCP. He started with that Voice of America interview on April 19, 2017. And during that interview, he started criticizing officials in the party in a way that, even according to the government's own witnesses, others had never done before, in a way that shocked people, in a way the Communist Party didn't like. But the CCP's reaction was swift and severe. Just look at the timeline of events around the VOA interview. On April 18, 2017, PAX filed its litigation against Miles Guo in New York. The following day China announced it filed an Interpol red notice seeking his arrest. That's the same day that the VOA interview was cut off abruptly right as Mr. Guo was criticizing the CCP. And as you heard, this was just the beginning of the CCP's effort to silence him. You heard how on May 2017, the CCP dispatched that team of undeclared Chinese agents to coerce him to return to China. And you saw in the translations of the calls and meetings between Mr. Guo and those Chinese agents. You heard the deal the CCP was offering him to be quiet. You can have your family back. You can have your money back. You can have your life back. But you know what happened next? Mr. Guo turned that down. He kept going. Kept criticizing the CCP, kept speaking out publicly, and the CCP kept going too. That same year it stood up. That group of Chinese agents specially dedicated to harassing and trying to discredit this man. The power of a nation to discredit one man, it start paying people to protest him here in America. It bribed American citizens to lobby the Trump administration to send him back. You even heard from George Higginbotham, a former DOJ employee, about how he met with the Chinese ambassador to discuss how to convince the Trump administration to send him back. The CCP made him the #1 priority of its repatriation efforts. It tried to kidnap him. The CCP also tried to stop U.S. social media companies from giving him a platform to speak. Because, as you heard, as much as anything, what Mr. Guo was doing that infuriated the CCP was speaking publicly. He was broadcasting. And his broadcasting was becoming more and more popular. He was picking up followers from here in the United States all the way to Australia. To use Beau Collins and Limari Reyes' words, it was a following of like-minded individuals. All committed to one overarching goal, to free the people of China of the repressive Communist Party. And so, yes, a movement was born. The whistleblower movement, a movement to tell the truth about the CCP. To wake up the people of China about the truth about the corrupt government that ruled over them. Because that's the thing, the government wants you to believe that there was an enterprise here. You know what? They're right, but it's not a racketeering enterprise. It's a political one. A political enterprise of people banded together to bring down one of the world's most powerful governments. And so that's what they set out to do. They started setting up the infrastructure to help carry that movement forward. We'll talk about each of these in detail, but just think about it. They set up the Rule of Law Foundation and society nonprofit organizations formed to advance the movement's advocacy. They set up GTV, a social media platform that would bring the truth about the CCP to people in China and around the world. They created the Farms, a group of volunteers that put their time, efforts, and money toward the movement's goals. They created G Club, a membership club intended toward high-net-worth Chinese people who believe in the fight against the CCP. And they created the Himalaya Exchange, a cryptocurrency exchange intended to give people the ability to move their money freely without interference from an oppressive regime like the CCP. It is indisputable the whistleblower movement and these businesses were intertwined. Even if there wasn't a complete overlap, even if you can't say it's one-to-one between the NFSC and G Club, the government cannot seriously dispute that the target audience for the Rule of Law Foundation or GTV or the Farms or G Clubs or the Exchange are the members of this movement. That's their entire theory really. That Mr. Guo used these businesses to steal from the members of the movement. And even their own witnesses told you that. Remember Le Zhou? He told you that he bought G Fashion because he understood that it would support the movement. Or Patrick Chen, who told you that he didn't really believe Mr. Guo's promises of high return. But he wanted to support GTV's mission to help people in China. Or Limari Reyes, who told you that part of why members bought G Club membership. Because of the social bond that members felt knowing that they're all part of a club with the same mission. You cannot take the movement out of this. And before we turn to the specific entities, I just want to say one more atmospheric point. Now, Mr. Guo was unfamiliar with the culture. Very little knowledge of its language. He fled from his home country. And despite that, and it may sound crazy to all of us, he decided to work on a political movement. 2 non-profit organizations, a social media company, a membership company, and a cryptocurrency exchange. And think about when he decided to do it, 2020 and 2010. What else was happening in 2020? We all remember it well. That's when the COVID pandemic started. Think about the impact that it had on all of us, on our families, our work, our businesses. Well, the same thing is true here. You heard from Karen Maestrello how people weren't going to the Golden Springs office because of COVID. So these people were facing the same challenges that we were. But they also had to contend with one of the world's superpowers doing whatever it could to stop them. So, yes. We're not saying there weren't struggles. You heard about the SEC stepping in. You heard about the banking issues. You heard about the challenges getting these business to work exactly right. When you look at the whole record, when you look at the whole story, you'll see that those struggles were not because there was some criminal plot lurking. They weren't because Mr. Guo and his fellow fighters didn't sincerely believe in those goals. Sure. They may approach them with unfamiliarity and overexuberance. The unfamiliarity of trying to do big things in a country you know very little about. The exuberance of a political movement, then around a single month raised almost $500 million. Yes. That may be true. But there was never an intention to defraud anyone, never an intention to steal. Now, before I go on, I want to talk briefly about another topic that the government has touched on over again and again in its summation and during the trial. And that Mr. Guo's lifestyle. They showed you over and over again videos and images of Mr. Guo living a lavish lifestyle. They talk about how he lived in the Sherry Netherlands, how he had a home in Greenwich, Connecticut, the yacht, the jets, the Brioni suits. Think about how many times you heard about those suits. They even showed you multiple photos of the hangars for those suits. But never any evidence about when those suits were brought. So I have two things to say about that. First, to go back to something that Ms. Schroff said in her opening statement. Please do not be fooled by these repeated allusions to Mr. Guo's lifestyle. It's not a crime to be wealthy. It is not a crime to live in luxury or to spend money on nice things. It's not a crime to have a yacht or a jet or to wear nice suits. It may not be our lifestyle. It may be odd. It may even be off-putting to some, but it's not a crime. And Mr. Guo was fortunate enough to have access to that kind of wealth, and he was grateful for it. But that doesn't make him a criminal. The second thing I will say is that the government's repeated harping on Mr. Guo's wealth is strange because it undercuts its own case. You heard from Mr. Finkel just a few moments ago. He told you that Mr. Guo had a motive to steal from his fellow movement members because he needed the money to fund his lifestyle. But what's the government's evidence of his supposed poverty? Well, they point to the fact that the CCP seized Mr. Guo's assets in Hong Kong in 2018. But where was he living after that seizure? That same penthouse overlooking Central Park. He had those same security teams. He was chauffeured around. You even heard from Ms. Maestrello, while she was there. Mr. Guo didn't even think about paying for things. He just asked people to buy them. And you saw in that excerpt of Mr. Guo's credit review. He didn't even have a credit card or a debit card. Even after the seizure, Mr. Guo continued to live the same life that he always had. He had no reason to steal. And the reason why he could do that is because he's always had the aid of his family and his friends. The vast wealth that he and his family had amassed in China. And you saw examples of that help throughout this trial. For example, look at the bank statements for Mr. Guo's family's offices. What do you see? Massive amounts of money coming to account from other companies, including Soraka and ACA. Look at the first one. $19 million in 2015. That's 3 years before the government claims there was any kind of racketeering enterprise. And it keeps going. Millions of dollars from these companies into Mr. Guo's family companies here in the United States. He didn't need to steal money for a yacht payment. He had plenty of money. And he certainly didn't need to steal it at the cost of the movement that he nearly threw his life away for. These companies, they belong to his family and his friends. Soraka, as you heard Steele Schottenheimer tell you, was Mr. Guo's son's company. We don't dispute that. The government's right. It was, because it's his family business. And ACA, who did ACA belong to? William J. And who is William J.E.? It's Mr. Guo's investment advisor. Again. Nothing suspicious about a son taking care of his father or a person hired to manage someone's money, giving him money. And yet that's what the government would like you to believe, that these family and friendship relationships are criminal. They are not. So much for the Hong Kong seizures. What's the government's other argument? Why else do they tell you that Mr. Guo is broke? Well, they say he declared bankruptcy in February of 2022. First of all, let's just think about the circumstances of that bankruptcy. You heard from Douglas Skalka. He was the bankruptcy lawyer, right? That just a few days before Mr. Guo's filing, what happened? The judge in the Pax case entered an order directing Mr. Guo to pay more than $100 million in penalties. And how long did he have to pay that? 5 business days. And what happened if he didn't do that? He faced jail time. And what's always in the background? The CCP and its disruptive impact on Mr. Guo's banking relationships. And as you heard, Mr. Guo couldn't just keep all that money. He had to rely on his family and friends. So given all that, is it any surprise that even a wealthy Chinese businessman couldn't pull together more than $100 million in cash over the course of a few days? Including a weekend? And here's the other thing, the bankruptcy occurred in February of 2022. But look at when Mr. Guo is alleged to have lied for the money. The GTV private placement happened in April of 2022. Almost 2 years before that. The G Club's launch happened in October of 2020. The farm loans program was in July of 2020. And the Himalaya exchange was in November of 2021. All predate the bankruptcy. So how does a bankruptcy explain Mr. Guo hurting for money in May of 2020? Especially when the government didn't show you that his lifestyle had changed at all. Now, I think we can all guess what the government is going to say when I sit down. Of course he was maintaining his lifestyle. He was stealing the money. We'll go through in detail why Mr. Guo did no such thing. But I want to give you just a couple of points here to show you how shaky the government's argument really is. They flashed a lot of documents and photographs before you, but in the end, the government's case really is a lot of sound and fury signifying nothing. So here, before we dive into each of these alleged schemes in detail, I'd like you to just consider a few things. If Mr. Guo thought he was as broke as the government says he was, then why would he take $100 million from the GTV raise and invest it all, in a super risky hedge fund where he knew that he was likely to lose it? In fact, he bragged about losing a big chunk of it afterwards. I know the numbers in this case are staggering. But $100 million could buy a lot of campers. It could buy a lot of Bugattis. It could buy even a few Mawa mansions. So who does something like that? A man who is just simply not worried about money. Think about G clubs. Let's look at that red Lambo parked at Mr. Guo's Connecticut home. The government opened its case with that, remember? Tried to get you to believe that Mr. Guo had secreted that car away for his own use. There's a couple of problems with that. Let's start with this. The car was bought in September of 2021. And it was seized by the FBI in March of 2023. The government's only proof that he ever used the car was that it was showcased in 2 videos. One for G Clubs and one for the Himalaya exchange. So imagine that a spokesperson for a company using a prop in a video. There isn't a single witness, video, or document that shows Mr. Guo out joyriding that car, even driving it outside of those videos. In fact, you heard the witnesses, Mr. Guo doesn't even drive. He doesn't even have a license. They showed you an expired learner's permit from the Mawa facility. Does it really make sense that Mr. Guo would steal all that money to buy a Lamborghini just to park it in a garage and never to drive it? Never make one of those slick videos the government shows you, the Ferrari, remember racing around the track? You didn't see any of that. I know. I know what they're going to say. But the daughter's boyfriend's name is on the car. We'll talk about that more too. But what? Is the theory that Mr. Guo stole this money to buy his daughter's boyfriend an expensive race car? Does that sound like any father anywhere in the world? Hey, buddy, thanks for dating my daughter. Here's a Lamborghini. Or what, the boyfriend was going to drive Mr. Guo around in it. Does anybody buy a Lamborghini to ride shotgun? It does not make sense. What makes much more sense is that the spokesperson for the company advertising the products used the car to do exactly that. And we're going to come back to that. What I'd like you to think about is this. According to the government, Mr. Guo was desperate for money. He had a massive PX judgment hanging over his head that could send him to jail. And he was apparently willing to steal this money to pay for things like maintenance on his yacht. But he never just takes the money from GTV or G clubs or the farms or the exchange and just pays the whole thing off. Not just the $37 million loan, I mean pay PX off completely. Why not do that if you're willing to steal instead of declaring bankruptcy, putting yourself in arms of the trustee? Sitting through an inquisition by these creditors. How would that make any sense if Mr. Guo was willing to use this money for his own personal benefit? Now, I know we have a lot more to talk about on each of these things, and we will. But when you just pause and think about each of the government's allegations for just a moment longer. When you give a deeper look, the government's case doesn't hold up. Let's go back to the start. Mr. Guo's in New York. And it's 2018, and he started this very public campaign against the CCP. He draws attention from some polarizing figures. But folks who are undoubtedly anti-CCP. He meet Mr. Bass, the manager of a hedge fund who is a very vocal critique of the Communist Party. And of course, Mr. Guo meets Steve Bannon, a man who brings out a lot of emotion. But who Mr. Guo could agree with about one thing for sure, the CCP was evil. So Mr. Guo and Mr. Bannon embark on a plan. A plan to fight the Chinese Communist Party. And real quick before I move on. There can be no dispute at this trial that Mr. Guo could reasonably believe that the CCP is something worth fighting. Even forget about his problems. Here's what some of the government's own witnesses told you about their interaction with the CCP. Think about Lu Zhou, where he was a risk of a forced abortion at the hands of that regime. Or Patrick Chen talking about how his grandfather and several uncles were brutally murdered. Even Steele Schottenheimer, who lives in Texas, told you about the CCP and its concentration camps. So Mr. Guo and Mr. Bannon agree to do something about that. They agree to start the Rule of Law Foundation and Rule of Law Society. And there's a big announcement in November of 2018. You heard from several government witnesses about that because they all claimed that they watched it and came away with the impression that Mr. Guo was going to donate $100 million to the Rule of Law Foundation. You know what the government hasn't claimed? The government hasn't claimed that the Rule of Law Foundation didn't have any money to fulfill its mission. You saw that even in what Mr. Finkel put up. They had millions of dollars to work with. And contrary to what Ms. Maestrello told you, and we'll get to her in a second, it did a lot with that money. It funded rescue effort in the Ukraine. It helped sustain a farm in its political activities. Isn't that what you expect from a nonprofit? But the government says, well, people wouldn't have donated without Mr. Guo's promise. Does that make any sense? Do any of the members of this movement seem like they need further incentive to spend money on taking down the CCP? Yu Lu Zhou from that witness stand talked to you about how he bought a golden commemorative whistle for more than $3,000. Why? Because he believed that it contributed. Something that may be foreign to you and I. But that they believed and that he believed. So, the so-called promise. You heard several witnesses tell you they heard it during that November 2018 press conference. You remember that? They stood there on that stand under oath and told you all of that. And during our second week of trial. I know it's a long time ago. You saw Mr. Shamal Medrano present a summary chart where he presented that supposed promise to make that donation. In fact, let's take a look at it. You guys remember this? So let's look what it says here. What Miles Guo has committed to since he's enjoying the freedoms of the democratic West is to establish a $100 million fund immediately, which will be called the Rule of Law Fund. And then they put up next to it. This is his money. This is what the government wants you to believe was said at this press conference. And presented just this way. Maybe it lines up with what those witnesses said. Maybe it supports their point. But the problem is, that's not what Mr. Bannon actually said. Remember during Mr. Skirik's cross-examination of Mr. Medrano? He played the actual full clip of Mr. Bannon's statement. What did he say? Well, see for yourself.
Media played.
Mr. Kumraju said, when you listen to that full clip, you can see that Mr. Bannon is not tying $100 million to a personal donation for Mr. Guo. Despite what the government's witnesses told you, Ms. Maestrello and Mr. Chen and Jenny Lee what they said they heard. Mr. Bannon is clearly talking about the money that was spent on an investigation done by Guo Media. And what was that investigation? That was an investigation into the death of the chairman of a Chinese company called HNA, which even Mr. Zhou, one of the government's witnesses, viewed as a criticism of the CCP. That's his money. What's his money? Mr. Bannon is clearly saying that his money, Mr. Guo's money, was being used to fund that investigation. And you know what, that was true. And you know how it was true? Because Karen Maestrello told you so. She testified that she went to France with investigators to look into this death. And that, oh, by the way, Mr. Guo paid for it. And that was all work done in advance and in preparation for the Rule of Law Foundation. So then what's the other evidence the government offers you for this supposed $100 million promise? It's Government Exhibit 6192. Mr. Finkel showed you this. Let's look at what it says in the transcript. First of all, you notice this video is from 2019. So all of those witnesses that testified that Mr. Guo made this promise in 2018. This ain't it. It has to be the Bannon video they were talking about then, and you saw what that said. So let's look at what he says here. He says specifically that the donations shouldn't be called by Guo Wengui. To be donated by his family foundation and the related companies. And he doesn't say it's all coming in one shot. It's coming like this. We're going to make it happen right away. $100 million is a lot of money. He doesn't say any of that. He just says, my family's going to donate it. And Judge Torres instructed you that in order to convict Mr. Guo, the government has to prove beyond a reasonable doubt that his statement, including this statement, was not only false, but that it was made with fraudulent intent. And that means, he had to know it was a lie when he said it. So again, about those dots. Ask yourself, what is the proof that in 2018 or 2019, Mr. Guo didn't believe that his family could or would make this donation? Think about it. What has the government shown you? Did they show you any chats between Mr. Guo and Yvette Wang saying, hey, boss, you're broke? Did they show you any recorded conversations between Mr. Guo and William J.E. saying, hey, too bad you ran out of money? Did they show you any secret recording by Haitham Khaled or anybody else of Mr. Guo secreting lamenting the fact that he could no longer live the life he once did? They've given you none of that. Zero. They're asking you to connect the dots, but they won't give you the dots. So you know when I sit down what they're going to say. Well, He knew because the CCP seized his assets in Hong Kong in 2018. Well, we've talked about that. But even Mr. Finkel in his summation acknowledged the possibility that there was other money coming. He just told you it didn't matter, but this is why it matters. Because it undercuts their entire theory of motive. And the only reason they can give you why Mr. Guo would intentionally harm the movement that he built. Without that, what sense does the government's case make? And as we've seen, that 2018 seizure had no impact on his lifestyle. So there's no reason that he would ever have to believe that his family couldn't back up this promise. And, in fact, you heard him say it during that creditor's interview, he thought his family was backing it up. They couldn't talk to him about it for security reasons, he said. I know that sounds to us so hard to comprehend. But is it that crazy when the Chinese government is trying to hack his phones and seize all his assets? Mr. Finkel spent a good amount of time telling you, yes, they acknowledged that he was targeted. But it doesn't matter to this case. Of course it matters because this entire case is about what's in Mr. Guo's head. That's what they have to prove to you. And how is it possible that enduring, going through, mitigating, managing, being hunted by a foreign government for your political activism, for the very work that undermines everything that the government is alleging has no impact on his brain, plays no role in his thinking? That's what they would have you believe. That's what Mr. Finkel asked you to believe. And it just doesn't make sense. So going back to belief. Mr. Guo's belief that his family would come through for him is supported by what his family actually did. Take a look at example of the bank accounts for the rule of law account. You know what you're going to see. Well, you're going to see $500,000 donations in 2019. There's one from Golden Spring. There's one from Soraka Media Group. What are those? Those are Mr. Guo's family companies. And there's more. There's also the money that went into launching the Rule of Law Foundation. All of that is Mr. Guo's family helping to support the Rule of Law Foundation, validating this man's belief that they would come through. Now, I get it. It's not $100 million all at once, but no one ever said that it would be, not Mr. Guo, not Mr. Bannon. Nobody. But those are large sums of money to be sending a foundation if you're just lying about planning to make a donation. It's impossible for the government to prove that Mr. Guo didn't reasonably believe that his family was going to come through over time when his family's businesses are sending hundreds of thousands of dollars at a clip to the Rule of Law Foundation. So let's talk about the rest of the government's evidence about the foundation. You remember they put up Yali Mulan. You recall her testimony, right? She testified that from basically the start of the foundation, she was a director. She testified that they had votes. As a member of the board, she participated in those votes. She testified that the organization did actual work for the movement, including by giving grants to the farms to support their volunteerism. Ms. Li's testimony was that the Rule of Law was a real non-profit that was doing what Mr. Guo said it would: help support the Chinese pro-democracy movement. But the government doesn't want you to focus on that part of her testimony though. The government instead wants you to think about Ms. Li's testimony about those protests and how she saw a couple of people get punched at them. And the government wants you to pay attention to that because they think it discredits the Rule of Law Foundation. They think it will make you think that it's not a real organization. In fact, the exact opposite is true. Because remember during Ms. Schroff's cross-examination, what did Ms. Li admit? She admitted that after those protests where punches were thrown, the Rule of Law Foundation took steps to put an end to it. That's the government's own witness telling you that. And that's the very same witness who claimed that Mr. Guo ran the whole show at the Rule of Law Foundation, even though he wasn't on the board. She did everything because he told her to. He controlled it from the shadows as Mr. Finkel would like you to believe. So then which is it? On the one hand Mr. Guo is using the Rule of Law Foundation to fund a roving band of vigilantes to silence his critics. But on the other hand, he's causing the Rule of Law Foundation to put a stop to the violence. That doesn't make sense. The only other witness that the government tried to give you about the Rule of Law Foundation didn't even work there. Mr. Finkel spent quite a bit of time talking about Karen Maestrello's testimony. I will submit to you that you should spend no time thinking about Karen Maestrello's testimony because she is completely not credible. So first, do you remember on direct Mr. Horton kept asking her questions about something called rule of law over and over again. He'd ask her a question about rule of law. She would say, rule of law did nothing. But on cross-examination what came out? On cross-examination it came out that Ms. Maestrello worked at something called the Rule of Law Society. A totally different non-profit than the Rule of Law Foundation. She wasn't part of the Rule of Law Foundation. She didn't sit on any of the board member meetings. She didn't know what the Rule of Law Foundation was doing. She was part of a completely different organization. And yet she had no problem opining to you as to what the Rule of Law Foundation did, even though she was never there. That's one way in which you know she's just not credible. You want to know another way? She told you that all of these security forces that Mr. Guo had hired, these former NYPD officers, that they were all just handymen who weren't necessary, who weren't needed. Well, you heard from one of them. Scott Barnett, former NYPD director. And what did he tell you? He certainly thought the security was necessary. He thought there was targeting. He thought there was security threats. And think about it. The government itself agrees that the CCP had just tried to kidnap Mr. Guo the year before Ms. Maestrello started. How can you believe somebody who takes that stand and tells you that the security was all overstated and they were nothing but a whole bunch of plumbers and handymen who carried packages around when you know that fact? You know the other thing she told you that Mr. Guo was fluent in English. Do you remember that? Fluent in English. All the videos the government showed you, I think he spoke English in one. That's the Kyle Base one. And I think if you look at it, you would agree with me that Mr. Guo is far from fluent. In fact, I don't think you've ever seen Mr. Guo speak fluently. In fact, Ms. Maestrello's testimony on that point doesn't make any sense. What was she hired to do? She was hired to be a translator. So if Mr. Guo was fluent in English when Ms. Maestrello was there, what was Ms. Maestrello there for? So, respectfully, whether Ms. Maestrello was lying or is just clueless, her testimony is totally unreliable and worthless to you. So after the Rule of Law Foundation, what the government focused on next, GTV and the GTV private placement. Now, the government alleges that the GTV conducted a private placement offering. Basically a private sale of its own stock. And that Mr. Guo stole $100 million worth of proceeds from that private placement to make an investment in a hedge fund called the Prodigious Fund in the name of Soraka, his son's company. The government's case, as with all of it, has numerous and significant holes in it. So first I would submit, you don't actually have to waste much time on the GTV-related counts. Because the government can't get out of the starting block as a legal matter. Let me explain what I mean. You heard Mr. Finkel say that Mr. Guo and others stole the money for the Heyman investment in contravention of promises made to the prospective GTV investors. And those representations were in Mr. Guo's video announcing the private placement. And the confidential offering memorandum or the prospectus. Remember that? Mr. Finkel said that a couple of hours ago. Remember, in order for them to prove their case, they have to show you that Mr. Guo knew that the statement was false when he said it. So let's look at a timeline. April 20th, 2020. Mr. Guo announces the private placement in his video. GTV sends out the PPM. May 23, 2020, Mr. J.E. receives the Heyman prospectus. April 20th, 2020 through June 2nd, the private placement occurs. GTV raises up to $300 million. Soraka transfers $200 million the day after the raise closes. And transfers $100 million to Heyman on June 5. Then it transfers an additional $38 million to GTV. So all of the evidence summarized on this slide are government exhibits. And based on the government's own evidence, the supposed misrepresentations were made on April 20, 2020, right? That's what they told you. But also based on the government's evidence. The first time that there is any proof that any member of this so-called conspiracy learned about the possibility of investing in this specific hedge fund isn't until May 23, 2020. Ask for all of the exhibits related to this investment. See if there is any evidence whatsoever of Mr. Guo or even Mr. Je learning about this potential investment opportunity before May of 2020. I submit you will not find it. And why does that matter? Because it means that the whole point of the supposed scheme didn't arise for a whole month after Mr. Guo was supposedly going to lie. So how does it make any sense that Mr. Guo lied in April of 2020 with the intention of making the Heyman investment when he didn't even know about it until a month later? Does that make any sense to you? No. And that alone is enough to doom the GTV counts. Now I know after I sit down Ms. Murray is going to have a chance to speak. And I'm sure she will say a bunch of arguments about this. One thing she may say. He didn't have to know specifically about this investment. He just had to know that the money might be used differently. Okay. If she says that, I'd like you to pay close attention to what, if any, evidence she can show you of that, 'cause I don't think she can. I don't think there's an email or a chat or a recording or anything that proves that in April of 2020, Mr. Guo went into that private offering with the intention to steal that money. There's no witness that recounts such a conversation, not even Ms. Lee, who Mr. Guo supposedly shared, in her words. All the secret things with no one. Again, asking you to connect the dots without giving them to you first. Now, Mr. Finkel showed you during his summation clips of the interview between Mr. Guo and Mr. Bass, the head of Heyman. You remember that? You remember that interview? It happened in the airplane hangar in Dallas. We're going to talk about that a little bit in a little bit more detail. But before we do, I want you to go back and take a look at those and see what was actually said, what was actually discussed. Because you'll see that while Mr. Guo and Mr. Bass do talk about the Hong Kong dollar, and they do talk about the peg, there's not a single reference to investing in Heyman or even Heyman at all. It doesn't even show you that Mr. Guo asked about it that entire interview. That entire clip. There is not a single mention of the prospect or possibility of investing in that fund. It's all just general talk about the Hong Kong economy. They're asking you to bridge this gap without evidence. There is no evidence that prior to April 2020 Mr. Guo had any intention of stealing that money or he had any intention of making this investment. And you should hold them to their responsibility. It's their responsibility to give you that evidence. And if they can't do it, then they can't win. Now the other thing I suspect you'll hear is that, again, Mr. Guo needed money, the same refrain over and over again. He needed it, so of course he planned to steal it. In the interest of time, I'm not going to keep rehashing our argument over and over on this. But you can't really live like a billionaire for that long without having actual access to money. And again, if he were broke, is this how he would spend it, in something that could easily burn up in a second? It does not make sense. Now, second, even if you give the government the benefit of the doubt on this question, and please remember, Mr. Guo is the only one in this courtroom who enjoys a presumption, and that is the presumption of innocence. But even if you give the government that doubt, it still fails. Because they've still failed to give you any evidence that Mr. Guo was even aware that this investment was funded with GTV money. Remember, they have to prove that he knowingly participated in this scheme to defraud. And what's their evidence? Think about it. You know for sure that he knew that Soraka had made the investment. He talked about that publicly. But is there any evidence that he knew where that money came from? Did they give you anything?
Continued on next page.
Mr. Kumraju said, in fact. The entirety of the evidence about that investment shows up in the testimony of Ms. Schottenheimer. You remember her. She was the head of investor relations at Heyman Capital. So what did she tell you? That she first met Mr. Guo in Dallas in 2018 for that interview. That's it. That's the only time she ever met with Mr. Guo or spoke with him. And they didn't discuss any investment at that time. And they never interacted during the May 2020 period where the investment was happening. Instead, who did she speak with? She spoke with William J.E. Every single email, chat, WhatsApp, or phone conversation is with Mr. J.E. Nothing with Miles Guo. Now, when I sit down, you know what they are going to say, oh. But the investment was in the son's name. So. That doesn't mean that Mr. Guo knew where the money came from. It just meant that he knew that his son was making an investment. But Ms. Wang signed a subscription agreement. She's the one who transferred the money. Where's the proof that Ms. Wang discussed any of that with Mr. Guo? In fact, contrary to what the government has told you repeatedly, the evidence you have shows you that Ms. Wang had plenty of power, plenty of autonomy in operating. Think about Ms. Reyes for a second. We'll talk about her more, but the G Club CEO. She said she reported to Ms. Wang. Not Mr. Guo. And she even told you that Ms. Wang was an agent of Haran He, not Miles Guo. We'll talk about that a little bit more. But just think about that for a second. They basically want you to attribute every one of Ms. Wang's actions to Mr. Guo. But they give you very little to support them. But wait, they are going to say, Mr. J.E., he managed Mr. Guo's money. Of course he must have known. But that's the point. Mr. J.E.'s job was to manage Mr. Guo's money. Isn't that the entire point, so that he decided how to make these investments? There's no recording or message or chat or email or witness or anything. Ask for the entire trial record and you will not see a single communication or piece of evidence that shows any discussions with Mr. Guo about how this money was going to be used. Not a single piece of evidence. How can you hold this man accountable for something based on that kind of record? Again, Yoli, self-proclaimed keeper of Mr. Guo's secret thoughts. She didn't say, oh. Miles Guo told me he was going to use GT money for Heyman. He told me this. You didn't hear that from anybody. The fact is, and we'll talk more about this. But the fact is that the evidence fully supports that Ms. Wang and Mr. J.E. made that Heyman investment with that money without discussing it with Mr. Guo. And they can't give you any evidence to the contrary. But, again, let's say they come up with something and they wave it in front of you and say, look, this shows it. They still can't succeed. Because Mr. Guo could reasonably believe that $100 million. That the $100 million that went to Heyman, didn't belong to GTV investors at all, but was actually Soraka's money. And if it's Soraka's money, Soraka can choose to spend it however it wants, right? So let me break that down. So you know what was offered in the private offering was up to $200 million worth of GTV shares. You saw that in Mr. Guo's April 20, 2020 announcement. And you saw it in the prospectus that he told everyone to read before investing. And what does the prospectus say? It says that GTV was contemplating using these funds to do certain things like upgrading its technology or making acquisitions. Right? You remember this chart? Mr. Finkel showed it to you. Now, here's the thing that you heard barely anything about, if at all, during Mr. Finkel's summation. You didn't hear at all that GTV actually had that entire $200 million and more to do just those things. Remember Kim Espinosa's summary chart? You can see it here. Take a look. You can see that $238 million went from the Soraka account into the GTV accounts right after the close of the private placement. And you remember Haytham Khalid's testimony. Who caused that more than $200 million to be transferred from Soraka to GTV? Yvette Wang, the president of Soraka and the same person that signed the Heyman subscription agreement. So, in fact, Soraka did what it was said it was going to do in the PPO. It capitalized GTV with more than $200 million to do all the things that were described in the prospectus. To make those new acquisitions, to hire new talent. To develop the technology that was going to break through the Great Chinese Firewall. The money was there. So what we're really talking about here is money that was raised above and beyond what Soraka and GTV thought they needed. And so the question here is, who owns that money? Were there any restrictions on how it could be used? Well, you heard Mr. Guo. He certainly thought that the terms of the private offering were laid out in the prospectus. He said that in some of the videos that you saw. And you can read that prospectus cover to cover, every direction. Front, back, however you want to do it, English, Mandarin, you choose. You will not find a single promise, commitment, or even a word about what Soraka would do with any penny that exceeds the $200 million. Not a word. So there was never a promise for what happens if they get more money in than $200 million. So now the question is, who owned it? Well, again, based on the videos, you know Mr. Guo thought that Soraka owned it. He said it. He said it publicly. Soraka invested. Soraka invested $100 million. And I just want to pause on something that Mr. Finkel said during his summation. When talking about the bank accounts. You remember he showed you the money going from one bank account to the other. And he said, it's not that hard to figure out. It's not. Because they weren't actually hiding anything. And here's Mr. Guo saying publicly that Soraka owned it, that Soraka did it. All those scary charts they showed you, and the one bank transfer is one directional that everybody can see. So here you know that Mr. Guo's belief is that Soraka was the owner of that $100 million. And that belief is completely reasonable. Let me try to explain it with an analogy. So we've all been here a while. But just say you get tired of the courthouse cafeteria food one day. I know, hard to believe. And so let's say you decide to get a pizza. And one of your fellow jurors says, you know what? That sounds great. Could I buy a slice? You're all caring people, so you say, sure, no problem. I'm going to run to the pizza place. How about this? How about you give me $10, I'll give you a slice of pizza, and I'll get us a couple of sodas. Reasonable, right? Now, if when you say that you're really planning to take the money and use it on lotto tickets. Well, now you've lied. But you're all honest people. So let's assume that you go and you buy the pizza and the sodas and you come back. So now you've got a pizza and you give one slice away to one juror. What happens if a second juror comes up to you and says, you know what? I also would like a slice. And you say, sure. Give me $2. You can have a slice. Now, at the time you sold that second slice of pizza, you didn't make any promises as to what you were going to do with it, right? You could spend that $2 on anything you wanted at that point, because it's your $2. You sold one of your slices of pizza for an extra $2. And you didn't make any sort of commitment, you didn't say, I'll buy soda, you didn't say anything. It was a simple deal. Well, that's what we're talking about here. I know it's a private offering of stock and all that. But in the end, the same simple principles apply. The GTV stock, that's your pizza. And you saw in the prospectus that as part of the private offering, in exchange for $200 million, Soraka would give new investors 10% of the company, right? You could see it here. This is in the prospectus. So on the left, before the private placement of shares, Soraka owns 100% of the company, right? On the right, after the private placement, Soraka now owns 90% and the investors own 10%. So what's that 10%? Well, that 10% is the same thing as you giving that first slice of pizza to that first juror. And the statements in the prospectus about how the money could be used, that's like your promise to buy the sodas. To use the extra money to buy the sodas. Well, that's what happened here. Soraka did the same thing. It bought the soda. It bought the soda when it transferred the more than $200 million to GTV's bank accounts for the company to use. It's the same thing. It honored its commitment. But, as you heard, just like with our jury example, there were more investors who were hungry, more people wanted a piece of GTV, right? So that's the extra slice. Extra slice has to come out of the pizza, right? Can't come out of thin air. Well, it's the same with the extra shares. They had to come out of the shares that Soraka had left, the 90%. Because you know, as Ms. Chen testified, she actually got all of her shares. She may not like it now, but she got all of her shares. So it didn't come out of the other investors' part. And, in fact, you heard that was Raymond Dragon's understanding. You heard that was Raymond Dragon's understanding, right? That's what he told you. He told you that this money came from there. And Lai Dai, who was an investor, told you that was his understanding also. So if the shares for that extra $100 million are coming out of Soraka's piece, then who does that $100 million belong to? Just think about your pizza again. It belongs to Soraka, right? Just like that second slice of pizza. We may be dealing in stock offerings, but ultimately, it's a simple, logical matter. The money belonged to Soraka. Mr. Guo was entirely, It was an entirely reasonable belief for Mr. Guo to believe that money belonged to Soraka. And Soraka could do what it wanted with the money, including investing it in Heyman. Now, again, they get the last word. So I'm sure Ms. Murray is going to say in response, no, the promise in the PPM. The promise in the statement, it was to use all of the money that came in to fund GTV. I'm sure that's what she'll say. But, again, hold them to their burden. See what evidence she identifies. What part of the prospectus does she point you to say, look, here's that commitment. Here's that promise. Here's that representation, which, as Judge Torres has already instructed you, they need to prove beyond a reasonable doubt. Is she going to be able to give you something? I don't think so. I think it's going to look more like that spliced Bannon quote. And please also just think about this, if Mr. J.E. and Mr. Guo thought that they were stealing this money through Soraka, then why be so open about it? No one hid that Soraka was making the investment or that even Mr. Guo's son owned Soraka. This is his passport that was provided to Heyman. And look, I get it, they may say, you know, they don't have to be the smartest criminals in the world. But you need to think about this kind of evidence because you have to decide what was in their head and their intent. And this goes beyond being not the smartest criminal in the world, this is them operating openly and honestly. Which is not something you do if you think you're committing a fraud. Think about this, not only did they openly disclose that Mr. Guo's son's company was making the investment, they also disclosed where the money was coming from. Think about this for a minute. This is the information provided to Heyman. They told Heyman that they were selling shares of a subsidiary. And that's where the money was coming from. Now, Mr. J.E. could have put anything down on this. You heard from Ms. Schottenheimer, some people don't even fill this question out. He could have put anything down that he wanted. So what did he do instead? He specifically identified that the money was coming from the sale of a subsidiary's shares. Well, what's GTV? It's a subsidiary of Soraka, of course. And what had Soraka just done? It had sold GTV shares through the private placement. He was just being truthful. And I'd ask you to consider this. Mr. Finkel alluded to this. As part of the investment process, Heyman had follow-up questions for Mr. J.E. and Soraka. They asked for more information, they pushed back on certain requests by Mr. J.E. So if Mr. J.E. was really trying to be deceptive when he submitted the subscription paperwork, then what was the plan if Heyman came up with a simple question like, "Thanks, William. Which subsidiary?" What was he going to say? "Oh, never mind. My bad. Forget about it." It doesn't make sense. And it especially doesn't make sense when you think about the fact that Kyle Bass was not only the owner of Heyman, but was also going to be a director of GTV. This is from the PPM. Take a look at it. He was going to be a director. And you can see Mr. Guo knew that because Mr. Guo even talked about that fact in a video. So ask yourself, how would that work? Mr. Bass both knows that the $100 million is coming in from Soraka. He knows that Soraka has identified the source of those funds as the sale of a subsidiary's shares. And he's also going to be the director of the subsidiary whose shares have been sold. So do you really think that they would risk Mr. Bass not putting 2 and 2 together and figuring out where the $100 million came from? To borrow Mr. Finkel's phrase again, it ain't that hard to figure out. But everything you've heard about is that Mr. J.E. is a master money launderer, that Mr. Guo is a criminal mastermind. That's what you've heard. And yet they are going to do this in a way that makes it so easy and obvious to get caught. When you've got all those scary charts up there, this is how they do it. It doesn't make sense. The other point I'd like you to consider about this is the government had numerous people testify from that stand, where they said that they would have never put their money in if they knew about the Heyman investment. It's your job to evaluate their credibility. But the fact is that the Heyman investment was consistent with what GTV was trying to do. And so let's look at what investors were actually told. Now, before I do that, I do want to make one comment. And Mr. Finkel spent some time on this, and Judge Torres told you that to prove its fraud counts, the government doesn't have to show that a victim relied on the alleged misrepresentations. It's no defense to say a victim was gullible. But Judge Torres also told you that for the government to prove its case beyond a reasonable doubt, it has to show you not just that an alleged misrepresentation happened, it had to show you that it was material. Remember when Mr. Finkel put up those 7 points and he said, any one of these points is enough to convict Mr. Guo? That's not right. All of those points. They can't just show you a lie, they have to show you it was material. They can't just show you a mistake, they have to show that he intended to lie. They have to piece all of that together. It's not a pick-your-own adventure, they have to do it all. So what does it mean to be material? Judge Torres told you. But essentially, information that would affect a reasonable person in making their decision. And in assessing that, you have to consider the total mix of information available to an investor or alleged victims. So the sections I'm pointing you to now, I'm showing you them to show, 1. There's no inconsistency between the way that the money was actually used, and 2, that even if there was, that inconsistency is not material. So let's look first at what Mr. Guo said and what the prospectus said. So starting with Mr. Guo, what does he say about how the GTV investor money would be used in that April 20th, 2020 video? The answer is nothing. Seriously. Read the whole transcript. Here it is. Nothing. Yeah. He talks about general goals for the company, he talks about how it's going to be like TikTok and maybe Amazon. It's going to have a financial system. These are all aspirational plans that Mr. Guo discusses. But there is nothing in this transcript about how Mr. Guo or GTV or anyone was going to spend $200 million. There are no details. There's no descriptions of secret Israeli technology, which is what Yali told you, she said. You can look for yourself. No. What he actually says is that for more information about this investment, you need to look at the documents. Mr. Finkel told you that setting up, asking victims to go look at the documents was a setup. I believe those were his words, a setup for the victims. Well, I'll tell you this, that certainly seems like a damned if you do / damned if you don't scenario. So Mr. Guo is a fraudster for telling people to read documents that contain information. He's setting them up. He's targeting them, to use Mr. Finkel's term, by telling them to read about the risks for investing. Just think about that. So let's read the prospectus. Let's start with the use of proceeds slide. This is the one Mr. Finkel has talked about. So what do you notice? Well, that this table is of contemplated uses. What does contemplated mean? What does it mean in your real life? It means it's something you're thinking of. Right? You've thought about it. It doesn't mean it's a promise. It doesn't mean you're saying this is absolutely how I'm going to do it. It means you're thinking about using it that way. And that point is driven home when you look at page 20 of the prospectus, which makes clear that the table, the one we just talked about, the use of proceeds in this memorandum, is illustrative. What's illustrative mean? It means that these are just examples, right? So that's what investors were actually told. That these categories are some examples of how the company would use the money. Let's look at another part of the prospectus. The part that talks about how Soraka is the parent company and effectively controls the company. Here it is, Soraka will own at least 80% of the company's common stock. They can exert significant control over the company's business and affairs. So investors were told that Soraka controls GTV. And that Soraka could make GTV use investor money in ways investors didn't like. And you also see that investors were told that there was a lot of risk to investing in a company like GTV. Particularly because it had no operations. So all those statements that they said Mr. Guo made about how there was no risk, well, this is part of the total mix of information available to GTV investors as well, these disclosures. And now let's look at the statement that the government focused on. It's that the GTV private placement offering money would be used to strengthen and expand GTV. I expect that Ms. Murray may focus on that too. For one, as we talked about, the only commitments made in this prospectus are up to the $200 million. That has to be the case. Because there's no other reference to money above and beyond that in this entire document. But even if you do apply that sentence, that extra $100 million that was used, it's still consistent. So let me explain. Let's start with Yali's testimony. Now, Yali told you that in her mind, the real value in GTV would be unlocked after the CCP fell. So you believed that the platform would be most successful after the CCP was taken down, correct? Yes. And that's consistent with Mr. Dragon's testimony, who was our valuation expert. He told you that the value of a company goes up when it enjoys a monopoly in a niche market. And so if the CCP went down, GTV would be worth more, right? Well, the so-called prodigious fund was exactly that, a way to strike at the heart of the CCP. At least you saw in the video clips that Mr. Finkel played for you. That's the way Miles Guo thought about this situation. So let's look at it. Let's look back at that interview. This is from 2018, between Mr. Bass and Mr. Guo.
Video played.
Mr. Kumraju said, first of all, that's Miles Guo, fluent in English, according to Ms. Maestrello. But luckily for you and me, we don't have to interpret what they were saying because Ms. Schottenheimer did that for us already. She told you that in this section. Mr. Guo and Mr. Bass are talking about how breaking the peg would put pressure on the Hong Kong dollar. And that would create pressure on something called the Hong Kong Monetary Authority. Basically a banking regulator in Hong Kong, to try to keep that peg from breaking by spending some of its reserves. Right. Basically, US dollars that it had in the bank. But they also go on in the interview to say that they think that HKMA's reserves are overstated. Which means that it may not be able to save the peg, right? As Ms. Schottenheimer explained. That could cause the global market to lose confidence in Hong Kong. And how do you think that would reflect on China? Which claims Hong Kong as its own? Think about it. If the global economy lost confidence in New York City, how do you think that would reflect on the US government? It would weaken it. In the same way, this would weaken the CCP standing on a global scale. And so now let's take a look at how the prodigious fund was marketed. There's no doubt that the fund was marketed as having a focus on the Chinese-Hong Kong relationship. I mean, just look at the first line. You guys remember, this is the President of China, Xi Jinping, blowing away Hong Kong. And then let's look at the rest of the slides. They are all about how China is tightening its control over Hong Kong to deter additional protests. Do you think an economic crisis in Hong Kong might cause protests? And now let's look at the prospectus for the prodigious fund, which you saw Mr. J.E. received. Let's take a look at what it says about the fund. It says that the fund intends to make money by adopting a trading strategy related to pressure on the Hong Kong dollar. Right. You see it here. This is from the prospectus. On the left is the email that Mr. J.E. received. And on the right is the investment objective and strategy. And you see exactly. It tracks what Mr. Guo and Mr. Bass were talking about. Now, Ms. Schottenheimer told you that the fund was specifically designed to take advantage of this peg. Look at how the fund would make money. The Hong Kong dollar is pegged to the US dollar. And so if the Hong Kong dollar were to devalue against the US dollar, then the fund would make money. They are betting on it breaking. That's what they want. And if it breaks, Hong Kong and the Chinese government only have two options. That's what Mr. Guo told you in that video, either they try to save it and reveal to the world that they don't have the money to do it. Or they have to set up a fake economy, that's what he said. And you can see it in the marketing materials. The willingness and ability of the Chinese government to support Hong Kong and Chinese markets is uncertain. The ability. Well, you heard from both Mr. Guo and Mr. Bass, you heard from both of them in that 2018 interview. That they didn't think the Chinese government had the ability to do that. And so if this bluff was called and the CCP couldn't come up with the money, that would be embarrassing, right? And embarrassing the CCP on a global scale by showing that it was lying about its economic strength. Don't you think that could damage the Chinese economy? Don't you think that could harm the CCP's grip on its country? And then what happens to the value of GTV? Well, according to Yali, the value goes up. And now I know they are going to say, well, why didn't GTV just make the investment? Why did it have to go through Soraka? GTV is a brand new company with no history. Soraka had a relationship. They had a relationship with Mr. J.E. So they chose to invest it that way. But you don't have any evidence that that was done at a fraud. And you can't derive that conclusion when you have the director of GTV being the same owner of Heyman. What were they trying to hide? Now, one thing that Mr. Finkel spent some time on is he talked about those Heyman letters, remember? He kept saying, well, Heyman asked for this information and Soraka never responded. And Heyman asked for that information and Soraka never responded. Well, think about this, at the time that was going on, the SEC was investigating. The SEC had already contacted Heyman. And Heyman knew that the SEC was going to be asking questions. And Heyman also knew that Soraka had disclosed that the money came from the sale of subsidiary. That no one had tried to hide that. So what was Heyman doing in asking those questions? He was covering itself. And why would Soraka choose to engage with Heyman when it was already dealing with the SEC? What would be the point of answering Heyman's questions, when the big bad SEC is already talking to you? Who's Heyman at that point? Nobody, but just someone trying to cover themselves. And, in fact, what you heard from Mr. Finkel and during this trial is that Soraka and GTV entered into a settlement. It was related to civil administrative allegations by the SEC, which Soraka and GTV neither admitted or denied. There were no allegations of fraud, there were no allegations of criminal conduct. That's what happened. Soraka wasn't trying to hide from Heyman, it just had bigger fish to fry. So that's GTV. I want to turn to another subject related to the SEC. So as you heard from Ms. Schottenheimer, the SEC was investigating the GTV private offering by at least July 2020. Just a month after Mr. Guo had announced the close of the fundraise. And you saw that Mr. Guo thought that the SEC's investigation was caused by work of spies from the CCP, right? These are catastrophic consequences of the SEC listening to all the false reports from the Communist Party. And he didn't discourage when people wanted to protest the SEC. He said, "These are your rights." You also saw the signs from the protest of the bankruptcy trustee. The ones that said that the DOJ had been corrupted by the CCP. So I want to say a word about that. Because the government has suggested throughout trial and in summation that those beliefs are so unbelievable as to be fake. And that the protests were really just an attempt to obstruct the operations of the SEC and the bankruptcy court. So as an initial matter, I just want to say this, what the government is saying, the United States is claiming. Is that core political speech, specifically? Protests against perceived infiltrations of U.S. institutions by malign foreign powers is evidence of a crime. That's what they are saying. And so as a result, you were called upon to decide very squarely whether Mr. Guo genuinely believes that the CCP is trying to use the U.S. government to quash his movement and harm him. And I want to be very clear on this, very clear so there is no misunderstanding. I am not saying that anyone at this table or any FBI agent involved in investigating this case is a spy or an agent of the CCP. I'm not even trying to imply that. I want to be very clear about that. But I am saying that the evidence introduced at this trial proves that Mr. Guo's fears that the CCP could manipulate U.S. government agencies against him are genuine and reasonable. So first, you have testimony from Jianhu Yi, who, by the government's definition, is a victim. And he talked about how the CCP forced him to file complaints with the SEC and the FBI, even though he didn't want to. You remember his story, right? He told you about how he invested in GTV while he was in China. He also testified that as a result of that investment, the Chinese police came to see him. They demanded answers about the investment. You heard how they forced him to sign complaints to the SEC and the FBI about Mr. Guo. Even though Mr. Yi didn't believe that Mr. Guo had done anything wrong. And you heard how after he traveled to the United States, Mr. Yi learned that a lawsuit had been started in his name against Mr. Guo in this very courthouse by a lawyer Mr. Yi had never spoken to, much less hired. And you also heard that even though Mr. Yi made a GTV investment, loaned money, even though he did all of those things, he still believes in Mr. Guo and the movement. So you have evidence that that is one of the tactics that the CCP uses, planting false complaints. And you know what? Mr. Yi's information is corroborated by other actions that the CCP indisputably took against Mr. Guo. So let's look at the stipulation again. Remember, this stipulation reflects facts that both sides have agreed to. So first, you see that beginning in 2017, the CCP paid protesters in the United States to protest against Mr. Guo. That's the same thing that Mr. Finkel said that Mr. Guo was doing, remember? They were paying the rule of law protests. Well, that's what CCP was doing. You also see that starting that same year, the CCP established that special group of operatives that we talked about, tasked with slandering and discrediting Mr. Guo online. So is it really such a stretch for Mr. Guo to believe that these CCP spies couldn't make their way over to the SEC's website? The FBI's website? Of course not. It's of course reasonable for him to believe that. Now, also think about the so-called 90-day protests, the one against the bankruptcy trustee and his family. You saw the signs describing the trustee as a CCP running dog, and insinuating that the DOJ was infiltrated by the CCP. Again, please be clear. I am not making that claim about anyone here. And now, while that claim may seem crazy in a vacuum, think about what you've seen in this case. Think about it. Let's look at the STIP again. In DX STIP 1 you saw how multiple American citizens had pleaded guilty to try to corruptly lobby the Trump administration to cause Mr. Guo's extradition back to China. One of them, George Higginbotham. Well, who's that? You heard from him yourself. He's a former DOJ lawyer who met with high-ranking Chinese government officials, the ambassador, to try to cause the extradition to happen. And he pled guilty to a crime for it. And you know that Mr. Guo was aware of Mr. Higginbotham because Yoli testified that she heard Mr. Guo discuss Mr. Higginbotham's efforts publicly. So now go back to those signs. You know now that Mr. Guo had a reason to believe that the CCP could influence DOJ employees. And you heard from Mr. Skalka, remember the bankruptcy lawyer, that the bankruptcy trustee had been appointed by another employee of the DOJ, the U.S. trustee in the bankruptcy proceeding. And you had also heard from Mr. Skalka and Mr. Zhou that the bankruptcy trustee had participated in settlement talks between Pax and Mr. Guo. And that Mr. Guo believed that the trustee had tried to blackmail him out of $250 million as part of those discussions. So yes, it may seem paranoid to us, but we don't have the Higginbothams of the world plotting against us. But for Mr. Guo, it's certainly reasonable for him to fear that the CCP had once again tried to use the channels of the US government against him. And for him to want to expose that. Now, before I move on from this subject, I want to say one thing. The government put what it says is some very ugly evidence about these protests in front of you, these signs. Photographs of a protest at a school, even a smattering of violence at the protests. First of all, whatever you think about those messages, those protests show people standing peacefully with signs, many of them older, not threatening violence against anyone. You heard that the police were there and didn't stop them because they were peaceful. And on the two occasions that Yoli said that a protester punched someone in the face, as Mr. Finkel pointed out, you saw that Rule of Law Foundation took steps to put a stop to that. And be that as it may, however distasteful you find these protests, I do not believe you heard Judge Torres say that participating in a protest against the government or in support of an unpopular cause or through obnoxious crimes is a crime. Not in this country. So I'd like to talk now about the farm loans program. Before we get there, there's something that Mr. Finkel spent a lot of time on. And this is the idea of shares and GTV shares for farm loans. Participants and G Club's members. It's a common theme running through their argument, right? That Mr. Guo promised people that they would receive GTV shares if they just loaned money through the farm loans program or if they bought a G Club membership. Well, the government has it wrong again. So let's think first about the context. The political movement at the heart of this case is the whistleblower movement. It's a group of people dedicated to the concept that free speech and speaking truth to power can create great change. Can topple one of the world's most powerful dictatorships. And that started with Mr. Guo's public statements in 2017. The ones that angered the CCP so much that they dispatched agents to kidnap him. It then grew to the Rule of Law Foundation and its funding of protests and volunteer groups. And that energy culminated in two events in the summer of 2020. 1. The founding of the formal organization of the whistleblower movement, the new federal state of China, on June 4, 2020. We may have just had fireworks and burgers, they had fireworks and dumplings. And 2. You had the launch of the movement's voice. A social media company in GTV that could spread the pro-democracy message hopefully one day all the way to China. That was their chosen weapon, speech. Political discourse. Bringing a different perspective to the Chinese people that the CCP didn't want. And so that resulted in the second big event of the summer of 2020, the GTV private placement. That was the moment the movement really stepped into the light. Not Mr. Guo. He had been out in public for years at that point. But this was the movement's opportunity. And the thing is, the government's resistance to that idea. Its stubborn refusal to accept that this movement and these businesses are intertwined. Shows you that they just don't understand what happened here. You certainly know that's how Mr. Guo thought about it. Look at what he said when announcing the closing of the race. It can be said that from our entire media platform and whistleblower fellow fighters. The efforts of billions of fellow fighters have awakened the world. And you know that's what GTV investors thought too. This is Lu Zhou's testimony, so as one of the goals that the movement had was to set up a social media network like that. Right? For all people to use, yes. But it wasn't just about fighting the CCP with free speech. It was also about helping GTV investors make money, become wealthy, and not just for wealth's sake. But because that was part of the messaging against the CCP. Now, the prosecutors want you to think that that's part of the fraud. That Mr. Guo displayed all these fancy things and this luxury lifestyle as some part of a get-rich-quick scheme. But that's not it at all, no. Because as you heard from even one of the government's witnesses, the goal of making investors rich was also a way to spit in the eyes of the CCP. A way to show people trapped under the thumb of that regime that there was a better way. Now, the government says that message is twisted. They even tried to mock it by showing you videos of Mr. Guo's anti-CCP messaging. Remember when they showed you that hero video? Why do you think they did that? Because they want you to look at that video and think it's ridiculous, that it's cringe. That it can't possibly be sincere. First of all, it's a music video. But remember, that's the same guy who was talking to Kyle Bass about the Hong Kong Monetary Authority. Again, dig deeper. And this message, it's really not that different, the things you and I are familiar with. Just through a different cultural lens. So let me explain. What you see in those videos. When you hear about movement members getting rich, what is Mr. Guo really saying? He's trying to tell people that they can have a better life without the CCP. That they can have nice things if they weren't living under the CCP. And is that really foreign to us? It's an election year, after all. We are bombarded with campaign ads that tell us how you could be better off if you just voted the bums out, right? This isn't any different. Mr. Guo is simply trying to show people that they could live the same life afforded to China's elites, to be sure. Elites like him, if they dumped the party that had been in power for decades, the party that had impoverished them. So back to the summer of 2020. We all remember that summer, I think, but it had some specific up and downs for GTV. Think about it. Between May and June of 2020, the company raised almost $500 million from thousands of investors. There's no doubt about that. And then almost immediately, in July, actually, the SEC starts investigating. Banks start freezing the company's accounts, the company's in limbo. And then, as you saw, the company settles with the SEC, not for a criminal issue, but for a violation of a civil regulation. About how many investors can participate. So where did that leave the movement? The SEC investigation had stymied its first major initiative. But did that mean that their cause was any less important, any less urgent? These people thought they were creating a social media platform that could bring down a regime that, in the words of Steele Schottenheimer, a hedge fund executive from Texas, is running concentration camps. If you believe that's what you're fighting, would you just stop because the SEC found some technical violation of its rules? I don't think so. But what to do? It didn't seem like they could do the private placement in the way that the SEC wanted. Not with the level of enthusiasm that had come in through the GTV private placement. And so you saw what Mr. Guo said about it. He said the SEC was going to handle the refunds to investors and that GTV was going to move offshore. And he even said that on a live stream that he thought the SEC was watching. So why does that matter? Well, the government has made a big deal about moving money offshore, Swiss bank accounts, to try to make it look shady. But here is Mr. Guo announcing to the world, including in his mind, that GTV is closing up shop and moving offshore. Moving out of the United States. If he thought that was an issue, then why would he talk about it on a public broadcast when he thought the SEC was listening? And there's also the little inconvenient fact for the government that so much of the money was left in U.S. bank accounts. They tell you that these people were fleeing offshore to avoid the FBI. They seized hundreds of millions of dollars that were just sitting in U.S. bank accounts, not in some Swiss account. Just sitting there waiting for them. Waiting for them to come and seize it. And think about that seizure. Because they made a big deal about it, how everybody was moving money after that. Well, you saw those protest signs. You saw the ones that the government loved to show you about the DOJ being infiltrated by the CCP. So think about it. First you had the SEC freezing money with GTV and then DOJ. Both agencies that these people clearly thought had been compromised by the Chinese government. So is it any wonder that when the DOJ started freezing the funds, they reacted in fear, they tried to move the money. But that fear wasn't because they thought they would be criminally prosecuted by the United States. It was because they thought they were going to be politically persecuted by the CCP. Because as Mr. Doran told you, freezing bank accounts and assets is a common tactic of the CCP in targeting dissidents. So it's clear that after the SEC intervened, the movement's operations were going offshore, including GTV. So that's what they did. They started Freedom Media Ventures, or FMV in the British Virgin Isles, or BVI. Before you let the government spook you into thinking that's somehow nefarious. Remember Mr. Skalka's testimony that there were legitimate corporate reasons to run a business out of the BVI. So that's what they did. They started the new GTV. And people were able to invest in it if they wanted. You heard from Yali, there was an offering memorandum for FMV. So now what about the farm loans and G clubs and Mr. Guo's alleged promise that participants in those programs would get GTV shares? Well, you now know that there was a company that they could have gotten, that's FMV. But also look at Mr. Guo's statements. Look, for example, when he talks about buying G club memberships. He doesn't say you're going to get GTV shares immediately. He doesn't say they are going to come with your membership card. He places no deadline, he gives no time frame. In fact, you saw in the video, the one that Mr. Finkel pulled up, the Economic Me Too video. He told people they weren't going to get it. And G Clubs had the disclaimer on its website saying the same thing, you will not get shares in G Clubs or any other company. That's part of the total mix of information available to G Club members. So what did Mr. Guo mean in those videos? Well, it's simple really. When you look at what happened. You also heard that before being allowed to invest in GTV, potential investors had to disclose how much they had donated to the Rule of Law Foundation. Why? Because investing in GTV wasn't an opportunity for everyone. It was supposed to be for those people who had proven themselves to be devoted to the movement. And so as proof of that, potential investors were asked about their donation history. But then GTV was stopped by at least in Mr. Guo's mind an SEC that had been tricked by the CCP. So as they kept trying, it became even more important to make sure that the people who participated in the new GTV were supporters, not CCP spies trying to bring down the company from the inside. And how do you do that? Well, you reward the people who have given the most to the movement. So you give the people that invested in GTV the first time around, the old shares. The first shot at buying shares in the new GTV. Why? Because they were early supporters of the concept. And you give the people who gave a farm loan the first shot at buying shares in the new GTV. Why? Because they were helping to fund the movement's volunteering and broadcast activities. And you give the people who bought G Club's memberships that same shot at buying shares in the new GTV. Why? Because by buying those memberships, they were demonstrating their desire to be part of this community, the community, as Ms. Reyes put it, of like-minded people devoted to a democratic China. That's what Mr. Guo is saying. We'll reward the true supporters with the opportunity to get shares in the new GTV one day. Now, the opportunity to get shares at some point in the future is not the same thing as getting shares right away. Look at what Mr. Guo said about getting shares for the farm loans, for example. Mr. Finkel played that video. He said that it would be in 3 to 5 years where people would have the opportunity to convert their loan into equity. That's 3 to 5 years from 2020. The period hasn't even come. And there was no deadline set for when G Club's members would get theirs. And in fact, you heard in Mr. Khaled's recordings that the company hadn't even been fully set up yet. And it wouldn't have made any sense to give them any shares in the old GTV because that company was being shut down. The SEC had done that. So when you look at all of the relevant circumstances, what you see is that Mr. Guo was saying that one day the members of the movement who carried the movement on their backs would be guaranteed the opportunity to participate in the upside of FMV, the new GTV. And if you think about it, if you use your common sense, if you look at the evidence, you'll tell that that's not a fraudulent enterprise. So first, this concept wasn't just invented out of whole cloth for the farm loans and G Clubs. That's how the GTV private placement was conducted, right? Before you can invest, you had to establish your credentials. Now think about the connection between the G Clubs and farm loans and the HCN allocation. Remember, we had a lot of testimony on that. And you'll recall, what did you see in the testimony of Yili, Luzhou, Wei Chen, that supporters of HCN allocation was based on 4 things, right? Investment in GTV, farm loan amounts, G Club memberships, and volunteer efforts. Right? If you did those things, then you had an opportunity to buy HCN at its initial offering price of 10 cents a coin. You got preferential treatment based on your contributions to the movement. Lu Zhou told you that. You had to establish your credentials. And by the way, the price of that coin skyrocketed. So there's a common thread that runs through all these projects. And again, this might all seem very foreign to us. But as far as I can tell, none of us are high net worth Chinese individuals committed to trying to overthrow a murderous regime. We don't come from that perspective. But that's who these people are, that's what they believe in. And to truly understand and judge these products, you have to put yourself in their shoes just a little bit. And use your common sense. The government says that all of these projects, from GTV to the farms to G Clubs to the Himalaya Exchange, were all parts of a criminal enterprise. And that GTV shares and HCN were the vehicles of that fraud. Okay. So if that's true and Mr. Guo architected this massive fraud scheme, because his assets had been frozen and he needed to fund this lavish lifestyle, then why would he have made it harder for people to buy more GTV shares or more HCN? Why tell people that they have to volunteer and actually do things? Actually do things for the movement to buy more HCN. Making it harder to buy the coin means less people do it, right? And that means fewer so-called fraud proceeds, right? Does that make any sense if Mr. Guo has just set this whole thing up as a criminal enterprise? No. It only makes sense if he actually wanted the movement to work out. And if that's the case, then it undercuts the government's arguments that he intentionally sought to deceive the movement's members. And frankly, that applies to a lot of things in this case. If this whole thing was fake, which is what the government is saying, then why go through all the effort? Why spend money on engineers for GTV? The ones that Yili paid? According to the government, the company had no plans on developing this technology to attack the CCP censorship efforts. It was all a fraud. So why pay engineers? Why have all that KYC at G clubs or the Himalaya exchange if it's just a sham to steal people's money? Think about what Jesse Brown told you. He told you it was a very arduous process. He told you that the company was going overboard. Why hire outsiders like Ms. Reyes or Mr. Brown or Mr. Bass at all? Instead of just staffing those high-ranking positions with people who the government claims are part of their enterprise. Why not make Long Island David the head of G clubs? Why invite regulators like the Puerto Rican Banking Authority, OSIF, to look into your business by asking for banking licenses? Or crypto regulators by asking for crypto licenses if you knew it was all just a house of cards? It doesn't make sense. So going back to Mr. Guo's statement, why does the distinction I drew matter? For two reasons. First, since Mr. Guo is clearly saying that GTV investors, farm loan members, and G Club members are going to get preferential treatment when the time comes to invest in the new GTV. What's the government's proof that that's fake? You saw Yili talk about it. She talked about how there's an offering memorandum. And for people like her, they had the opportunity to invest. So where's the lie? Without a lie, the government can't prove it's fraud. Now, the second reason that's important is because the government also chose to charge Mr. Guo with securities fraud in connection with the farm loans and G clubs. To prove that charge, however, the government must show that the alleged fraud was in connection with the security. Meaning it touched upon a purchase or sale of securities. So how can this touch upon the sale or, how can this touch upon the purchase of FMV or GTV shares? When there are absolutely no specifics at all with respect to the date. No one can tell you when it's actually supposed to happen. How can that actually be material to a reasonable investor? Now, during the trial, you heard some talk also about the value of GTV. I'm not going to spend very long talking about that. I'm just going to tell you that the only concrete valuation Mr. Guo ever put on it, the only one that wasn't qualified, was that the company was worth $2 billion. And our valuation expert, Mr. Dragon, told you that the way that Mr. Guo arrived at that valuation, just taking the money that people were willing to invest at the terms, was an industry standard way of doing it in the valuation industry. So if that's standard practice in the valuation industry, how can it be criminal for Mr. Guo? The answer is it's not. So that's what's going on with the supposed promise for GTV shares. And when you think about it in that context, it actually leaves the government's case in shambles, because that's the thread that holds it all together. Without it, the government is left with isolated claims related to these that just don't hold up. So let's look at those now. So first, for the farm loans. Now remember, this was a volunteer program for members of the farms to help fund the movement's operations. There were loan agreements. Well, the government says there wasn't any interest paid. And it says people didn't get their money back. But again, the government is asking you to make leaps in logic without the underlying evidence. Because look at the terms of the loan. It says that the interest is payable in full on the final maturity date. So nobody gets interest until the final maturity date. When is the final maturity date? 3 years from the effective date. What's the repayment? The total loan plus the interest will be paid in a lump sum on the final maturity date. And what else did it say? The borrower has the right, but not the obligation, at any time before the final maturity date to extend it by another 2 months, another 2 years. In fact, you heard from Le Joux that his loan had been extended that way. And when you look at the long list of farm loan agreements that Mr. Hinton identified, you'll see that none of those loans were due before Mr. Guo's arrest. They arrested him and charged him for this before the obligation even arose. That is a rush to judgment. That is haste. That is a mistaken prosecution. And the thing is, even though they put evidence in front of you about this person was receiving loans or interest, or this person was, you didn't get any evidence whatsoever about Mr. Guo being involved in any of that process. Just generic testimony that Mr. Guo somehow ran the farms with nothing else. How can you rely on that? They are making very specific allegations of what happened, but giving you generic statements. Is that the kind of evidence that you take a man's liberty away with? Is that the kind of evidence that proves something beyond a reasonable doubt? So what's left? Well, there's this idea that Mr. Guo misappropriated funds from the farm loan programs for his own personal use and the use of his family. But, again, the government has given you nothing when it comes to that claim. So let's look at what the government's evidence is on that. First, you have Yali tell you that she sent loan money to ACA Capital. And you saw from Mr. Hinton's charts that the farm loan money did go to ACA Capital. But so what? That makes complete sense. Why? Because Mr. J.E. is not just Mr. Guo's financial advisor. He's a skilled investment advisor. He's well known. And he's also aligned with the movement. So why wouldn't you take advantage of that expertise? In fact, think about a story that came out during Beau Collins' testimony, the Mercantile Bank CEO. He told you about how Mr. J.E. was looking to make an investment through Hamilton, not Himalaya Exchange. As the government said in its summation, but through Hamilton, another hedge fund of his, on behalf of who? Well, you heard from Yali the farm members, right? And it would make sense for the movement to own a bank, wouldn't it? Think about all of the banking troubles they had. If you couldn't maintain banking relationships to further your political movement, and there is a chance to fix that. That would make sense, right? That would be money spent for the benefit of the movement, right? And isn't that the promise that was made about the farm loans program? Same with all of those translations and broadcasts and protests and payroll expenses. Where did that money come from? Well, you heard folks at all these different businesses were staffed through a company called HCHK, which was funded with money from the farms. A staffing company basically for the businesses that were tied to the movement. Now, during the trial, the government tried to make this sound nefarious, to use it as some sort of connective tissue. But let me ask you this, do you think it's easy to find staffing solutions for companies that can't keep bank accounts open? Or struggle to enter into agreements with vendors? And do you think you might be prone to keeping a tight circle of people if you thought the CCP was sending spies to take you down? As we all know, just because you're paranoid doesn't mean they're not out to get you. And that's what was happening here. So really, what it comes down to is the government's claim that Mr. Guo and his family stole money from the farm loan proceeds. Right? That's the heart of it. And so for such a serious claim, they must have put on some really powerful evidence of that, right? You must have heard that during this trial. So let's look at that evidence. So first, you have exactly 0 witnesses who have any personal knowledge of the payments that the government focused on. You don't have a single witness who can tell you that Mr. Guo directed them to do that, or even that Ms. Wang directed them to do that, or even that Mr. J.E. directed them to do that. You don't have any witnesses who can tell you what the justification was for those payments. The most you have are some scattered references to there being loans from ACA to various entities like Greenwich Land or Hudson. But you have no details about why or how those loans were made. Really? The only time you heard about any supposed misappropriation. The only evidence they gave you was through the testimony of Mr. Hinton and his scary charts. So let's look at that one again. This is the farm loan slide, you remember Mr. Finkel put it up. All right. So what do we see here? You got all these crazy boxes and arrows and lines, right? All so that the government can argue to you that this $77 million at the top from the farms went to ACA. And then ended up in the pocket of a yacht company for Mr. Guo's yacht or transferred to Mr. Guo's son's Swiss bank account. Here's the problem though, and you remember this cross-examination. I did it. Mr. Hinton himself told you that this chart can't make the connections that the government wants you to draw. Remember that testimony? So even though there were arrows connecting the ACA capital box and those entities we just talked about, and arrows connecting the farms and ACA capital, you don't actually know if any of that $77 million account for these transfers, right? I haven't traced the funds through to their ultimate uses, that's correct. Mr. Hinton can't link up that money for you because the government didn't even ask him to do the analysis. So if Mr. Hinton, with his impeccable credentials and the $2 million worth of work that he spent on this chart, can't tell you that this money ended up here, then how can you be sure? How can you determine that beyond a reasonable doubt if their witness tells you he can't do it? Let me just give you a real-world explanation of what I mean. So you can look through Mr. Hinton's whole chart. You can look at all of the exhibits cited to, you can look at all of the exhibits introduced in this entire case. You know what you won't find? You will not find a bank account, bank records for that ACA First Abu Dhabi bank account. You simply will not find one. So what does that mean? Well, first, that means the government has no evidence of how any money in that account was spent. So, for example, that $77 million that went in. How can the government prove to you that it wasn't sent to a farm in Japan or Korea or the United Kingdom or somewhere else around the world for use on farm-related activities? They've argued that to you, but is there any evidence of that? Nope. Because they can't show you what's happening in that account. That's point one. But equally important is that without that bank statement, the government can't tell you how much money came into that bank account from other sources during that relevant time period. So let me ask you to think about it this way, let's say you deposit your paycheck in your bank account and there's some money in there from before. And your grandmother also gives you a check for your birthday. So now let's say there's $4,000 in there. Next day your rent comes out. Let's say that's $2,000. Can you tell me whether the $2,000 that came out for your rent came from your paycheck? The money that was already in there from before, or your grandmother's birthday check? No, you can't. And you know why? Because Mr. Hinton told you that without doing a tracing analysis, that was impossible. And they didn't ask him to do a tracing analysis. So now think about that ACA First Abu Dhabi bank account. You have no idea how much money was in that account when the farm loans program started. But you know that it had to have had millions in it at some point before that, right? Because you saw transfers from the ACA First Abu Dhabi bank account to Golden Springs. Millions of dollars coming from that account into these accounts to the Guo family companies. And all before the farm loans program is even alleged to start. So you have evidence that there was money in there before, but the government can't tell you how much. So where did they come from? Well, you know that Mr. Guo's family was supporting him, you saw that and you heard that. And then you have this giant bubble, other inflows, right? It sits on the slide and the government can't tell you how much is in that bubble or when it happened. So basically, you have no idea how much money was in that account and where it came from. So what happens if there was $1 billion in that bank account when, let's say, the $950,000 in jet payments went out. You couldn't say that any of that $77 million was used to pay that $950,000. And you don't have to take my word for it either. That's exactly what Mr. Hinton told you, right? Without doing a tracing analysis, you can't tell. And they didn't ask him to do that. So you don't have any evidence to support that those jet payments came out of that $77 million. And that's true for every single dollar that the government claims was stolen from the farm loans proceeds. Every single amount that's shown on this government exhibit. The government has not given you any evidence to show you that that is from the farm loans proceeds. So remember what I told you, they want you to connect the dots. But they haven't given you the dots to connect. They can draw the arrows from one box to the next, they can do whatever kind of paint by numbers they want. They can't get over this basic fact. Mr. Ferguson promised you at the start of this trial that the government would prove that Mr. Guo and his family stole money from the farm loan proceeds beyond a reasonable doubt. And now here we sit, after 7 weeks, and the government's own witness tells you that they can't connect it up. Is that the quality of evidence you want to take a person's liberty away, speculations and guesses?
Mr. Finkel said, objection.
The court said, sustained. Considerations of punishment are not to be part of the jury's duties. It's only the judge who makes decisions about punishment.
Mr. Kumraju said, I'm sorry, Your Honor. I didn't think I alluded to punishment, but I'll move on. And the thing is, it doesn't end here. I know this is a strange case. But what you've seen time and time again is they don't give you the evidence to tie it together. Mr. Guo lived a wealthy lifestyle, right? But he barely thought about his finances. That's what you heard from Ms. Maestrello. She told you that the boss never paid for anything, right? She just said, where do you want it, and that was it. And you saw Mr. Guo's creditor interview. He didn't even know what the Golden Springs head of finance's last name was. He didn't have any credit cards or debit cards or carry around any cash. From Mr. Guo's perspective, since he fled China, he has always depended on the kindness of his family for support. And he was open about that in his bankruptcy filings. And he was provided for. Sure, look at his lifestyle. And the person who handled his financial matters was Mr. J.E. You heard that from Ms. Schottenheimer and others. And you saw that. Mr. J.E. even sent money from the ACA First Abu Dhabi bank account to Mr. Guo's family offices. We just looked at those transfers. So now ask yourself, how do you decide what happened? Think a man like Mr. Guo, who doesn't even have a credit card, is going over bank statements and telling people to take money out of the farm loans program to make a random maintenance payment on his yacht? Or do these ACA transfers look like all the ones before from his family? And there was no reason for Mr. Guo or the folks at Golden Springs to think that anything was off with them. I think you know, but at best you can't tell. Because the government hasn't given you enough evidence of their argument. The bottom line is this. The government simply has not carried its burden to prove to you beyond a reasonable doubt that Mr. Guo stole anything from the farm loans program. Your Honor, I'm about to turn to another section. There's 10 minutes. It's up to you if you want to continue or if you want to take a break.
The court said, this is an appropriate time to pause.
Counsel conferred.
Mr. Kumraju said, sorry, Your Honor.
The court said, all righty. Members of the jury, we will stop our work for the day. Although you've heard from the prosecution and you've heard a portion of the summation of the defense, it is not time to start discussing the case. You will only begin your deliberations when I tell you that it's time. So the same old rules apply. Do not discuss the case amongst yourselves or with anyone else. Don't permit others to discuss the case in your presence. Don't read, watch, or listen to anything from any source that touches upon the subject matter of this case. Have a good evening.
Jury not present.
The court said, Mr. Kumraju, for the second time you raised the issue of the defendant's liberty, and it's not appropriate. That's why I sustained the objection. And so you will not do that again tomorrow.
Mr. Kumraju said, Yes, Your Honor. I apologize. I understand the nature of the objection. I was not trying to. But I understand the issue and I will not do it again tomorrow.
The court said, Is there anything before we end for the day?
Mr. Finkel said, Just a question for defense counsel. Approximately how much is left? It was a 3-hour estimate. I think it's about 40 minutes or so.
The court said, Mr. Kumraju?
Mr. Kumraju said, I need to look through the material, but I think it's fair to say 45 minutes to an hour.
The court said, All right. Well, you'll try to be as efficient as possible tomorrow morning.
Mr. Kumraju said, Of course, Your Honor. I think that would be about commensurate with what the government did, so.
The court said, All righty. Is that it?
Mr. Finkel said, Just for the record, the government was 3 hours. Just for the record. Have a nice evening. Your Honor. Thank you. See you tomorrow.
The court said, Good evening.
Adjourned to July 11th, 2024 at 9 a.m.